Hello, hello. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಗಳು ಕೊಟ್ಬಿಡಿ, ಏನ್ ತಗೊಳಕ್ಕಾಗತ್ತೆ ತಗೊಳ್ಳೋಣ. ಎಸ್ ಪೆಂಡಿಂಗ್ ಯಾವ್ದು ಕೊಡ್ಬೇಡಿ, ಯಾವ್ದು ಬರಲ್ಲ. ಚಾರ್ಜ್ ಶೀಟ್ ಅದು ಕೊಡಿ 2:30 ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ. ಏನು ಅರ್ಜೆನ್ಸಿ? 2:30. ಸೊ ವಾಟ್? ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಕ್ಕೆ ಬಂದ್ಬಿಟ್ಟಿದ್ದೀರಾ? ಅಲೋ ಮಾಡಿದ್ಮೇಲೆ ಬನ್ನಿ. ನೋ ಅಲೋ ಮಾಡಿದ್ಮೇಲೆ ಬನ್ನಿ. ಅಲೋ ಹೊಡೆದ್ರೆ ಕೊಡಿ. ಎಸ್ ನೋ ಮಂಡೇ ಸರ್. ಎಸ್ ಕೊಡಿ ಸರ್. ಎಸ್ ಗಿವ್ ಇಟ್. ಸೊ ವಾಟ್? ಚಾರ್ಜ್ ಶೀಟ್ ನೀವು ಹೇಳೋದೇ ಫಾಲ್ಸ್, ಕೊಡಿ. Seriously, give it, sir. Yes. Monday or Tuesday. Yes. Monday or Tuesday. Give it. Ad seniority prakara baratte kodi. No problem. Give it, sir. Yes. Give it, sir. Yes. ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ಯಾಕೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್? ನಾಳೆ ಅಂತೂ ಇಲ್ಲ ಕೋರ್ಟ್. ಕೊಡಿ ಎಲ್ಲ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಕೊಟ್ಟು. ಡೋಂಟ್ ಮೂವ್ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್. ಐ ಹ್ಯಾವ್ ನೋ ಟೈಮ್ ಟು ಟೇಕ್. ಎಸ್. ನೋ ಸರ್, ನಥಿಂಗ್. ನೋ ಪ್ರಾಬ್ಲಮ್ ಸರ್, ಗಿವ್ ಇಟ್. ಎಸ್. ನೋ ಸರ್, ಡೋಂಟ್ ಮೂವ್ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಎಟ್ ಆಲ್. ಮೂವ್ ದ ನೆಕ್ಸ್ಟ್ ಬೆಂಚ್. ಮೂವ್ ದ ನೆಕ್ಸ್ಟ್ ಬೆಂಚ್. ಇರೋದು 4 ದಿನ, ಅದ್ರಲ್ಲಿ ಏನಿದೆ ಕೊಡಿ. ನೋ ಸರ್, ವಾಟ್ ಎವರ್ ಇಟ್ ಈಸ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಕೊಡಿ. ಅದು ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ನಾನು ಹೇಳಿದ್ದೆ ತಗೊಳಕ್ಕೆ. ದೆನ್ ಟೇಕ್ ಇಟ್ ಬ್ಯಾಕ್. ಎಸ್. ನೋ ಪ್ರಾಬ್ಲಮ್ ಸರ್, ಏನ್ ಮಾಡಕ್ಕ ಕಾಂಟ್ ಹೆಲ್ಪ್ ಸರ್. ಎಸ್. ನೋ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಕೊಡ್ಲೇಬೇಡಿ ಸರ್. ಫ್ರೆಶ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ಮಂಡೇ ಅಂತ ಹೇಳಿ ಕೇಳ್ಬೇಡಿ, ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ. ಪ್ಲೀಸ್ ಗಿವ್ ಇಟ್ ಸರ್. No 2:30 sir. 1:30 ಇರಲಿ. 2:30 urgency. So what sir? ಏನ್ ಅರ್ಜೆನ್ಸಿ ಅದರಲ್ಲಿ? ಅಷ್ಟೇ ತಾನೆ, ಕೋರ್ಷನ್ಗೆ ಏನಿಲ್ಲ, ಕೊಡಿ. Give it sir. Monday or Tuesday ಬರುತ್ತೆ, ಕೊಡಿ ಸರ್.
ಇದು ಚಾರ್ಜ್ ಶೀಟ್ ಆಲ್ರೆಡಿ ಫೈಲ್ ಆಗಿದೆ.
ಸರಿ ಬಿಡಿ. ಅದಕ್ಕೆ 2:30. Nothing. 2:30. Yes.
Fag end of the trial, the application for amendment of the complaint is allowed.
1:38.
1:38. 2:30. My lord, day after tomorrow it is posted for argument. That's the reason.
Argue the matter. Yes.
My lord, I have disclosed my defense. I have confronted.
2:30. Yes.
Fox Act is falsely implicated. Fox is falsely implicated for me, my lord. Petitioner, my lord. The petitioner has filed a complaint against the victim's father, my lord. Threat of arrest, my lord.
2:30.
Stay order from vacating stay order application.
Next bench move ಮಾಡಿ. Vacating stay ಎಲ್ಲ next bench move ಮಾಡಿ, ಯಾರು ಮೂವ್ ಮಾಡಬೇಡಿ. ನೋ ಸರ್, vacating stay ಕೊಡ್ಲೇಬೇಡಿ ಯಾವ. ಇನ್ 4 ದಿನ ಇದೆ, ಎಲ್ಲಿದೆ ಟೈಮ್ ತಗೊಳಕ್ಕೆ? ಬಿಡಿ. ಆಗಲ್ಲ ಸರ್, ಆಗಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಬೆಂಚ್ ಮೂವ್ ಮಾಡಿ. ನೀವು vacating stay ನೇ ಬೇಕಾಗಿಲ್ಲ ನಿಮ್ಗೆ.
Fresh matter section 85, my lords, fractured second marriage of both husband and Monday, my lords.
Give it. Yes.
My lords, senior citizens have been wrongfully accused under Dowry Act, my lords.
No
and
problem.
Now,
give it. Yes.
my lords, Monday, my lords.
Monday or Tuesday or Wednesday.
125 CRPC, my lords.
Sorry?
125 CRPC.
Give it. Pending matter.
Proceedings, yes, my lords.
Not move.
Fresh matter, my lords, a contractual dispute.
Anyway, Monday or Tuesday or Wednesday, give it. Yes.
Student visa, my lords. It's pending.
ಅದು ಯಾವ್ದು ಮೇಡಮ್ ನೋಡಿ, ಸ್ಟೂಡೆಂಟ್ ವೀಸಾ ಸಿಗ್ತಾ ಇಲ್ಲ ಅಂತ ಹಾಕಿ. Student visa ಇದ್ರೆ ಅಲ್ಲ, it's only student visa purposes you filed an application.
No, my lord, the thing is that it's a civil matter which is being colored.
No, that's all right madam. Student visa ಯಾವ್ದಕ್ಕೆ? visa ಸಿಗ್ತಾ ಇಲ್ವಾ?
One of the petitioners is trying to go for abroad, my lord. Student visa ಸಿಗ್ತಾ ಇಲ್ಲ, criminal matters ಇದೆ ಅಂದ್ಬಿಟ್ಟು it's a civil matter which is colored into.
ಆಯ್ತು, we'll see. ಅದು ಯಾವ್ದು ಸ್ಟೂಡೆಂಟ್ ವೀಸಾ ಇದೆ ಹಾಕಿ ಮೇಡಮ್. ಆಯ್ತು, 25th ಕೊಟ್ಟಿದ್ದಾರೆ, ಮತ್ತೆ ಯಾಕೆ ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? Yes.
My lord, this is a fresh matter, my lord. False FIR came to register against me, my lord.
Give it,
I have
give it.
threat of arrest, my lord. My lord, I'm
2:30, threat of arrest 2:30.
kindly have it on Monday.
Threat of arrest ಅಂದ್ಬಿಟ್ಟು Monday,
My senior is.
give it, no problem. Why, you have not read the file? Read the file and come, 2:30 ತಗೊಳ್ಳಿ. Yes,
Matter, matter,
threat of arrest 2:30 ತಗೊಳ್ಳಿ.
matter, my lord.
ಅದೇನು ಅರ್ಜೆನ್ಸಿ ಮೇಡಮ್, ಆಯ್ತು 2:30.
Threat of arrest, my lord.
ಎಲ್ಲರೂ ಥ್ರೆಟ್ ಆಫ್ ಅರೆಸ್ಟ್ ಅಂತ ಇದ್ದೀರಾ? ನಿಜವಾಗ್ಲೂ ಇದೆಯಾ ಇಲ್ಲ?
Already FIR has been stayed with respect to accused number 1.
My lord,
2:30.
7th matter, my lord.
Settlement, when do you want? Huh? When do you want, madam?
Tuesday.
ಆಯ್ತು ಕೊಡಿ.
Lordship,
ಬರ್ತೀನಿ.
The case of defamation, if your lordships may recall, is a case.
Pending
where-
matter?
No, your lordship, this is
Then-
a case where Satnarayan Rao had filed a defamation case against DIG Rupa. Your lordships had quashed for accused
What happened
number
now?
1, 2. There are 3, your lordship. This matter has to be heard before you. Any day next week, your lordships.
I never give it, madam.
Please, your lordships. Any
Pending,
day next.
please don't move pending matter.
lordship, it is 7th,
Any day next.
No,
7th
madam,
file.
I am left with only 5 days of sitting next week.
I didn't pressurize
First,
you any time.
first in the, I am out of the, I am going to Dharwad. So what can I take now?
Any difficulties in-
No difficulty. My difficulty also you should know, yes, give it.
Lordship,
Lords.
file.
Any day next.
No, give, yes.
One
My
minute,
lords, matter for settlement, my lords.
Say whenever you want settlement.
Settlement, Monday.
urgency.
My lord, in this,
Madam, Monday.
ಕೊಡಿ ಸರ್, ನಾಳೆ ತಗೊಳ್ಳ ಅಲ್ಲ, ನಾಳೆ ತಗೊಳ್ಳ. ವೈ 2:30? So what, ಕೊಡಿ. You are the husband. Then ಆಯ್ತು 2:30. See, there's a meeting at 5 o'clock. I'm rising at 4:45. If the files don't come, I'm going away. It is your responsibility to get it. Yes. ಬಿಡಿ ಮೆಮೊ. ಡೋಂಟ್ ಗಿವ್ ದಟ್ ಮೆಮೊ. ಎಸ್, ಇದೇ ಕೆಲಸ. ದಿನ ಒಂದೇ ಮ್ಯಾಟರ್ನ ಮೆಮೊ ಮಾಡಿ ಇಲ್ಲಿ ಕಲೆಕ್ಷನ್. ನೋ ಸರ್, ಈಗ 24th ಡೇಟ್ ಕೊಟ್ಟಿದೆ ತಾನೆ? 24th ಬಂದಿದ್ಯಾ? 24th ಬಂದಿದ್ಯಾ? ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಅವತ್ತು ಮೂವ್ ಮಾಡಿ ಸರ್. 24th ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಮೂವ್ ಮಾಡಿ. ಡೋಂಟ್ ಬಿ ದಿಸ್ ಫೂಲಿಶ್. ಎಸ್, ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ? ಕೊಡಿ, ತಗೊಳ್ಳಿ. ಮಂಡೇ ಆರ್ ಟ್ಯೂಸ್ಡೇ ಹಾಕಿ. ಅದು ಪರವಾಗಿಲ್ಲ. ನೋ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಕೊಡ್ಲೇಬೇಡಿ. ಪರವಾಗಿಲ್ಲ, ತೊಂದರೆ. ನೋ ಸರ್, ನಾಟ್ ಆಲ್. ಎಸ್, ಗಿವ್ ಇಟ್ ಸರ್. ಎಲ್ಲ 2:30 ಅಂತ ತಗೊಳ್ಳಲ್ಲ, ಕೊಡಿ. ಮಂಡೇ ಡೇಟ್ ಯಾವುದು ಕೊಡಲ್ಲ, ಕೊಡಿ. ಇನ್ನ 5 ದಿವಸದಲ್ಲಿ ಯಾವತ್ತಾರು ಬರುತ್ತೆ, ಕೊಡಿ. ನೋ, 5 ದಿವಸದಲ್ಲಿ ಯಾವತ್ತಾದ್ರೂ ಬರುತ್ತೆ. ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ.
Atrocities Act, my lords, is being
Atrocities Act
138.
it's being
ಯಾವ್ದಾದ್ರು
my lords, land dispute, my lords, is given Atrocities Act color, my lords.
Lordship,
next 5 days I am left. All those days, any of those days will come. Give it. Give it.
2:30.
My lords, disposed matter being spoken. There is a typographical error in the order. Instead of
being spoken to. Being spoken to ನಾಳೆ ಹಾಕಿ.
My lord, in this 138, my lord.
ಮಂಡೇ ಹಾಕಿ.
lordship, covered matter.
ಕೊಡಿ ಸರ್, ಎಲ್ಲ
My lord,
ಕೊಡಿ.
this is 138 case.
Everything.
my lord.
Lordship, list
This,
two.
Sir,
all
give
the
it.
8
Give the
directors
memo.
are made a party and they're
Give the memo, sir.
taking warrant, my lord. Check amount has
Give
been
the
already
memo.
paid.
Yes.
Lordship,
My lord, for the end of the list, my lord.
lordship, on covered matter, lordship,
ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ನೆಕ್ಸ್ಟ್ 5 days ಸಿಟ್ಟಿಂಗ್ ಇದೆ, ಅಷ್ಟರಲ್ಲಿ ಯಾವಾಗಾರು ಬರುತ್ತೆ.
one
My
submission.
lord, this is the end of the list, my lord. End of the list.
Why end of the list, sir?
They're trying to take a warrant against me,
Time
my
to
lord.
take. After they take, you give it.
No, my lord, they're already advanced. They're already advanced.
Defreezing ಎಂಟ್ರಿ ಮಾಡಲ್ ನಾನು ಕೊಡಲ್ಲ ಸರ್.
ಅಲ್ಲ, stay ಆಗಿದೆ ಸ್ವಾಮಿ.
ತೊಂದ್ರೆ ಇಲ್ಲ, ಅದೆಲ್ಲ ನೆಕ್ಸ್ಟ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ. ನೋ,
My lord, in this check amount has already been paid, my lord. Check amount has been.
all right, give it sir. I'm not saying I won't take the memo. Please give the memo.
End of the list.
End of the list ಆಗ ಏನ್ ಅರ್ಜೆನ್ಸಿ?
My lord, they're taking
ಏನ್
warrant.
ಅರ್ಜೆನ್ಸಿ?
Warrant.
What warrant, sir?
They're advancing and taking
You are
warrant
not,
against all
let
the
them
directors,
advance,
my
let
lord.
them take the warrant, you move it.
8 directors are there, my lord.
Sir,
Only one
if
is
they take,
authorized.
if they take the warrant, move it on Monday. Yes.
Lordship,
Your lordship, in this have to pay salary to 26 centers, your lordship. Defreezing.
Give it, sir. No, I am not pending matter ಕೇಳಲೇಬೇಡಿ. Yes.
lordship,
ಎಲ್ಲ fresh matter ಕೊಟ್ಬಿಡಿ.
lordship,
One matter.
Give all the memos, sir.
One
one matter,
After filing of MC, my lords, POCSO is filed. Charge, my lords, for framing of charge, it's on Saturday.
Order sheet.
It is there, my lord.
2:30. Yes.
Lordship, list to serial number 100, I'm withdrawing.
Thank you. Memo ತಗೊಳ್ಳಿ ಇದು. List to serial number 100.
Lordship, one covered.
100.4, Lordship.
Lordship,
Madam,
Give it, sir.
List to 100.4.
Lordship,
For what it is listed, sir?
Lordship, one the covered matter, Lordship.
Covered matter ಎಲ್ಲ ಕೊಡಿ. Pending ಇದ್ರೆ ಕೊಡ್ಲೇಬೇಡಿ. sir.
Lordship, ಇದು fresh matter. Fresh matter, my lord, 7th board
sir.
ಹೋಗಿದೆ.
2:30 ಇಲ್ಲ.
Lordship,
List to serial number 97 seeking to withdraw the petition.
Thank you, sir.
Lordship, ಒಂದು covered matter ಅಲ್ಲಿ, covered matter ನಲ್ಲಿ 7th board ಹೋಗಿದೆ. I am out of country, my lord, next week 2:30, my lord.
ಏನಕ್ಕೆ ಹೋಗಿದೆ?
7th board ಹೋಗಿದೆ, ready for admission. I am out
ಬರುತ್ತೆ.
of country,
Monday,
my lord.
Tuesday ಯಾವ ತರ
ಅಲ್ಲ,
ಬರುತ್ತೆ?
at 2:30.
2:30 ಯಾಕೆ?
ಅಲ್ಲ, ಇದು covered matter.
No, sir.
ಅಲ್ಲ, ಇದು
ಸರಿ, ಅವ್ರದೆಲ್ಲ ಯಾಕೆ ತಗೊಳ್ಬಾರ್ದು?
ನಾನು out of
ನಿಮ್ದೇ ಯಾಕೆ ತಗೋಬೇಕು?
ನಿಮ್ಮ ಮಂಗಳವಾರ ಇದಕ್ಕೆ ಹೋಗ್ತಾ ಇದ್ದೀನಿ ನಾನು.
ತೊಂದ್ರೆ ಇಲ್ಲ.
At least ಸೋಮವಾರ
ಕೊಡಿ ಎಲ್ಲ.
ಸೋಮವಾರ ಮೇಲೆ at least
ಸೋಮವಾರ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ.
My lord, MC case has been filed, my lord.
Give it, sir. ಬೇಡವಾ? ಕೊಡಿ.
ಮಂಡೇ ಮೇಲೆ
My lord,
ಮೆಮೊ ಕೊಡಿ. ಮೆಮೊ ಎಲ್ಲ ಕೊಡಿ.
my lord, petitioner is a practicing advocate.
Maybe, madam. ಮೆಮೊ ಎಲ್ಲ ಕೊಡಿ.
Kindly for Monday, my lord.
Give it, sir.
at least ಮಂಡೇ ಮೇಲೆ
Give it, sir.
Lord, hearing before charge.
Give all the memos. From 1st of September, all of you move like this, we'll see. Yes. ಕೊಡಿ.
My lord,
at least
2:30,
ಮಂಡೇ ಮೇಲೆ
My lord.
Huh?
lordship
child
ಮಂಡೇ
is
Give it, sir.
suffering from abuse from the mother by
Who?
ಮೇಡಮ್ out
child,
of
my lord.
Child, what happened?
ಮಂಗಳವಾರ
MC case has been filed. After that, FIR has
Out
been
of
filed
country,
against
okay,
the
Mangalore.
husband
Monday-
and
Monday
in-laws
will-
of the husband, in-laws of the
Monday date
wife,
could-
and then the child is also abused by mother itself.
ಮಂಡೇ ಮಂಡೇ
Pending matter.
Fresh matter.
2:30 ತಗೊಳ್ಳಿ.
at least ಮಂಡೇ ಮೇಲೆ
pending DA matter, requesting it to be connected to other DA matters coming on 28th.
You move the previous day.
lordship
You move the previous day.
ಮಂಡೇ ಮೇಲೆ
7 ಏನಾ?
490 ಲಾಸ್ಟ್ ಪ್ರೀವಿಯಸ್ ರೆಫರ್ ಬಿಟ್ಟು ಲಿಸ್ಟ್ ಆಗಿ ರೀಚ್ ಆಗಿಲ್ಲ, ಜಸ್ಟ್ ಅರ್ಜೆಂಟ್ ಆಗಿದೆ, ನೋಟಿಸ್ ಆಗಿಲ್ಲ, ಸ್ಟೇನು ಆಗಿಲ್ಲ.
Next roster move.
ಸೀನಿಯರ್ ಸಿಟಿಜನ್ಸ್
ಕೊಡಿ. ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ವಾ? ಅದು ಕೊಡಿ, being spoken to ಹಾಕಿ.
ನೋಟಿಸ್ ಆಗಿಲ್ಲ.
ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಸರ್.
DV Act proceedings against mother and
ವರ್ಕ್ ತಗೊಳಕ್ಕಾಗುತ್ತೆ, ಕೊಡಿ ಸರ್ ಎಲ್ಲ.
ಮಂಡೇ ಮೇಲೆ
Give all the memos.
ಮೇಡಮ್
Give off all the memos.
ಮಂಡೇ ಮೇಲೆ ಮಂಡೇ
Give off all the memos.
ಮೇಡಮ್
ಎಲ್ಲ all memos will dates ಬೇಕಾ?
ಮಂಡೇ
ಎಲ್ಲ 7 September ಗೆ ಹಾಕಿ ಮೇಡಮ್. ಕೊಡಿ.
ಸಾರಿ ಮೇಲೆ ಮಂಡೇ ಮೇಲೆ
All the memos post on 7 September. Withdrawal ಕೊಡಿ.
lordship
BWs.
I'll give a date 7 September ಕೊಡಿ.
MPMLA matter, Lord, Tuesday hearing before charge, Lord, from 6 months pending ಇದೆ. Lord, last occasion.
Next week.
Lord, Monday at least.
No, 28.
My lord, NBW is issued against.
ಅದು ಮೂವ್ 27th ಮೂವ್ ಮಾಡಿ, ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಬರುತ್ತೆ. ಇವತ್ತೇ ಹಾಕಿದ್ರೆ ಮೆಮೊ ಎಲ್ಲ ಹೋಗುತ್ತೆ. ಎಲ್ಲ ಕೊಡಿ ಸರ್.
My lords, NBW is issued, my lords, against bank officials.
NBW ಯಾರ್ದು? Why?
Bank officials, my lords, they're not even party for defreezing.
Why NBW?
Defreezing order was passed against the bank officials, my lords. I'm neither a party nor an accused in that petition.
Why you have not defrozen it?
My lords,
Why have you not complied with the order of the court?
lords have complied only 40% in view of the SOP.
Why 40% ನಿಮ್ ಪ್ರಕಾರನ?
SOP, my lords, I've not
Which
heard
SOP?
the Supreme Court's SOP, my lords.
What Supreme Court's SOP?
40%.
Next Monday or Tuesday ಕೊಡಿ.
30, my lords.
2:30 ಯಾವ್ದಿಲ್ಲ ಸರ್ ಕೊಡಿ.
ಮಂಡೇ ಮೇಡಮ್ ಮಂಡೇ ಮೇಡಮ್
Wait. Pending matter. ಕೊಡಿ.
DV
Engagement ಯಾವತ್ತು ಸರ್? Coming up on coming week. Then you also move it in the coming week. ಕೊಡಿ ಸರ್, ಸುಮ್ನೆ ಏನೇನೋ ಹೇಳ್ಬೇಡಿ, ಕೊಡಿ. Atrocity ಯಾರ್ದಿದೆ? ಏನು?
Since 2002 civil suit is pending. Last week they filed an FIR.
2:30. Atrocity ಇನ್ಯಾರ್ದಾರ್ ಇದೆಯಾ? Yes.
Lords, DV proceedings.
ಒಂದ್ ನಿಮಿಷ. ವಾರೆಂಟ್ ಇನ್ಯಾರ್ದಾರ್ ಇದೆಯಾ?
My lords,
ವಾರೆಂಟ್ ಇನ್ಯಾರ್ದಾರ್ ಇದೆಯಾ? ಇಲ್ಲಲ್ಲ. ಮಿಕ್ಕರ್ದೆಲ್ಲ ಮೆಮೊ ಕೊಟ್ಬಿಡಿ ಅಷ್ಟೇ.
my lords,
ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ ಮೆಮೊ.
petitioner is a
ಯಾವುದು
practicing
ಇನ್ನ
advocate.
2:30 ಗಿಲ್ಲ, ಕೊಟ್ಬಿಡಿ ಮೆಮೊ.
Lords, Tuesday, my lords, DV proceedings as against
No
mother
date.
and
We'll
other
give it.
who don't
Yes,
save.
give it.
My lords,
By the sessions.
Please
code,
give it.
FLW is issued against
Memo
me,
ಕೊಡೋದ್
my
ಕೊಟ್ಬಿಡಿ.
lords.
Lord.
I am not
this
giving
matter,
date, please
Lord.
give a memo, give the memo.
Citizen, my lords.
ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ sir memo.
This is the
My lord,
fourth
petitioner
memo.
is a practicing
Please
advocate,
give the
my
memo,
lord.
madam.
So kindly for Monday, my
No,
lord.
madam.
My lords, Monday.
Please give the
FLW
memo.
is issued against me by the honorable sessions court.
Why
my
you did
lords.
not attend the court?
My lords, I attended.
ಮತ್ತೆ ಸುಮ್ನೆ
on
FLW
payment
ಯಾಕೆ
of,
issue ಮಾಡ್ತಾರೆ?
Compensation they have, without setting
ಆಯ್ತು,
the
ಕೊಡಿ,
assets and
ತೊಂದ್ರೆ.
liabilities are
No
already.
problem, no problem.
Senior
FLW
citizen
issued,
is
my lords.
involved.
Kindly
Tuesday
take
is
up
the
the
matter
matter on
before the
Monday,
trial
my
court,
lords.
Monday ಬೆಳಗ್ಗೆ move ಮಾಡಿ.
Monday, my lords.
No, Lord. I have filed, Lord, I moved.
Monday ಬೆಳಗ್ಗೆ move ಮಾಡಿ sir.
Four memos.
Can I talk?
Date is.
Then ಡೇಟ್ ತಗೊಳ್ಳಿ 7 ಸೆಪ್ಟೆಂಬರ್ ಅಂತ ಕೊಡಿ. ಬೇಕಾದ್ರೆ ಕೊಡ್ತೀನಿ ಡೇಟ್.
I moved.
7 ಸೆಪ್ಟೆಂಬರ್ ಆಗತ್ತಲ್ವಾ?
Four memos have been moved. Your
ಡೇಟ್
lordship.
ತಾನೇ ಬೇಕು ನಿಮ್ಗೆ? 7 September is a date.
Tuesday is the
Chance
matter.
Monday,
Lord,
Mother.
before the trial court.
Kindly,
Kindly, Lord.
Now let me
Your
start the
lordship is
proceedings.
not aware of. not-
Nothing doing. ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ.
Can I take chance, my lord, Monday, my lord?
ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ sir.
Your lordship.
7 months, my lord. Appeal court not passing judgment. DV, criminal appeal arising out of DV proceedings.
ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್ ಕೊಡಿ ಅದು.
Tuesday, my lord.
ನೀವು ಬರುತ್ತೆ ಕೊಡಿ. ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್ ಅಂದ್ಮೇಲೆ ಕೊಡಿ.
Your lordship. First list serial number 48, your lordship.
ವಿಡ್ರಾ ಮಾಡ್ತೀರಾ? ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳಬೇಡಿ.
Can I take chance, my lord?
ಕೊಡಿ ಸರ್, ಪರವಾಗಿಲ್ಲ.
The lordship.
Not Tuesday. I won't give a date. Give it.
Fresh
No
matter,
sir,
Monday.
please give.
My lords, fresh matter.
Please give.
My lords, it's senior citizen.
So what? Please give. Yes.
There's a threat of arrest, my lords.
ಕೊನೆಗೆ ಇದೊಂದೇ ಬಾಕಿ ಅಂತಾನೆ.
There's no, my lords, he's a senior citizen.
Aye,
My lords,
yeah.
I'm a purchaser, my lords.
ಆ ಥ್ರೆಟ್ ಆಫ್ ಅರೆಸ್ಟ್ ತಗೊಳ್ಳಿ. ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ?
Lordship,
Madam.
case of acid attack.
That's kindly
Finally
230, my
ಪೆಂಡಿಂಗ್
lords.
ಮ್ಯಾಟ್ರ್.
ಇಲ್ಲ ಇಲ್ಲ ಸ್ವಾಮಿ, fresh matter ಸ್ವಾಮಿ.
ಏನು ಆಸಿಡ್ ಅಟ್ಯಾಕ್?
ಇದು ಸ್ವಾಮಿ.
ನಾನು ಇಲ್ಲೇ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ ಅದನ್ನ. ವಾಟ್ ಯು ವಾಂಟ್?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಸ್ಟೇ ಕೊಡ್ತೀನಿ ಅನ್ಕೊಂಡ್ರಾ?
Husband wife ಸ್ವಾಮಿ.
So what? You think I'll get it, grant an order in that? ಸುಮ್ಮನೆ don't move. Next bench try ಮಾಡಿ.
My lords, kindly 230, my lords.
ಅರೆಸ್ಟ್ 2:30 ತಗೊಳ್ಳಿ
My
ಮಾಡಿ.
lord, charge sheet has been filed against the sister-in-law and mother-in-law.
No problem, give
Kindly
it,
have
madam.
it on next week.
No,
any
no,
date,
give
my
it, give it.
May I
Yes.
make a mention?
Your lordship, this matter
Wait.
was listed yesterday. It has been referred to mediation.
ಹಾ.
My bank account has been frozen, your lordship. There are
ಅದಕ್ಕೆ
26
ಮೀಡಿಯೇಷನ್
centers.
ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಡಿಫ್ರೀಸ್ ಮಾಡಕ್ ಹೇಳ.
ನಿನ್ನೆ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ application. There are
ಏನ್ನ?
26 centers to which I have to pay salary.
I will see.
Without any
Give it.
judicial order, my bank account has been frozen.
Give
your
it,
lordship.
give it,
Kindly
please.
have it at 2:30.
No. ಅದು ಮಂಡೇಗೆ ಹಾಕಿ ಮಾಡಿ.
My lord,
Your lordship.
ಸಾರಿ?
ಇವತ್ತಿಗೆ date ಕೊಟ್ಟಿದ್ರಿ.
ಯಾರು ಡೇಟ್ ಕೊಟ್ಟು? ಆರ್ಡರ್ ಮೆಮೋನಾ? ಆರ್ಡರ್ ಇದ್ರೆ ಮಾತ್ರ ವಿಲ್ ಸಿ. ಎಸ್ ಕೊಡಿ ಸರ್, ತೊಂದರೆ ಇಲ್ಲ.
my lord, may I make a
ನೀವು
mention?
ಕೊಡೋಂಗಿದ್ರೆ ಕೊಡಿ ಸರ್. ಏನ್ ಈ ಎಲ್ಲ ಪ್ರೆಗ್ನೆಂಟ್ ಲೇಡೀಸೇ ಆಗ್ಬಿಟ್ಟು ಮೂವ್ ಮಾಡೋದಿಲ್ಲ. ಮೆಮೋ ಕೊಡಿ ಇಲ್ಲಿ ಎಲ್ಲ ಸುಮ್ನೆ. ಗಿವ್ ಇಟ್. ಎಸ್ ಸರ್.
My lord, today there is item 92.
ಹಾ.
I have to travel today, if your lordship can.
Who's stopping you from travel?
My lord, please, any other day. It's a IA filed by the government.
Seal number 92.
Yes.
What is the problem?
List number 2.
All right.
Yes.
You are for the respondent.
Yes.
All right.
Any other day which you.
No, today I'll take it.
My lord, today I cannot appear, my lord.
Why you cannot
I
appear?
have to travel to
Then
Goa.
why did you come?
Only to mention.
Only to mention.
Yes.
Seriously. Yes.
Lord, can I make a mention, my lord?
ಅದ್ರಲ್ಲೇನಾ?
ಇಲ್ಲ.
Huh?
Lord, see the
We have informed the others.
All right. Whenever you want. We post it on in the second week of September.
Whichever date your lordship.
No
Much of.
lordship. My lord, item number 116, my lord. In list 2, my lord, your lordship to recall, my lord, that there's Canada Bank matter where your lordship.
ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಆದ್ರೆ ಈಗ ರೀಚ್ ಆದ್ಮೇಲೆ ಹೇಳಿ.
My lord, I'm told your lordship said at 3 o'clock. My lord,
ಯಾವ್ದು?
take it up at 3 o'clock.
Which one?
116 in list 2.
ಯಾವುದು ಅದು?
My lord, that Canada Bank matter, my lord, we are finding a solution. We are finding a solution. If I may say so, my lord, with due respect.
ಅದೇ
we are finding
ವ್ಯಾಲ್ಯೂ
a-
ಇರ್ದಾ?
Yes. We are finding a solution to put an end to the mess. Can it be taken up on Monday? I'll finalize.
No problem. Monday.
It is, I must confess, my lord, a lot of wrong things have happened. We will sort it out, my lord.
All right.
So that we
Your
will not
lordship.
trouble the court also to write an order. Great.
Your lordship, on matter for 2:30, your lordship.
2:30 ಯಾವ್ದಿಲ್ಲ ಕೊಡಿ.
Connected matter listed today. ma'am.
ಪರವಾಗಿಲ್ಲ.
There is option on 20.
Third round of litigation instituted.
ಈಗ ಏನ್ ಬೇಕು? No.
My lords.
No. Just give the memos.
Sister in law, mother in law.
ಯಾವ ಇನ್ಲಾ ಆದ್ರ ಬ್ರದರ್ ಇನ್ಲಾ ಅದರ್ ಇನ್ಲಾ ಎಲ್ಲ ಕೊಡಿ ಇಲ್ಲಿ. ಮೇ ಬಿ ಟ್ಯೂಸ್ಡೇ ಇದ್ರೆ ಮಂಡೇ ಮೂವ್ ಮಾಡಿ.
My lords, it's a.
ಇವತ್ ಮೆಮೋ ಹೋಗ್ಬಿಡುತ್ತೆ ಎಲ್ಲೋ. ನಿಮ್ ರಿಸ್ಕ್ ತಗೊಂತೀನಿ ಕೊಡಿ. You move 10 also, no problem, sir.
My
7
lords,
September date ಕೊಡ್ತೀನಿ ಬೇಕಾದ್ರೆ ತಗೊಳ್ಳಿ. No problem. 7 September I'll give a date. No, sir. Nothing.
my lords, it's a,
Defreeze ಮಾಡಕ್ order ಆಗಿದೆ.
ಈಗ ಮೆಮೊ start the cases. Call the cases.
my lords, it's a road access issue, my lords. They're
Give it,
blocking
madam.
access to
Give
the
it,
road
give
of
it.
500-600 people and
Give it,
encroaching on
madam.
public road, my lords.
What happened?
They're encroaching on public road, my lords.
Who?
Anytime, the complainants, my lord, anytime the neighbors object to it, they're filing FIRs, my lord.
So what? Give it. Yes. ವೆಂಕಟಾಚಲಪತಿ
they're
ಎಲ್ಲ ಕೋರ್ಟ್
using-
ಮುಗಿಸ್ಕೊಂಡ್ ಬಂದಿದ್ದ ಕೊಡಲ್ಲ.
No, no.
No.
Waiting here.
No, I did not see you at all. You are a prominent figure. I can't miss you at all. No way. Yes. No, don't do this. Nothing doing. ಕೊಟ್ಬಿಡಿ. ಯಾವ್ದು ಡೇಟ್ ಇಲ್ಲ ಎಂತದಿಲ್ಲ. Call the cases, please.
Disturb this court and
I see you. What a good cause, sir. Very good. ಇವೆಲ್ಲ ಕಲ್ತ್ಕೋಬೇಡಿ. ಎಲ್ಲ ಮುಗಿಸ್ಕೊಂಡು ಇಲ್ಲಿ ಬಂದಿದ್ದೀರಾ.
is on Monday, my lord.
Maybe, sir. Move on Monday, sir.
My lords, one submission. The advocate has issued notices on behalf of complainant.
ಕೊಡ್ತೀರಾ ಇಲ್ವಾ? ಡೇಟ್ ಏನ್ ಕೊಡಲ್ಲ ಕೊಡಿ.
My lords, the advocate, the affair has been raised against the advocate.
No problem. Give it.
Notices-
Give it. If you want to give it, give it. No date. September 7th ತಗೊಳ್ಳಿ ಇವ್ರು 3 ಜನದ ಮೆಮೊನ. Yes.
Fresh matters?
September 7th.
Matter is on Monday.
No problem. We'll post it on September 7th. ಪರವಾಗಿಲ್ವಾ?
It's on Monday, my lord.
No. September 7th is also a Monday.
This one fresh matters, number 1.
3 students have been dragged into the.
ಅದು ಮುಂಚೆ ಇಲ್ಲಿ ಇರ್ಬೇಕು. ಎಲ್ಲರೂ ಇದ್ದು ನಿಲ್ಲ. ನೀವೆಲ್ಲ ಕೊಟ್ಟು ಮುಗಿಸ್ಕೊಂಡ್ ಬರ್ತೀರಾ? ಹೌದಾ ಇಲ್ವಾ ಹೇಳಿ? ಸುಳ್ಳು ಹೇಳ್ಬಾರ್ದು.
It's actually late, my lord. ನನಗೆ ಇರೋದೇ ಇಲ್ಲ. ಇದೊಂದೇ ಕೋರ್ಟಲ್ಲೇ ನಾನು ರೆಗ್ಯುಲರ್ ಆಗಿ.
ಬೇರೆ ಎಲ್ಲ ಹೋಗೋದೇ ಇಲ್ವಾ?
No, my lord.
ಅದೇ ಹಿಂಗೆಲ್ಲ ಹೇಳ್ಬೇಡಿ.
Only practice before.
Only practice before this court. Dangerous. ತಗೊಳ್ಳಿ. Why 2:30? ಸೋಮವಾರ ಮಂಗಳವಾರ ಬರುತ್ತೆ. ಸೋಮವಾರ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ ತಗೊಳ್ಳಿ ವಾಪಸ್.
Monday, my lord.
ಸೋಮವಾರ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ ತಗೋತಿ. ಬಟ್ 10:30ಗೆ ಬರ್ಬೇಕು.
Definitely.
ಬ್ರೇಕ್ಫಾಸ್ಟ್ ಮಾಡಿಲ್ವಾ? ಮೈಗೆ ಕೇಳ್ಕೊಳ್ಳಿ.
Here for the petitioner, my lords, there's some inconvenience today. Kindly have it on any other date, my lords.
7th or 8th September ಬರ್ಲಿ. At the request of the council appearing for the petitioner, list in the second week of September. Next. ಇದೇನ್ ಕವರ್ಡ್ ವಾಪಸ್ ಕಳಿಸ್ಬೇಕಾ?
Criminal appeal ಒಂದು ಪೆಂಡಿಂಗ್ ಇದೆ. Whether conviction ಆಗಿರೋದು
ಬೆಳಕೆರೆ
ಅದಾ?
the order is pending.
ಅಲ್ಲ ತೊಂದರೆ ಇಲ್ಲ. ಇದು ಪವಿಂದರ್ ಸಿಂಗ್ ಅಲ್ಲ ತಾನೆ?
ಅಲ್ಲ ಅದಲ್ಲ.
Yes, yes.
ಅದಾದ್ರೆ ನಾ ಹೇಳ್ಬಿಡ್ತೀನಿ.
ಆಯ್ತಾಯ್ತು. ನೆಕ್ಸ್ಟ್.
Number 2.
Matter, my lord, where speech was done, my lord, is the
ಗೊತ್ತು.
allegation.
ಪ್ರೊಟೆಕ್ಟಿವ್ ಆರ್ಡರ್ಸ್
Yes,
ಕೊಟ್ಟಿದ್ದೀವಿ.
my lord. But my lord,
Objections ಎಲ್ಲಿ? SPP ಎಲ್ಲಿ?
proceedings may be stayed, my lord.
28
There is no ingredients
final.
of the offence at all.
We'll see. List on 28 as a last chance for filing of statement of objections. In the event no objections would be filed or no submissions would be made, this court would be constrained to pass necessary orders, hearing the senior counsel of the petitioner. Yes. Next.
Matter by petitioner.
That will continue. Yes.
Number 3.
Requesting for some accommodation.
Why?
Get ready, my lords.
Get ready.
351(2) is invoked. My lord, this is calling officer.
Aye.
This is an officer as an.
Of course, my lord,
Pomerian dog.
it could be in a bad.
Kalburgi.
ಇಲ್ಲ, ದಾವಣಗೆರೆ. Could be in a bad taste, but definitely ingredients would not.
No, sir. If it's bad taste, we will dismiss it right away.
My lords, I'll argue next week.
No.
351(2) and 79.
Where is that? I have granted.
Page 32,
My lords, it was granted on the premise that cognizance order detail illanta. Last time, my lord.
ವಾಪಸ್ ಕಳ್ಸೋಣ.
No. Last time we filed a memo along with detailed cognizance order, which we were not aware. Next week I'll argue this. Kindly accommodate.
Is it against that Muslim officer?
No.
ಅದಲ್ವಾ?
Against
List
the
the matter
officer,
on-
my lords, he addresses as.
ಆಯ್ತಾಯ್ತು. List the matter on 28. La. Yes.
What's interim order?
That will continue. Why is the learned age waiting?
Item 7.
Yes.
4.
before, my lord, covered by that MSPL judgment with respect to exporters are concerned.
Hmm.
Previous occasion, my lord,
ಏನದು?
last week, my lord, there was similar matter listed. This is in respect of IPC offences. What is listed today, my lord, is MMDR offences. MSPL compared,
We'll tag it.
yes,
Tag this petition along with so and so, same order. Our date and ಕೊಟ್ಟಿದ್ದೀನಿ. To list on 28/8
please.
in the fresh
The
matters.
crime number changes, my lord, but the
ಅಲ್ಲ
crime
ಪರವಾಗಿಲ್ಲ.
number.
Anyway, interim order ಅಲ್ಲಿ
Please,
we'll tag it and do it.
please.
28. ಅವ್ರು ಯಾರಿಗೆ ನೋಟಿಸ್? ಇದು ಯಾರಿಗೆ?
Prasanna Kumar, CBI.
ಅಲ್ಲ ಇದು ಈ ಕೇಸ್ ಸೇಮ್
Same petitioner.
ಎಲ್ಲ ಸೇಮ್.
MSPL had IPC and MMDR. Here, my lord, two separate petitions.
Yes, next.
Same.
Oh, same order.
The petitioner is 81-year-old, former minister, MP and MLA. Allegation
Heard
against
the learned senior counsel Divakar appearing for the petitioner. Learned additional SPP is directed to accept notice for the respondent, first respondent, second respondent emergent notice. There shall be an interim order of stay of further proceedings in CC so and so, finding not a speck of ingredient of the offences being met against the present petitioner. Yes.
Still number 6.
May I please, your lordship?
Short,
I beg to appear through VC, my lord.
had to intimate.
For retirement, yeah, retirement.
No, that is Madhukar Deshpande has transferred.
All right.
Other though, if it may be taken on 28, lordship.
Right.
Finally.
My lord, this cancellation filed by the ED, my lords. This is the third time they are seeking adjournment.
No, but
Cancellation of bail.
Cancellation of bail note granted in December. This
It's
is
not
the same
cancelled.
public case, my lords, which your
You're-
lordships have
you're-
heard.
You're still at liberty, Allah, don't worry.
Yes, my lords.
Yes, as a last chance. The learned counsel Madhu N. Rao seeks time to make his submissions. As a last chance, list this matter on 28/8. In the event no submissions are made, appropriate orders would be passed.
Publish.
Yes.
Seven.
Idiano.
What's this, the bail condition relaxation,
yes, sir.
my lord.
Lord, I have 3 submissions to make. Lord, the petitioner has now built the entire case on the ground of a changed circumstances. Changed circumstances can be a valid ground. The bail itself was granted in August 2024. And now, Lord, my respectful submission is, should not the petitioner approach the court which granted the bail to go back and place the changed circumstances by placing foreign adjudication on that? Lord, that has not been done. Lord, he has approached directly. Lord, my second submission is that, Lord, so what if the petitioner has been now appointed as a minister? It is not a curtailment of his liberty is not taken away. It is only a regulation of his liberty. Lord, in the past, he has taken the permission of the court and he has traveled. So therefore, he can continue to do so merely because he is now appointed as a minister. That does not mean that he need not seek the permission of the court if the court has otherwise felt that his permission is necessary. And Lord, my third submission is that in the past, Lord, this constitutes approbation and reprobation. The petitioner has used the very same liberty which is granted, condition number C. He has made applications, availed the permission of the court and then traveled. Now, my lord, to question the condition itself, my lord, would constitute approbation and reprobation. So therefore, my lord, he should first go before the court which imposed the condition and place the so-called change in circumstances for an adjudication. That is all.
Yes, sir. Anything in reply? The
Lords, voluntarily, though your lordships had observed, the condition is she shall not travel outside Karnataka.
outside the country, no.
Country
not
ನಾನೇ ಕೇಳ್ತಾ ಇಲ್ಲ ಅಂತ your lordship for the present. Anything required, my lords? Not that we are voluntarily saying that.
The petitioner is before the court calling in question in prayer.
My lords, the prayer your lordships would get, my lords, in page.
Page 500 ಅಲ್ಲಿ ಇದೆಯಾ?
ಇಲ್ಲ. The order starts at 228.
ಅಲ್ಲ ಸರ್, ನಿಮ್ ಪ್ರೇಯರ್ ಇಲ್ಲಿ ಏನಿದೆ?
Prayer, my lords, 8, page 8.
8 ಅಲ್ಲೇ ಇದೆಯಾ?
Page 8 ಅಲ್ಲಿ.
Oh, it's short. The petitioner is before the court seeking the following prayer. Heard the learned senior counsel K. N. Panindra appearing for the petitioner, the learned additional Solicitor General of India, Sri Arvind Kamath, along with so and so. The petitioner presently minister, huh?
Cabinet.
Presently a minister in the cabinet of the government of Karnataka has knocked the doors of this court seeking relaxation of a condition that was imposed upon him while bail was granted by the concerned court. The order of the concerned court reads as follows. Elidadu.
320, 320, running page.
320.
320, clause C, my lords.
The petitioner was enlarged on bail by a detailed order of the concerned court in criminal miscellaneous 7892 of 2024. The operative portion of the order reads as follows. Though the order was passed on 14/10/2024, the petitioner had not sought relaxation of any of the conditions till the subject petition was preferred before this court.
Not for deletion of that condition. Quashing that condition. I was applying for bail as and when I wanted to
Correct.
move.
ಈಗ ಅಲ್ಲಿವರೆಗೂ ಏನು ಕೇಳಿಲ್ವಲ್ಲ. Had not sought quashing of those conditions till the day the present petition was preferred on 7th August 2026. The petition was preferred in the wake of the petitioner being sworn in as a minister of the cabinet in the government of Karnataka. Owing to the necessity, this court had granted an interim order suspending the effect of that condition that had imposed that the petitioner should not travel beyond the jurisdiction by the order dated 7/8/2026. The learned additional solicitor general would project three contentions. One, that the petitioner ought to have approached the concerned court itself seeking quashment of the said condition.
Deletion of that condition or modification of that.
But ಇಲ್ಲಿ ಕೇಳಿರೋದು quashing ಅದು. Anyway, deletion.
Ultimate net result is the same.
Correct. ಅದಕ್ಕೆ that should not be like your statement.
Yes.
Because that court has no power to
Has no
quash.
power
That- Deletion or dilution of instead of deletion, we'll take it as dilution. Dilution of the said condition and not approach this court directly, seeking the relief that he has sought for. The learned counsel would, the learned ASGI would further contend that changed circumstance no doubt would inure to the right of the petition, right of the accused to seek relaxation of conditions. But this is not a changed circumstance that this court must entertain, as at every time for the last 2 years, whenever he is wanting to travel, he has sought permission of relaxation of the condition and then has traveled. Therefore, that method ought to have been adopted. He cannot now approbate and reprobate by accepting the condition for 2 years and now seeking its dilution or deletion as the case would be. The learned ASGI would further contend third ಏನು
Other approbation.
ಅದೇ ಅಲ್ವಾ ಅಷ್ಟೇ so and so.
But I'm sorry.
Based on the said
The prayer is not for quashing, to delete the condition.
sorry. Therefore, the learned ASGI would submit that the remedy lied before the concerned court as he was seeking that remedy all through the 2 years that the order was in subsistence. Per contra, the learned senior counsel Panindra would submit that the circumstance today is not that he should knock at the door of the concerned court every time that he has to leave the jurisdiction, owing to his present position, that he may have to travel beyond the shores of the jurisdiction. The petition is sought. As observed here in above, the prayer.
Also the time taken after I filed the application.
As also the time that is consumed before the concerned court when the application is filed, which is not allowed ex parte, but after hearing the counsel for the hearing the state and all the rigmarole to be followed later. In the light of the aforesaid submission and the contra submission, what necessitates consideration is whether the petitioner is entitled to deletion of the said clause in owing to the circumstance that is narrated herein above. The prayer of the petitioner is deletion of condition C imposed on 14/10/2024. The condition is quoted supra. The position of the petitioner today being the minister in the cabinet of government of Karnataka is an admitted fact. In the light of him being the minister in the cabinet of a cabinet minister in the government of Karnataka and holding a portfolio or a B portfolio would necessarily would necessarily require to travel beyond the shores of the jurisdiction. In the light of the said circumstance, there is a circumstance while observing that the petitioner cannot travel without the permission of the concerned court or this court beyond the shores of the nation. The petitioner is free to travel within the country, as not permitting him to travel within the country would undoubtedly curtail his liberty and the position that he is holding today. In that light, I deem it appropriate to pass the following order. The the criminal petition stands allowed. The condition number C so and so stands deleted in the light of the aforesaid reasons so rendered by the concerned court. It is made clear that the petitioner cannot leave the shores of the nation at any point in time without the concerned court or this court permitting him to do so on an appropriate application so filed.
Let him also appear before the authorities.
For what?
If required. There are some new material found. There is, my lord, the new.
Whatever,
new
that he will
proceeds-
go.
They have actually postponed to, yesterday they were called me on 18th.
That's all.
They have postponed to 20th, my lords. We
He
have
will
said
he will
after
appear.
session we'll.
He will appear,
because they-
definitely. The learned ASGI would submit that the petitioner should cooperate with the inquiry stroke investigation. The learned senior counsel submits that he has never stopped from cooperating with the investigation or inquiry and he will continue to cooperate.
Any attendance will be done after session. So
That's what.
because session is current, they want.
So
me to-
whatever, that's, you submit to that, we'll see. Yes.
Bill number 8.
My lords, this is discharge of surety. The company has gone into liquidation.
Who is this?
I am the liquidator appointed by IBC, Your Honor, in this case.
K.S. Mahadevan.
Yes, Your Honor.
K.S. Mahadevan.
No, Your Honor, I am Narayana Kamma, liquidator has been appointed
Again,
by the
It's for discharge of surety, Your Lordship. The respondent number 1 had conducted a raid.
will not say, we'll take it next week. List on 28th. Yes. Next.
Number 9.
State
Any-
as the petition, my lords.
Respondent number 2.
ಮುಜಫರ್
ಎಲ್ಲ
ನಿನ್ನೆ
respond
ಒಂದು ಟ್ರಾವೆಲ್ ಪರ್ಮಿಷನ್ ಕೊಟ್ಟನಲ್ಲ ನಿಮ್ಗೆ
ನಿನ್ನೆ ಹೌದು
ಅದರಲ್ಲಿ ಕೇಸ್ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬಿಟ್ಟಿದೀವ.
ಇಲ್ಲ ಡಿಸ್ಪೋಸ್ ಆಗಿಲ್ಲ ಸರ್, ಸ್ಟೇ ಆಗಿದೆ.
ಅಯ್ಯೇ ಹಾಕಿದ್ರ ಅದ್ರಲ್ಲಿ?
ಇದ್ರಲ್ಲಿ ಅಯ್ಯ ಹಾಕಿದ್ವಿ.
ಅಯ್ಯ ಮೇಲೆ ಆರ್ಡರ್ ಆಗ್ಬೇಕು ಬಿಕಾಸ್ ಅದು ಕೇಸ್ ಡಿಸ್ಪೋಸ್ ಆಗ್ಬಿಟ್ರೆ ಕ್ವಾಶನ್ ಕೇಳಿದಿರ ಅದ್ರಲ್ಲಿ.
ಇಲ್ಲ
ಅದಕ್ಕೆ
ಅಯ್ಯ ಮಾತ್ರ.
ಅದೊಂದು ನೆನ್ನೆ ಪೆಟಿಷನ್ ಯಾವ್ದು ನೋಡಿ ಮೇಡಮ್ ಅವರು. ಎಸ್ ಡಿಸ್ಪೋಸ್ ಆಗ್ಬಿಟ್ಟಿದೆ, ಚೆಕ್ ಮಾಡಿ.
Let's agreed by the order of the revisional court, my lords, the status before the petition. My lords, there's an FIR
ಏನಿದು
registered.
ಡಿಸ್ಚಾರ್ಜಾ?
Discharge ಮೇಲೆ revision dismiss ಮಾಡ್ತಾರೆ. The same has been challenged.
ಏನ್ 2018
ಹೌದು.
ಎನಿಥಿಂಗ್ ಎಲ್ಸ್ ಸರ್?
Then my lords, the involvement of the respondent is very much involved.
ಯಾವ ಇನ್ವಾಲ್ವ್ಮೆಂಟ್?
Flying 2 buses, my lords, in the same chassis and the engine number.
ಓಹೋ.
Evading paying taxes, my lords, to the government.
ಎನಿಥಿಂಗ್ ಎಲ್ಸ್ ಸರ್? ಬಸ್ಸಾ?
ಸೇಮ್ ಬಸ್.
ಡಿಸ್ಮಿಸ್ಡ್. ನೆಕ್ಸ್ಟ್. ಸುಮ್ಮನೆ 2019 ಇಂದ ಪೆಂಡಿಂಗ್ ತೋರ್ಸುತ್ತೆ.
10.
ಈಗ ಬಸ್ ಎಲ್ಲ ಬಿಡಿ ಅವ್ರ ಹತ್ರ. ಅಮ್ಮದ ಗೊತ್ತು ಇದೆಯಾ? ಈಗಲೂ ಇದೆಯಾ? ಸುಯೋಗ್.
R2, my lords, may request for passover, my lords.
ವೈ ಪಾಸ್ ಓವರ್ ಸರ್?
It is held up in next part.
ನಥಿಂಗ್. ಎಸ್ ಸುಯೋಗ್, ಏನಿದೆ? ನಿಮಗೂ ಪಾಸ್ ಓವರ್ ಬೇಕಾ? ಹೇಳಿ.
420 is the offense. 420.
420
ಹೌದು.
ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ?
B report was initially filed by the police after investigation. Regular magistrate, my lords, has taken cognizance, my lords, and has
Not
one
the
aspect.
not the special court.
Not the special court. That is one aspect. Apart from that, my lords, on merits also we have got a good case.
Not the special court ಅಂದ್ರೆ ವಾಪಸ್ ಕಳ್ಸೋಣ.
apart from that, even merits, my lords, there is a good case.
ಏನ್ ಮೆರಿಟ್?
My lords, the allegation is that, my lords, a compromise petition
ಹಾ,
entered in the court, my lords, was not with the consent of the parties, is the allegation made by the respondent number 2.
ಡಿಸ್ಪೋಸಲ್ ಅಲ್ಲ ತೆಗೆದ್ಬಿಡಿ, ಯಾಕೆಂದ್ರೆ ನೋಡಿ ಅಲ್ಲ ಬೆಳಗ್ಗೆ ಹಾ.
So the allegation is, my lords, the compromise petition entered between the parties in a suit, my lords, was not, my lords, at the willingness of the respondent number 2 is his allegation. Someone else has impersonated.
ಸೈನ್ ಮಾಡಿಲ್ವಾ ಇವರು?
ಅವ್ರು ಮಾಡಿಲ್ಲ, someone has impersonated ಅಂತ allegation ಅವ್ರು ಮಾಡಿ.
ಯಾವಾಗ ಆಗಿದ್ದು ಕಾಂಪ್ರಮೈಸ್?
My lords, compromise in the year 2011.
2011
ಹೌದು. ಅದಾದ್ಮೇಲೆ ರಿಟ್ ಆಗ್ತಾರೆ. ರಿಟ್ ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಮೇಲೆ ಆರ್ಡರ್ ಹ್ಯಾಸ್ ಬಿನ್ ಸೆಟ್ ಅಸೈಡ್ ಆನ್ ಡಿಫರೆಂಟ್ ಗ್ರೌಂಡ್, ನಾಟ್ ಆನ್ ದಿ ಗ್ರೌಂಡ್ ಆಫ್ ಫ್ರಾಡ್ ಆರ್ ಎನಿಥಿಂಗ್.
ವೇರ್ ಇಸ್ ದಿ ಸೆಟ್ಟಿಂಗ್ ಅಸೈಡ್ ದಿ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್? ಯಾರು ರವಿಶಂಕರ್ ಬರ್ಬೇಕಾ?
ಸತ್ಯನಾರಾಯಣ ಚಾಲ್ಕೆ
ಹೇಳಿ. ಎಸ್ ವೇಟ್, ನೀವೆಲ್ಲ ಮಾಡಿದೆ ಯಾವಾಗ?
on this legs, my lords.
ಸ್ಪೆಷಲ್ ಇಲ್ಲೂ ನಿಮ್ ಇವ್ರು ಬರ್ಬೇಕಾ?
Yes,
ಡಾಕ್ಟರ್
Doctor.
ಪಾಸ್ವರ್
Said my request, my lords, on 28.
ಪಾಸ್ವರ್ ಎಸ್. ಬೇಡವಾ ನಿಮ್ಗೆ ಆರ್ಡರು?
ಆರ್ಡರ್ ಬೇಕು
ಮತ್ತೆ
ಪಾಸ್ ಓವರ್ ಬೇಡ. ಮಧ್ಯಾಹ್ನ ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ಫರ್ದರ್ ಏನ್ ಐ ಡೋಂಟ್ ವಾಂಟ್ ಟು ಸೀಕ್.
The list on 28th in the fresh matters list. Finally,
please.
ಮತ್ತೆ ಅವರ್ ಟೈಮ್ ಕೇಳಿದ್ರೆ ನಾನು ಆರ್ಡರ್ ಮಾಡ್ಬಿಡ್ತೀನಿ. ಅವ್ರು ಕೇಳಿದ್ರೆ ಡಿಸ್ಮಿಸ್, ನೀವು ಕೇಳಿದ್ರೆ ಅಲೋಡ್. Yes.
Interim order maybe.
Interim order will continue next.
Correct.
7.
Not adjournment, my lords. Senior is not well.
Respondent number.
Pasha sir is not well. 28ಕ್ಕೆ ತಗೋಣ.
Interim order.
27th.
28th. List the matter on 28th in the fresh matters list. In the same admission, same stage. Same stage made clear, no further adjournment would be granted in the matter. Arbatti sir ಯಾರಿಗೆ?
Look, including
ಯಾರು impleading ಯಾಕೆ?
we have filed not application for cancellation of bail. Not the decision in this case not is substantially affecting the application that we have filed.
Cancellation of bail ಹಾಕಿದ್ದೀರಾ?
We have filed not before the.
ಯಾರು? ಕುಮಾರಸ್ವಾಮಿ ಅವರದು. ಯಾಕೆ ಏನಾಗಿದೆ?
Not because of not the facts which are narrated in the complaint. That they are in the nature of intimidatory facts, not and intimidation against the investigating officers of the SIT, and also not other not some statements are made in that press release, briefing, not which affect not the investigation also. He would also make some declarations regarding not availability of papers which are only between exchange between the investigating officer and the office of His Excellency the Governor. Some lot tampering and all.
Pasha sir, you're not well. I'll take it on 28th. ನೀವ್ ಯಾಕೆ ಬರಕ್ ಹೋದ್ರಿ? 28 ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ಗೆ ಇದಾಕಿದ್ದೀರಾ? ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ದೀರಾ?
Already there is an order. They cannot be a party for this.
Then leave it. ಮತ್ತೆ ಯಾಕೆ still pending?
We are there not just to assist this honorable court. Not I will show not the earlier order which was passed not which was passed in the nature of a disposal, not a rejection of my request for impleading.
Disposal and rejection are same.
That disposal at that stage not with some observations. That observations not subsequently were not fulfilled. That is why I'm not there is an.
28ಕ್ಕೆ ತಗೊಂತೀನಿ.
Great.
List on 28th.
12.
ನೀವು ಹಾಕಿದ್ದೀರಾ? ರಜತಾ ನೀವಾ?
We need to file ready.
ಏನ್
Complaint.
ಏನ್ ಶಿವಣ್ಣ ಇದು?
This is a defamation complaint, my lords, that we had preferred. They challenged it on the ground, my lords, that it's
Respondent is also Shivanna.
Next week, any date may be given. Their only ground, my lords, is that their actions are covered under exception 8 of section 499, my lords. The criminal acts perpetrated by the petitioner, my lords, is twofold. One, he addresses a letter, my lords, to His Excellency the Governor, making certain defamatory remarks.
Oh, that.
Second, my lords.
ಇದಿರ್ತಾನೆ ಮೂಡಾದ.
No.
ಬೇರೆನೇ ಇದು?
ಬೇರೆ. Second, my lords, he completely unconnected, unrelated to the letter addressed to His Excellency the Governor. He calls upon a statewide recognized news channel into his legislative house and then makes, my lords, defamatory remarks. Even assuming, my lords, that the letter addressed to His Excellency the Governor is covered under Exception 8, the live press interview, my lords, where he makes these statements are by no stretch of imagination covered. He's had the benefit, my lords, of an interim order for almost over a year, making these submissions.
Finally, 28th, whoever comes on record, I'm not concerned. List the matter on 28th in the fresh matters list finally. It's made clear, no adjournment would be granted to the petitioner on whatsoever ground. Interim order subsisting subject to the aforesaid shall continue till the next date of hearing.
So,
13.
Appear for petitioner, Lord. Offense of 509, my lord, sir.
ಏನ್ ಮಾಡಿದ್ರಿ ಸರ್?
Page 16 of the para 2, my lords. The last 3 lines. Page 16. ಇಷ್ಟು ಜನ ಹೆಣ್ಣು ಮಕ್ಕಳು ಸೇರಿರುವುದು ನೋಡಿದರೆ ಅಕ್ಕ.
ಯಾರ ಮೇಲೆ?
The last line, my lords.
She says,
The last
she
line is
presumes
the-
that it is against Nimbalkar.
ಹೆಸರು ಹೇಳಿಲ್ವಲ್ಲ?
ಹೇಳಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ?
ಅಕ್ಕ ಅಂತ.
ಅಕ್ಕ ಅಂದ್ರೆ?
It's to be presumed that, my lords, in a said locality, said leader is identified as Akka.
ಅಯ್ಯೋ ಇದು ಹೆಂಗೆ? ನೇಮ್ ಹೇಳಿದ್ರೆ ಸ್ಟ್ರೈಟ್ ಅವೇ. Why not 9 is not generic, sir. It's not general. It's specific to a woman. ಅಷ್ಟೇನಾ? ಯಾರಿಗೆ ಹೇಳಿರೋದು ಇದು?
Lakshmi Abbalkar. The last
She
three come.
She
ಅಲ್ಲ,
presumes that it is
ನೇಮೇ
against.
ಇಲ್ವಲ್ಲ?
Name ಇಲ್ಲ ಇದಲ್ಲ.
ಮತ್ತೆ ನೇಮ್ ಇಲ್ಲ ಅಂದ್ಮೇಲೆ 509 ಹೆಂಗ್ ಬರುತ್ತೆ?
Complaint, my lords, specific.
ಓ ಏರಿಯಲ್ಲ ಕರೆಯೋದು ಹಾಗೆ ಅಂತನಾ? Yes, nothing. Allowed cost.
Please.
14.
Hearing for responding.
Challenge the B report, your lordship, wherein no reasons have been given. It's covered by your lordship's judgment, wherein your lordship had said that even for a B report to be
Rejection of the
discarded.
B report.
Please, your lordship, the reasons would have to be assigned. Here, there are no
Again,
reasons
cognizance
assigned.
ತಗೊಂಡಿದ್ದಾರಾ?
Your lordship, please. Your lordship, this is also a matter wherein, as I had mentioned the last occasion, Honorable Supreme Court was seized of the same connected matters, wherein Honorable Supreme Court directed them why to give the 6 crores at least to start with. They refused to pay up the 6 crores.
That's that banking thing.
Your lordship,
connected.
this was mining license. He has paid them 15 crores. Out of 15 crores, they have not returned anything. 6 crores checks given. Even those checks are dishonored. No, those dishonored of
Who
checks.
gave you?
Your lordship, the complainant in this matter.
My lord,
For return of that amount. Now, your lordship, that dishonor of check cases, they approach this honorable court and they take a stay. What
Is
they do
that
is,
good?
as a counter blast, they file a case against us, stating that the police had harassed and the police had dragged him from Chennai and brought him to forcibly sign these checks. As a counter blast, this case is filed. Now, your lordship, the entire case is as against me, though all the excesses that he alleges are against the police officers, which nobody is made a party to. All of this was dealt with by Honorable Supreme Court, wherein Supreme Court told them at least to start with 15 crore beda, at least 6 crore return madi, they had not
ಅಲ್ಲ
done
ಇದು
it.
ಇನ್ನೊಂದು ಕೇಸ್ ಯಾವ್ದು ಸ್ಟೇ ತಗೊಂಡಿರೋದು?
That is the PCR matter where they have a, there's a-
Which petition is that?
my lord, I am seeking short adjournment, my lord.
I will grant you.
4732.
ಬರ್ಕೊಡಿ. Tag this petition along with ಅದು ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ದ?
That because he's a complainant there, it will not come under your lordship. Then clubbing them will be a difficulty. Your lordship had heard this matter on the last occasion.
List number ಕೊಡಿ.
Please.
List this matter along with, not tagging but in seriatim on 28/8/2026. Finally, it is made clear if the respondent would not make submissions, orders would be passed on hearing the Senate counsel for the petitioner. Interim order subsisting would continue to the next date.
Obliged. Just give us the number.
15.
This and 17 is connected. The same allegation, 2 FIRs were registered.
Lord, section 196 notes, making allegation against Lord, the community members notes. Kindly see Lord, the allegations here made in the complaint notes. Page 12 Lords.
I'm there only. Will Javed Hajam in?
But sir, last time I placed it. Last time I placed it. Your Lordship's judgment. Same.
Imran and Javed.
Lordships have quoted this.
Yes, Naveed.
Lords. Lords, see the allegations Lords have made Lords. It is investigation stage. Not let him face Lords the investigation Lords.
Not in
Being
this.
an MLM Lords.
ಬೇರೆ ಯಾವ್ದ್ರಲ್ಲಾದ್ರೂ.
It is a license for him to do all this Lords again, once again.
If I take your submission to its true sense, somebody will have to be pulled down every day.
Lords, being an MLM
Every
Lords,
ಅಲ್ಲ
Lords,
ಇನ್ನೂ
being an
ಇದೆ
MLA.
ಅಲ್ಲ
Lords,
definitely being a political representative,
Lord, we have
if this statement is taken to its true sense, somebody will have to be pulled down every day. ಗೊತ್ತಾಯ್ತಾ ಹೇಳ್ಬೇಕು. Yes, sir.
But there are so many allegations against him, Lords, on the.
ಏನೇನು ಹೇಳಿದ್ದಾರೆ ಸರ್? ನೀವು ಸುಮ್ಮನೆ ಇರೋದೇ ಇಲ್ವಾ?
That's only one line. There is nothing like so many allegations.
Let him withdraw that allegation, Lord. Let him give an unconditional apology, my Lord.
For what?
Lord, for making all this allegation, Lord. Kindly see him, Lord. Lord, I'm not supposed to read, Lord.
ಬಾಲ್ ಸಾಹೇಬ್ ಠಾಕ್ರೆ ತಾನೆ?
Can he blame, Lord? Let him give an unconditional apology, my Lord.
ಈ ಡೆಫಮೇಶನ್ ಅಲ್ಲ ಕೊಡಿಸ್ಬಿಡ್ತಾ ಇದ್ದೆ. ಡೆಫಮೇಶನ್ ಆಗಿದೆ.
Lord, even then,
ಡೆಫಮೇಶನ್ ಆಗಿದ್ರೆ ಡೆಫಿನೆಟ್ಲಿ ಕೊಡಿಸ್ಬಿಡ್ತಾ ಇದ್ದೆ.
Lord, even then,
You
Lord.
are not saying it is defamatory, but you are saying it generates communal disharmony. Then ಅದಕ್ಕೆ affidavit. Defamation will definitely I will tell him to do that. In whatever case of defamation comes, I will tell him to do that.
But it again defends, Lord, the community as well, my Lord.
Same what Apex Court wrote in Javed Hajam and Imran.
Let's put some conditions, Lord, that not to, Lord, he should.
That in every case I have put, that you will not repeat such things.
Please, Lord.
ಎಲ್ಲ ಹಾಕಿದ್ದೀನಿ ಎಲ್ಲದರಲ್ಲೂ.
This is not something, my lords, which they want to highlight something. In fact, the coordinate bench has quashed where pamphlets were distributed in the temple. So, my lord, if everything is to be taken seriously.
That is what I am telling. ಆ ತರ ಸೀರಿಯಸ್ ಆಗಿ ತಗೊಂಡ್ಬಿಟ್ರೆ.
Just is something else.
Yes, 15 and 17 ಅಲ್ಲ?
17 only. 17.1 is different.
17.1 ಏನ್ different?
By wrongly connect ಆಗಿದೆ.
I'm in 17, but appearing for.
Same offense ಇದ್ರಲ್ಲೂ?
No, same statement, 2 FIRs.
Same offense.
ಹೌದು.
The petitioner is before the court. ಇದೆರಡು ಮೇಡಮ್ ಕವರ್ಡ್ ಅಂತ ಹೇಳಿ ಇದು ಮಾಡಿ.
17, I may be permitted to make submissions.
17 ನವಿದಿಲ್ವಾ?
No, Lord.
All
I am
right.
in
Yes.
17.
So serial number 15 is disposed.
Yes.
Yes. 16 and.
Bill number 16.
Section.
Election offense, huh?
Yes, 188, my lords of the IPC.
Covered. Kodi. The petitioner is before the court seeking the following prayer. The learned counsel Shatabdi Shivarna, appearing for the petitioner, would submit that the issue in the list stands completely answered by the judgment rendered by Umesh Shettina, by the coordinate bench in Sons. The learned counsel Sharad Dodwad, appearing for the second respondent, would not dispute the position of law as is laid down by the coordinate bench. Allowed. 17 bani madam.
Same as 15.
Allowed.
Lordship. Bill number 17, your Lordship. The statement has been made in Ram Navami. Ian OOP. Additional speaker.
But serial number 15 ಅಲ್ಲಿ same complaint, two different FIRs.
Same complainant.
Same complaint, two different FIRs by two different persons.
Same complaint.
17, your lordships, in a Ramnavami procession, we said that Prophet Muhammad was born
ಅಲ್ಲ
in the
same complaint ತಾನೆ.
Thackeray, your lordship.
ಇಲ್ಲ ಇದು same complaint.
Same complaint, two different persons.
ಅದು ಕಾಸ್ಟ್ ಮಾಡಿದ್ನ.
Prophet Muhammad born in the house of Balasaheb Thackeray, your lordship. That is the statement that has
That's
been
not-
made in a Ramnavami.
ಅದಕ್ಕೆ communal disharmony ಏನಾಗಲ್ಲ. If you see then in Imran and other cases, what was said?
Your lordship,
ಇದೆ
Imran
ಈ ತರ
Pratap will
ಈ
not
ತರ
be-
crimes register ಮಾಡಿ disharmony ಆಗುತ್ತೆ.
Lordships, Imran Pratap Gidi will not be applicable in the present case, your lordship, because in that case, the court has only emphasized the need for a cautious approach in political sensitive matters, your lordship. However, in Lalita Kumari, your lordship, when the allegations prima facie discloses a clear commission of cognizable offences, and in this case, there is a promotion of enmity between communities, your lordship, circulation of false statements and disharmony, your lordship. I may be permitted to pass on one judgment.
Oh, please, madam, ಕೊಡಿ.
Your lordships, in this case, your lordship, the statement has been made by a journalist, your lordship, against Pir Hazrat Moinuddin Chisti. He has stated, Akrantak Chisti aya, Lutera Chisti aya, uske baad dharam badle. So this was a comment that has been made, your lordship, wherein the apex court has refused to quash the FIR,
I will consider all that.
Your lordship, page number 86, para number 120 and 121, if I may be permitted to read only two paragraphs.
Don't read, I'll go through it.
Para number 120 and 121.
By reading that, don't generate disharmony here. Yes, list 28 will dictate on 28.
Lordship, similarly in serial number 18 also, your lordship has made.
ಅದು ಕರ್ದೇ ಇಲ್ಲ.
18 ನಿಮ್ದೇನಾ?
ಇಲ್ಲ 18 is different. Malad 17.1 is different.
17.1 dealing ಮಾಡಿ.
ಅದು is covered by your lordship's judgment.
ಅಲ್ಲ ಯಾರು ಬರ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್?
17.1.
ಅವರೇನಾ?
ಇಲ್ಲ ಅವರಲ್ಲ. Nobody has present.
17.1 dealing 28. Yes, entry ಮಾಡಿದ್ರೆ continue ಮಾಡಿ. Next.
18.
Lord, I'm appearing for the petitioner. The respondent who files a complaint after watching a YouTube video that I've made some certain comments on political personalities. The alleged offences is 352 and 353 too. And if the political personalities is aggrieved, they can file a defamation. And then the ingredients. You're third party, a political background person, he files a complaint.
Social worker.
My lord, complaint is at page number 12.
Your lordship, the statement may be looked into, your lordship. I will not read it in front.
Last paragraph, I have made certain comments on political personalities. And they say that it has provoked the breach and caused enmity in the society, my lord.
They will file it. Why do you worry, madam? If they want, they
No
will
ingredients
file.
of 352 or 353 is made out. And it is covered by Nallabalu and Imran Pratap Gidi, my lord.
Nallabalu yake?
Third party, after watching a YouTube video, has filed a complaint.
Anything else?
Lordship, prima facie, it discloses the commission of the offence, your lordship.
Thank you.
Lalita Kumari will be directly
Oh,
applicable. in
Lalita
this
Kumari
case.
is not a panacea to all problems.
Imran Pratap Gidi will not be applicable.
We will see, yes.
And this is covered by Malad's judgment in 13650 of 2024, my lord.
Yes.
The same apex court judgment may also be.
We will
considered.
rely on that, man. Lord, question.
Amish
Next.
Devgan, yeah.
Yes, Amish Devgan.
Grateful, much.
Acha.
Next.
19.
ನೈನ್ಟೀನ್ ಈ ಕಡೆ
Once in a while, ಈ ಕಡೆ ಬಂದ್ಬಿಟ್ಟು. Rarely we get that opportunity.
Oh, then former CM da.
Please.
ಏನು?
And CM also, both, my lords. It's covered by judgment, my lords, insofar as very same accused number 4, my lords, this court has quashed.
Yes. Anything else, sir?
So, my lord, it's not covered by judgment.
Why, sir?
With regard to accused number 4, the contention is that, my lord, he has merely tweeted and the Twitter documents were not marked, my lord. That is the contention. However, here, they are the accused number 1 to 4, my lord. They have published the defamatory article in a newspaper
Oh, ಇದು 499 500.
Your lordship's judgment in Sunil Kumar versus State of Karnataka, wherein your lordship held that it is these are all matter of trial, my lord.
Oh.
Your lordship may kindly see the newspaper published by them just 3 days prior to the election, my lord, wherein they have not even 1% of a truthfulness in the.
ಅಲ್ಲ ಅವ್ರು
They have
ಪಬ್ಲಿಷ್
published
ಮಾಡ್ತಾರೆ
that.
ಇವ್ರು ಪಬ್ಲಿಷ್
ಅಲ್ಲ,
ಮಾಡ್ತಾರೆ ಇಲ್ಲ
ಅವ್ರು-
ಎಲ್ಲ ಕೋರ್ಟಲ್ಲೇ
That is exactly what I am telling. ಇದು ಮಡ್ ಸ್ಲಿಂಗಿಂಗ್ ಇದೆಲ್ಲ ಬಿಟ್ಬಿಟ್ಟು if all of you work on policies and welfare of the people, ಏನೇನೋ ಆಗ್ಬಿಡ್ತಾರೆ.
This is not
ಇದು
much.
ಬಿಟ್ಬಿಟ್ಟು ಬರೀ ಇದೇನೆ.
Premeditated.
ಇವ್ರಿಗೆ ಹೇಳಿದ್ರು ಅವ್ರಿಗೆ ಹೇಳಿದ್ರು
Lordship,
196 353 ಬರೀ ಇದೆ.
Because of this, my lord, we
Because of
lost
what,
in
sir?
40 seats, my lord, because of false.
ಅಯ್ಯೋ, ಇದರಿಂದ
They
you
have
lost 40
designed-
seats.
Yes, my lord. Yes, my lord. In all newspapers, almost all newspapers, for continuously 5 days, they have published saying that.
But for this, you would have won 40 more seats.
Yes, yes, we would have won, my lord.
What?
Because of this advertisement, they have designed in such a way that
Designed,
people should think that it is a news article ಅಂತ ಬರೋ ತರ ಮಾಡಿದ್ದಾರೆ. Your lordship may kindly see the kindly see the paper articles, what and all they have stated.
What and all?
ಈ ಕಾರಣದಿಂದಾಗಿ ಜನರಲ್ಲಿ ಏನಾಯ್ತು ಅಂತ ಹೇಳಿದ್ರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕಂಪ್ಲೈನೆಂಟ್ ಪಾರ್ಟಿಗೆ ವೋಟ್ ಹಾಕ್ಬಾರ್ದು ಅಂತ ಬಂತು ಜನರ ಮನಸ್ಸಲ್ಲಿ. ಏನಂತ ಹೇಳಿದ್ರೆ
ಇದಿಲ್ಲ ಅಂದ್ರೆ ಜನರಲ್ ಮನಸ್ಸಲ್ಲಿ ಬರ್ತಾನೆ ಇರ್ಲಿಲ್ಲ.
ಇಲ್ಲ ಖಂಡಿತವಾಗಿ 10% ವೋಟ್ ಸ್ವಿಂಗ್ ಇದರಿಂದಾಗಿ
10% ವೋಟ್ ಸ್ವಿಂಗ್.
ಹೌದು ಸ್ವಿಂಗ್ ನಮಗೆ ಬರ್ಬೇಕಾಗಿರೋದು ಕಟ್ ಆಗಿದೆ ಈ ಅಡ್ವರ್ಟೈಸ್ಮೆಂಟ್ ಇಂದ. ಏನೇನು ಹೇಳಿದ್ದಾರೆ ಅಂತ 1% ಅದರಲ್ಲಿ ಸತ್ಯ ಇದೆ ಅಂತ ಅವ್ರು ತೋರಿಸ್ಲಿ.
ಏನ್ 40% ಹೇಳಿದಾರಾ?
40% ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಸಿಎಂ ಪೋಸ್ಟ್ ಗೆ 2500 ಅಂತ ಕ್ರೋರ್ಸ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಒಂದೊಂದು ಪೋಸ್ಟ್ ಗೆ 1 crore 5 crore ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಇದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅವರು ತೋರಿಸಿದ್ರೆ
ಅಲ್ಲ ಇದರಿಂದ
ಟ್ರಯಲ್ ಮೇಲೆ
ಅಲ್ಲ ಕರೆಕ್ಟ್. ಇದರಿಂದ 40 ಸೀಟ್ ಹೊಟ್ಟೋಯ್ತಾ?
ಹೌದು ಡೆಫಿನೆಟ್ಲಿ my lord. I have stated in my sworn statement and I have stated in my complaint also, my lord. Because my lord, what happened last day of during the election, my lord, I had no opportunity to explain to the public that these are all false statement ಅಂತ ಜನರು misguided ಆಗ್ಬಿಟ್ರು. That is the reason why, my lord.
ಅಲ್ಲಿವರೆಗೂ ಅಲಿಗೇಷನ್ ಬಂದೇ ಇರ್ಲಿಲ್ವಾ?
ಅಲ್ಲಿವರೆಗೆ ಇಲ್ಲ.
ಫಸ್ಟ್ ಟೈಮ್ ಮಾಡಿದ್ದ ಇದು?
Yes, ಅದು ಕೂಡ
ಅಲ್ಲ 40% ಫಸ್ಟ್ ಟೈಮ್ ಮಾಡಿದ್ದ?
ಅಲ್ಲ ನ್ಯೂಸ್ ಪೇಪರ್ ಅಲ್ಲಿ
ಅಲ್ಲ ಅದಾಯ್ತು. ಪೋಸ್ಟರ್ ಹಾಕಿದ್ರಲ್ಲ ಅದು
ಪೋಸ್ಟರ್ ಹಾಕಿದ್ದಕ್ಕೆ
ಅದೇನ್ ಪರವಾಗಿಲ್ಲ.
ಎಲೆಕ್ಷನ್ ಕಮಿಷನ್ ಹ್ಯಾಸ್ ಟೇಕನ್.
ಕರೆಕ್ಟ್ ಹೌದಾ? ಅವಾಗ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
ಇಲ್ಲ ಇಷ್ಟೊಂದು ಡೀಟೇಲ್ ಆಗಿ ಯಾವತ್ತು ಹಾಕಿರ್ಲಿಲ್ಲ. ನ್ಯೂಸ್ ಪೋಸ್ಟರ್ ಅಲ್ಲಿ ಹಾಕೋದು ಸ್ಪೀಚ್ ಮಾಡಿದಾಗ ಜನ ಅದನ್ನು ವೆರಿಫೈ ಮಾಡ್ತಾರೆ, ಸತ್ಯ ಇರಬಹುದು ಸುಳ್ಳು ಇರಬಹುದು ಅಂತ ವೆರಿಫೈ ಮಾಡ್ತಾರೆ. ನ್ಯೂಸ್ ಪೇಪರ್ ಅಲ್ಲಿ ಬಂದಿರೋದ್ರಿಂದ ಅದು ಹೆಂಗೆ ಕಾಣಿಸ್ತಾ ಇತ್ತು ಅಂದ್ರೆ ಅದು ನ್ಯೂಸ್ ಆರ್ಟಿಕಲ್ ನ್ಯೂಸ್ ರಿಪೋರ್ಟ್ ಅಂತ ಕಾಣಿಸೋ ತರ ಅವರು ಪಬ್ಲಿಷ್ ಮಾಡಿದ್ರು. ಆದ್ರಿಂದ ಜನರು ಸ್ವಲ್ಪ ಮಟ್ಟಿಗೆ ನಂಬಿದ್ರು. ನಮಗೆ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಸಮಯ ಇರ್ಲಿಲ್ಲ. That is the reason why, my lord. It's not ordinary. My lord, they are
covered by judgment like page 13, my lord.
They are lawmakers, my lord. Lawmakers. They know law. What is the impact of law? What has to be done? What not to be done? They are aware.
Who are lawmakers? Every one of you are lawmakers.
My lord.
Sometimes you are, sometimes they are.
That is true, my lord. But your lordship, impact of this defamatory article, my lord, it changed the government, my lord. That is it. Therefore, they should not repeat it again. It will be like permitting them ಇನ್ನೊಂದ್ಸಲ ಮಾಡಿ. ನೀವು ಲಾ ಕೇರ್ ಮಾಡಿಲ್ಲ ಅದ್ರ ಪರವಾಗಿಲ್ಲ, ಇನ್ನೊಂದ್ಸಲ ಅಡ್ವರ್ಟೈಸ್ಮೆಂಟ್ ಹಾಕಿದ್ದ. It is not covered by judgment of.
Not covered.
Not my lord. Your lord, it's covered by judgment. Your lordship judgment in Sunil Kumar versus State of Karnataka, my lord. Wherein your lordship detail, I may be permitted to produce. Lordship may.
ಅದು ಕೊಡಿ ಮೇಡಮ್.
ನಮ್ಮ ಆಫೀಸ್ ಲಕ್ಷ್ಮಿ kindly Sunil Kumar. Lordship may kindly see it.
ಓ ಇದು ನೀವೇ ಅಪಿಯರ್ ಆಗಿರೋದು?
ಹೌದು ನಾನು ಆ ಸೈಡ್ ಇದ್ದೆ.
ಆ ಸೈಡ್ ಇದೆ.
ನಾನು I was for accused by law. ಅದರಲ್ಲಿ Lordship may kindly see para number 18.
Is agreed by the judgment, my lord, not it was not caution.
ಇಲ್ಲ no ಅಲ್ಲ judgment president wherein your lordship clearly held that accused and it is not it's a matter of trial. The truthfulness and it is there as per their petition, my lord. Their defense is that it's a true fair comment. My lord, fair comment should be tested through trial, my lord. And their contention is that some people have stated something, it was published in the newspaper. My lord, to prove any newspaper contents, my lord, there are procedure to prove before the court during the trial. They have to summon the reporter from where he has got the genuineness of reporter's statement. Based on that, it should be conducted in a trial manner. Therefore, it's a matter of trial.
Yes. Yes, sir.
Mainly para 20 may be kindly seen, no? Page
Of what?
of the judgment, my lord. In fact, they have not preferred appeal. This has become final.
This has become final, correct.
Para 20, page 12, my lord. Page 12, my lord. The para 20, the complaint appears to indicate the state unit of so and so, and the complainant so and so has been waived. However, the complainant who has brought the legal grievance before the court is a national so and so. If that were to be so, the agreed person is so and so. Then the complaint ought to have been filed duly by authorized representative. However, the authorized representative so by the state unit so and so. Such authorized or present unit cannot be accepted so and so and so. Further, there is no ultimately, my lord, para 2021. Basically, the root of the matter that there was no authorization by the national party to file this petition. That is one main aspect. Then on the merits also, it has been dealt and quashed, insofar as specific allegations are concerned. Ultimately, it's a case of defamation. As Supreme Court has been keep saying, fight out in the battle on the ground rather than in the courts.
Between politics. Heard the Advocate General?
No, senior.
Heard the learned senior counsel, Kiran Shetty, along with so and Vinod Kumar.
May I submit one judgment?
Deserved,
Got a
yes.
judgment of this honorable court with regard to aggrieved person. As per 11 of IPC, aggrieved person means whoever means it includes even Karyakarta also. When a Karyakarta can also.
ಅದ್ರ ಬಗ್ಗೆ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರ ನೀವು? ಅಲ್ಲ, ಅದ್ರ ಬಗ್ಗೆ ಏನ್ ಹೇಳಿಲ್ಲ.
That is not an issue.
ಬೇರೆ ಕೇಸ್
Karyakarta is not filed by Karyakarta. We are not on that.
Regarding locus standi, the reported judgment, the political party is also person. Political party is also person. Association also can file a defamation case. With regard to that, my lord, I may be permitted to produce one judgment of the wherein, my lord, we are the petitioners. BJP was the petitioner. Even
Subramanian Swamy judgment.
BJP versus Rizwan Arshad ಅಂತ ತಗೊಳ್ಳಿ ಸರ್. ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡಿ, ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ ಅಲ್ಲ, ಅದರಲ್ಲಿ whoever
anyway that does not arise in
aggrieved person ಅಂತ ಹೇಳಿ.
Heard reserved, yes. ಸಂತೋಷ್, ಏನಿದೆ?
20.1, my lord, it's relating to defamation allegations against the petitioner. Page 29 may kindly be seen, my lord. The subject matter of the defamation, which they are saying that it is amounting to defamation insofar as the respondent is concerned.
Page 29.
But is the publication, my lord, page 29 of the petition, my lord.
Which page? 20.1 ಅಲ್ಲ?
Yes, my lord.
20.1 ಕೊಡಿ.
Please, please.
ಅದೇ ಕೊಟ್ಬಿಡಿ.
ಅದಲ್ಲ, ಅದವರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ, ಅದು ಮಾಡಿದ್ರು.
ಕೊಡಿ, ಏನಿದೆ?
20.1.
ಇಲ್ಲ, ದಿಸ್ ಇಸ್ ಡಿಫರೆಂಟ್. ದಿಸ್ ಇಸ್ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ. ಅವರು ಒಂದೇ ಪೇಪರ್ ಪಬ್ಲಿಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಇನ್ನೊಂದು ಪೇಪರ್ ಕೊಟ್ಟಿಲ್ಲ.
ಅದು ಕೊಡಿ
ಅಲ್ಲ, ಎಲ್ಲ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಸೇಮ್.
ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಸೇಮ್, ಬಟ್ ದಿಸ್ ಇಸ್
no, the contention is, my lord, I will explain, my lord.
ಅದು ಉದಯವಾಣಿ ಪೇಪರ್ದು. ಅವರು ಹೇಳ್ತಾ ಇರೋದು ವಿಜಯ ಕರ್ನಾಟಕ ಪೇಪರ್.
No, here, my lord, we have not stated anything about the name of the
ಅಲ್ಲ,
respondent.
ಇದೇನು ಕಾನೂನು ಹೋರಾಟದಲ್ಲಿ ಅದ?
ಅದಲ್ಲ.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಅದೇ ಕಾನೂನು ಹೋರಾಟದಲ್ಲಿ ಜಯ ನನ್ನದೇ ಸುಧಾಕರ್ ಅಂತ ಹೇಳುವಂತ ಕ್ಯಾಪ್ಷನ್ ಅಲ್ಲಿ ಅದರಲ್ಲಿ ಅವರ ಸೋಲ್ ಕಂಟೆನ್ಷನ್ ಇಸ್ ದಟ್ ದ ನೇಮ್ ಆಫ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಸ್ ನಾಟ್ ಮೆನ್ಷನ್ಡ್ ಅಂತ ಹೇಳಿ. ಬಟ್ ಇಟ್ ಈಸ್ ರಾಂಗ್. ಯಾಕಂತಂದ್ರೆ ಅವರು ಎರಡು ಪೇಪರ್ ಪಬ್ಲಿಷ್ ಆಗಿದೆ, ಅವರು ಒಂದು ಪೇಪರ್ ಅನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ, ವಿಜಯ ಕರ್ನಾಟಕ ಮಾತ್ರ. ಉದಯವಾಣಿ ಪೇಪರ್ ಇವಾಗ ನಾನು ಕೊಟ್ಟಿರುವಂತದ್ದು. ಉದಯವಾಣಿ ಪೇಪರ್ನಲ್ಲಿ ಈ ಕಾನೂನು ಹೋರಾಟದಲ್ಲಿ ಜಯ ನನ್ನದೇ ಸುಧಾಕರ್ ಅಂತ ಹೇಳುವಂತ ಪೋರ್ಷನ್ ಅಲ್ಲಿ ಅಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ 1, 2, 3ನೇ ಇದರಲ್ಲಿ ಲೈನ್ ನಲ್ಲಿ ಶಾಶ್ವತ ನೀರಾವರಿ ಹೋರಾಟ ಸಮಿತಿ ಅಧ್ಯಕ್ಷ ಆರ್ ಆಂಜನೇಯ ರೆಡ್ಡಿ ವಿರುದ್ಧ ಸುಧಾಕರ್ ವಾಗ್ದಾಳಿ ನಡೆಸಿದರು. ವೆರಿ ಕ್ಲಿಯರ್ಲಿ ದ ನೇಮ್.
I have not uttered his name, my lord.
So,
It is the newspaper.
kindly see the allegations also, my lord.
ಏನ್ allegations?
Their allegation also, kindly see the allegations, which are very serious in nature. ಅವರು ಹೇಳ್ತಾ ಇರೋದು, in this case, sworn statement of the witnesses also are recorded. Not only the petitioner, the respondent, but also the witnesses who have appeared before the court also is recorded. The lordship kindly see, ಇದರಲ್ಲಿ ಇದೇ petition ಅಲ್ಲಿ page number 38, he is an eyewitness to this. This is marked as an, may I read this portion, my lord? ಇದರಲ್ಲಿ ಹೇಳ್ತಾರೆ, ನಾನು ಹಾಗೂ ಫಿರ್ಯಾದಿದಾರ ಮತ್ತು ಇತರರು ಶಾಶ್ವತ ನೀರಾವರಿ ಹೋರಾಟ ಸಮಿತಿಯ ಸದಸ್ಯರಾಗಿರ್ತೇವೆ. ನಾನು ಮತ್ತು ಫಿರ್ಯಾದಿದಾರ ಸುಮಾರು 20 ವರ್ಷಗಳಿಂದ ಸ್ನೇಹಿತರಾಗಿರ್ತೇವೆ. ನಾನು ನನ್ನ ಸ್ವಂತ ಕೆಲಸದ ಮೇಲೆ ದಿಬ್ಬೂರು ಗ್ರಾಮಕ್ಕೆ ಆಗಾಗ ಹೋಗುತ್ತಿದ್ದೆ. ದಿನಾಂಕ 27/6/2019 ಮರಳುಕುಂಟೆ ಗ್ರಾಮದಲ್ಲಿ ಶಾಸಕರಾದ ಸುಧಾಕರ್ ಅವರ ಹುಟ್ಟಿದ ಹಬ್ಬದ ಶಾಲಾ ಮೈದಾನದಲ್ಲಿ ಆಚರಣೆ ಆಗಿತ್ತು. ನಾನು ಆ ದಿನ ಅಲ್ಲಿ ರಸ್ತೆಯಲ್ಲಿ ನಡೆದುಕೊಂಡು ಹೋಗುತ್ತಿದ್ದು ಈ ಕಾರ್ಯಕ್ರಮವನ್ನು ವೀಕ್ಷಣೆ ಮಾಡುತ್ತಾ ನಿಂತುಕೊಂಡಿದ್ದೆ. ಆಗ ಮೇಲೆ ಹೇಳಿದ ಶಾಸಕರು ಫಿರ್ಯಾದಿದಾರನ ಬಗ್ಗೆ ಅವಹೇಳನಕಾರಿ ಮಾತುಗಳನ್ನು ಭಾಷಣದಲ್ಲಿ ಹೇಳುತ್ತಿದ್ದರು. ರೈತರಿಗೆ, ದಿಸ್ ಇಸ್ ಅವಹೇಳನಕಾರಿ ಭಾಷಣ, ರೈತರಿಗೆ ಕಳ್ಳಬಟ್ಟಿ ಕುಡಿಸಿ ಜೈಲಿಗೆ ಹೋಗಿರ್ತಾನೆ. ಇವನು ನೀರಾವರಿ ಯೋಜನೆಯ ಅಭಿವೃದ್ಧಿಗೆ ವಿನಾಕಾರಣ ಅಡ್ಡಿ ಉಂಟು ಮಾಡುತ್ತಿದ್ದಾನೆ. ಈ ಭಾಗದ ರೈತರ ವಿರೋಧಿಯಾಗಿದ್ದಾನೆ. ಆತ ಎಷ್ಟು ದಿನ ಜೈಲಿನಲ್ಲಿದ್ದ ದಾಖಲೆಗಳನ್ನು ತಂದುಕೊಡ್ತೇನೆ ಎಂದು ಈ ರೀತಿಯೆಲ್ಲ ಫಿರ್ಯಾದಿದಾರನ ಬಗ್ಗೆ ಅವಹೇಳನಕಾರಿ ಮಾತುಗಳನ್ನು ಹೇಳುತ್ತಿದ್ದರು. ಈ ಬಗ್ಗೆ ನಾನು ಇತರ ಸದಸ್ಯರಾದ, ದಟ್ ಈಸ್ ನೀರಾವರಿ ಸಮಿತಿಯ ಸದಸ್ಯರು ಆದ ಹರೀಶ್, ದೇವರಾಜ್ ಮತ್ತು ಸುಷ್ಮಾ ಮತ್ತು ಇತರರಿಗೆ ದೂರವಾಣಿ ಕರೆ ಮಾಡಿ ತಿಳಿಸಿರುತ್ತೇನೆ. ನಾನು ಅವರಲ್ಲಿ ಆಂಜನೇಯ ರೆಡ್ಡಿ ಅವರ ಜೊತೆ ಸೇರಿ ಈ ಎಲ್ಲಾ ತಪ್ಪುಗಳನ್ನು ಮಾಡುತ್ತಿದ್ದೇವೆ, ಆತನ ಬಗ್ಗೆ ಸುಧಾಕರ್ ಅವರು ಈ ರೀತಿ ಹೇಳುತ್ತಿದ್ದಾರೆ ಎಂದು ಹೇಳಿರ್ತೇನೆ. ದಿಸ್ ಇಸ್ ಅ ಸ್ಟೇಟ್ಮೆಂಟ್ stated by the eyewitness who was present, and he heard these words and he has stated it before the trial court. Then, my lord, yes, and the same has been published on the very next day. In the same version is published in the newspaper in Udayavani and in Vijaya Karnataka also. Same statement, my lord.
ಅಲ್ಲ, ಅವ್ರ ಹೆಸರು ಹೇಳಿಲ್ಲ, ನೀವೇ ಹೇಳ್ಕೊಂಡು ಎಲ್ಲ ಹೇಳ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದೀರಾ.
ಇಲ್ಲ,
ಸುಮ್ಮನೆ
ಪೇಪರ್ ಇರೋದು ಹೇಳಿದ್ದಾರೆ, ನಾವು ಹೇಳಿದ್ದಲ್ಲ. ಪೇಪರ್
ಮೇಲೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಎಲ್ಲ ಮಾಡಿ.
ಉದಯವಾಣಿ ಪೇಪರ್ ನಲ್ಲಿ ಅವರ ಆಂಜನೇಯ ರೆಡ್ಡಿ ಅವರ ವಿರುದ್ಧ ಅಂತ ಹೇಳುವಂತ
ಪೇಪರ್ನವ್ರು ಹೇಳಿದ್ದಾರೆ,
ಹೇಳಿದ್ದಾರೆ.
ಇವ್ರು ಹೇಳಿ
ಅಲ್ಲ, ಹೌದು, ಬಟ್ ಈ ಐ ವಿಟ್ನೆಸ್ ಆಂಜನೇಯ ರೆಡ್ಡಿ ಬಗ್ಗೆನೇ ಹೇಳಿದ್ದಾರೆ ಅಂತ ಹೇಳುವಂತದನ್ನು ಹೇಳಿದ್ದಾರೆ. ಅದೇ ರೀತಿ ಇನ್ನು ಇದ್ದಾರೆ ಇದರಲ್ಲಿ. ಪ್ಲೀಸ್
ನೇಮ್ಸ್.
ಅದೇ ಆಂಜನೇಯ ರೆಡ್ಡಿ ಬಗ್ಗೆ ಹೇಳಿದ್ದಾರೆ ಅಂತಲೇ ಇವರು ಹೇಳಿದ್ದಾರೆ. ಪೇಪರ್ಲ್ಲೂ ಹೇಳಿದ್ದಾರೆ, ಸೋನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಐ ವಿಟ್ನೆಸ್ ಅದನ್ನು ಕೇಳಿಕೊಂಡು ಹೇಳಿದ್ದಾರೆ.
ರಿಪೋರ್ಟರ್ ಇಸ್ ಮೇಕಿಂಗ್ ದಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್, my lord. It's not they are putting that name in my mouth by newspaper.
ಅಲ್ಲ, ನೀವೇ ಹೇಳ್ಕೊಂಡು.
ಅಲ್ಲ, ನ್ಯೂಸ್ ಪೇಪರ್ ನವರು ವಿತೌಟ್ ಹಿಯರಿಂಗ್ ದಿ ಅಕ್ಯೂಸ್ಡ್, my lord, ಅವರು ಹೇಳಲಿಕ್ಕಿಲ್ಲ. ಪೇಪರ್ನವರು ಇಮ್ಯಾಜಿನೇಷನ್ ಮಾಡಿ ಹೇಳಲಿಕ್ಕಿಲ್ಲ.
ಆ ತರ ಸಿ ಪಬ್ಲಿಕೇಶನ್ ಇಸ್ ವಾಟ್ ಇಸ್ ಪಬ್ಲಿಷ್ಡ್ ಬೈ ದಿ ನ್ಯೂಸ್ ಪೇಪರ್.
ಎಸ್,
but what is told by him should be there ಅಲ್ಲ.
ಸ್ಪೀಚ್
ಅಲ್ತಾನೆ ಆಗಿರೋದು.
ಯಾವುದು
ಸ್ಪೀಚ್ ಅಲ್ತಾನೆ?
ಸ್ಪೀಚ್
ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಅಲ್ಲಿ,
ಸ್ಪೀಚ್ ಅನ್ನ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಈ ಪೇಪರ್ ನಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಅವರು.
ಪೇಪರ್ ಅಲ್ಲಿ ಬಿಟ್ಬಿಡಿ, ಸ್ಪೀಚ್ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಎಲ್ಲಿ?
Produced before the trial court, my lord. They are not
your
produced.
case goes.
There is no transcript.
ನ್ಯೂಸ್ ಪೇಪರ್ ಅಲ್ಲಿ ಬಂದಿದ್ದು ಅವ್ರು ಹೇಳಿದ್ದಲ್ಲ. ಅವ್ರ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಇದ್ರೆ ಸ್ಪೀಚ್ ಅಲ್ಲಿ ಇಲ್ಲ. he has written some article or he has published something, tell me.
He has not published anything, but he has
stated. What a statement is made by a particular person, the newspaper would interpret in its own way and write it. Does it become defamatory? Our speech transcript kodi. If this transcript show is what is contained in this, we'll dismiss it straight away.
They have not produced it before the trial. One more important thing, my lord. They are referring to a
kindly see my
friend
complaint. My complaint.
Nim complaint irbodu sir. Your complaint is on the publication. Where is the transcript? Where is the transcript of the speech to hold it defamatory? Because it is personal.
My lord, it's per se defamatory, my lord.
There are where is the transcript to show it? I am saying personal, not per se. Give me the transcript, I will hold it defamatory if the same thing is there.
My lord, whatever
that is the basic thing a complainant should do while registering a complaint.
My lord, I have stated it in my complaint.
ಸ್ಟೇಟಿಂಗ್ ಆಗಲ್ಲ ಸರ್.
In my complaint.
ಸ್ಟೇಟಿಂಗ್ ಆಗೋದೇ ಇಲ್ಲ. ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಕೊಡಿ, ಹೌದಾ ಇಲ್ವಾ ಹೇಳ್ತಾರೋ.
ಈ ಪೇಪರ್ ನಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, ನೇರವಾಗಿ
ಪೇಪರ್ ಹೇಳ್ತಾರೆ ಸರ್.
ಯಾಕೆಂತಂದ್ರೆ ಇದರಲ್ಲಿ
ಪೇಪರ್ ಹೇಳ್ತಾರೆ. ಆರ್ ಯು ಹಾಲಿಂಗ್ ದಿ ನ್ಯೂಸ್ ಪೇಪರ್ ಫಾರ್ ಡೆಫಮೇಶನ್ ಆರ್ ಹಿಮ್?
both of them.
ನ್ಯೂಸ್ ಪೇಪರ್ ನೀವಾ?
ಹೌದು, ಅವರು ಇದ್ದಾರೆ ನ್ಯೂಸ್ ಪೇಪರ್.
ಏನ್ ಹಾಕಿದ್ರಿ ನೀವು? ಅವ್ರು ಹೇಳಿದ್ ಹಾಕಿದ್ದೀರಾ? ಸ್ಪೀಚ್ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ನೀವೇನ್ ಹಾಕಿಲ್ಲ.
My lord, in the my lord, kindly see what I have submitted right now. My lord, exhibit C1A ಅಲ್ಲಿ ಆ ಪೇಪರ್ ನಲ್ಲೇ ಇದೆ ಕ್ಲಿಯರ್ ಆಗಿ, ನೀರಾವರಿ ಯೋಜನೆಗಳಿಗೆ ವಿರೋಧ, ಒಂದು ಪಕ್ಷದಲ್ಲಿ ಗುರುತಿಸಿಕೊಂಡು ಹುಸಿ ನೀರಾವರಿ ಹೋರಾಟ.
ನಿಮ್ಮ ಮೇಲೆ ನೀವೇ ಹಾಕೊಂಡಿದ್ದೀರಾ?
ನಮ್ಮ ಮೇಲೆ ನಾವು
ಮತ್ತೆ ಅವ್ರೇನ್ ನಿಮ್ಮ ಹೆಸರು ಹೇಳಿಲ್ಲ, ಯಾರು ನಿಮ್ಮ ಹೆಸರು ಹೇಳಿಲ್ಲ.
ಇದು ಅವರು ಹೇಳಿದ್ದನ್ನ ನ್ಯೂಸ್ ಪೇಪರ್ ನವರು ಪಬ್ಲಿಷ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು ಸರ್, ನಿಮ್ಮ ಹೆಸರು ಎಲ್ಲುಂಟಲ್ಲಿ?
ನ್ಯೂಸ್ ಅಲ್ಲಿ ಇದೆ, ಇದರಲ್ಲಿ ಇದೆ, ಈ ನಾನು ಕೊಟ್ಟಂತ ಪೇಪರ್ ಅಲ್ಲಿ ಇದೆ.
ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಕೊಡಿ, ಐ ವಿಲ್ ಹೋಲ್ಡ್ ದೆಮ್ ರೆಸ್ಪಾನ್ಸಿಬಲ್.
ಕೈಂಡ್ಲಿ ಹ್ಯಾವ್ ಇಟ್ ಆನ್ another day.
ರೆಡಿ ಮಾಡ್ಕೊಂಡ್ ಬರ್ತೀರಾ? ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ದೇ ಇರೋ, ಸೋನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹೇಳ್ದೇ ಇರೋ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಈಗ ಕೊಡಕ್ಕಾಗತ್ತಾ?
It is not permissible.
ಈಗ ಏನಿದ್ರು ಬರ್ಕೊಂಡ್ ಬಂದ್ರೆ ಸ್ಕ್ರಿಪ್ಟ್ ಆಗುತ್ತೆ, ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಆಗಲ್ಲ.
ಇದು ಡೈರೆಕ್ಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ ಇಲ್ಲಿ. ದಿಸ್ ಇಸ್ ನಾಟ್ ಜಸ್ಟ್ ಹೌದು.
That's all, my lord. What I'm saying.
ಜಡ್ಮೆಂಟ್ಸ್ ಕೊಡಿ, ಒಂದು ಕೊಡಿ, ಒಂದು ಕೊಡಿ.
Specific allegation should be there, but vague allegations will not hold good, my lord. Para 66, my lord, the first judgment, my lord. Para 66.
Paragraphs ಹಾಕಿದ್ದೀರಾ?
Sakiri.
Yes.
That's all.
It will dictate on 29th.
Please.
ನಿಮ್ದು ಕೊಡಿ friends.
Please.
Isaac. Yes.
Please.
Grateful.
29th dictating. Yes.
Please.
Next.
21.
Here for petitioner's counsel.
ಏನು?
Leader of
defamation ಆ?
ಇಲ್ಲ.
Because in this case, no, sir, go to the papers, my lord, sir, make my
353
submissions.
clause 2,
Will be taken up on
leader of
next date.
opposition made, my lord, comment on the policy of the government and tweeted. For
ಪಾಲಿಸಿ ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ, ಏನು ಇಲ್ಲ. There is no ingredients of 353.
My lord, sir,
And the complainant,
15 of the
even after,
complaint,
my lord, opportunity did not appear. There is an order of this honorable court, my lord, on 17/7. Last opportunity. Then your lordship said one more opportunity. Even after one more opportunity, they are.
I'll go to the
ಕಂಪ್ಲೇಂಟ್
papers.
ಬರಲ್ಲ ಬಿಡಿ.
ನೋಡಿ ಹೇಳ್ತೀನಿ next week.
ಅಲ್ಲ,
ಏನ್
ಇದು
ನೋಡಿ
ಸುಮಾರು
ಹೇಳೋದು?
ಸಾರಿ ನೋಡಿ ಹೇಳಿ ಆಯ್ತು. ಇದರಲ್ಲಿ ಹೇಳಲಿಕ್ಕೆ ಇನ್ನೇನಿಲ್ಲ.
ಇಲ್ಲ,
Kindly see the
ಹೇಳಿದ್ದಾರೆ.
complaint, my lord, at page 15. Nothing is there. It's
There was a-
unnecessary, my lord.
Yes sir.
My lord, sir, specific words, my lord, here.
ಏನು ಇಲ್ಲ.
ವಾಲ್ಮೀಕಿ ಸಮಾಜದವರು ಕುರುಬ ಸಮಾಜದ ಮೇಲೆ ದಂಗೆ ಏಳಬೇಕು, ಇಂದು ಪ್ರಚೋದನೆ ಮಾಡುವುದಲ್ಲದೆ ಕೋಮುಗಲಭೆ ಆಗಬೇಕು ಎಂದು ಹೇಳಿರ್ತಾರೆ.
ಸ್ಪೀಡ್ ಆಗಿ ಓದಿದ್ರು, ಪಾಸ್ ಕೊಟ್ಟು ಓದಿದ್ರು, ಹೇಗ್ ಓದಿದ್ರು, there is no ingredient.
Yes sir. Allowed cost. Great. But ಅರ್ಜೆಂಟ್ ಮಾಡ್ಬೇಡಿ. ಇಲ್ಲ ಅರ್ಜೆನ್ಸಿ ಏನಿಲ್ಲ ತಾನೆ?
ಇಲ್ಲ ಇಲ್ಲ.
ಆರ್ಡರ್ಗೆ
No. Keeping it pending will be a burden, that's.
ಮುಗಿಸಿದೀವಿ, ಬಟ್ ಆಮೇಲೆ ಅರ್ಜೆಂಟ್ ಕಾಪಿಗೆ ಅಂತ ಬರ್ಬೇಡಿ.
No urgency.
ಎಸ್, ಸುಯೋಗು ನೀವಲ್ಲ, 3 ವಾರ ಈ ಕಡೆ ಬರ್ಬೇಡಿ. ಎಸ್.
22.
I was requesting short accommodation, my lords. Arguing council is out of town, my lords.
ಏನ್ ಡೆಫಮೇಶನ್? ಸೇಮ್ ಅದೇನಾ?
Yes.
28, finally, list the matter on 28, the request of the council appearing for the petitioner as a last chance. It is made clear no further adjournment to be granted in the matter.
Good.
Yes, next. 23.
These arised out of, my lord, the protest, my lord.
ಏನ್ ಪ್ರೊಟೆಸ್ಟ್? ಅದೇ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ನಲ್ಲ ಅದೇನಾ?
ಅಲ್ಲ, ಇದಲ್ಲ.
ಅಲ್ಲ, ವಾಪಸ್ ಕಳ್ಸದ್ನಲ್ಲ ಅದು?
ಅಲ್ಲ, ಇದಲ್ಲ. My lord, only the offense, there is a bar under section 195, my lord, this is the offense already is 188.
ಎಲ್ಲಿ SPP ಬರ್ತಾರಾ?
Fairly covered, my lord. My
28.
learned friend only appeared in that
ಯಾರು?
matter, lordship quashed the matter.
ಕೊಡಿ.
ಅಲ್ಲ, ಇದು coordinate bench.
ಮತ್ತೆ
There is one more, my lord.
KP Act ಇದು 103 ಇದಾ?
ಹೌದು, ಇದರಲ್ಲಿ there is a bar, my lord, to take cognizance.
ಆಯ್ತು, ಬಟ್ 103 ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡ್ತಾ
Private complaint can be filed.
No. 188
188 offense. Squarely covered, my lord.
188 ಉಮೇಶ್ ಶೆಟ್ಟಿನ ಇದೆಯಲ್ಲ?
ಉಮೇಶ್ ಶೆಟ್ಟಿ, ದೇವೇಂದ್ರ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ವಿ ಜಡ್ಜ್ಮೆಂಟ್.
28 ನೋಡು. List the matter on 28th as the last chance at the request of the council appearing for the respondent. In the event no submissions are made, orders will be passed on hearing the senior counsel of the petitioner. Interim order subsisting will continue to the next date. Yes.
24.
What's see?
Iದೇನು?
Former Chief Minister and petitioner, Lord, they were, while campaigning for the by-elections, both of them were attributed with some statement. There was a controversy regarding this Waqf properties note at that point of.
Correct.
Against former Chief Minister, this honorable court quashed it.
Kudi ಯಾವ್ದು?
Next, page 68.
Page
60.
68.
Please.
Same offense? ಅದು co-accused?
ಹೌದು, both of them were traveling in the same van. What the-
Your Lordship may kindly see page 23 of the complaint.
ಇದು ಫೈನಲ್ ಆಗಿದೆಯಾ? Page 68. ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
ಅದರ 11%.
It's a detailed order passed. Anything else, sir?
Waqf properties.
ಇದು ಅದನ್ನೇ ಸೇಮ್ ವರ್ಕ್ ಪ್ರಾಪರ್ಟಿ. Heard the learned senior counsel Prabhuling Nawadgi appearing for the petitioner. The petitioner is before this court seeking the following prayer. The co-accused, the former chief minister, was before this court in criminal petition 12164 of 2024. The coordinate bench of this court, the co-accused, has quashed the proceedings by the following order, page 70 to 106. In the light of the petitioner being the co-accused and also together while the alleged statement was made, is entitled to the same benefit that the petitioner in the said criminal petition has got. Allowed, quashed.
25.
88. Not so. Private complaint is filed without any allegations. Not your Lordship's judgment, my lord.
ಇಲ್ಲ ಯಾರು ಕಂಪ್ಲೇನೆಂಟ್ ಯಾರು?
Complaint serve ಆಗಿದೆ.
Serve ಆಗಿಲ್ಲ?
No, the state has represented both.
ಅಸಿಸ್ಟೆಂಟ್ ಇಂಜಿನಿಯರ್ 188
ಹೌದು.
ಕೊಡಿ.
Lordships.
ಯಾರು ಕಂಪ್ಲೇನೆಂಟ್?
Complaint is
ಅಸಿಸ್ಟೆಂಟ್ ಇಂಜಿನಿಯರ್. He is not the officer.
allegations at page 22.
20?
In page 22, my lord, allegations. Beyond the election hours.
The petitioner is before the court calling in question proceedings in CC 4202 of 2023 registered for offences punishable under zones. Heard zones. Facts adumbrated are as follows. The petitioner is said to have campaigned for the elections on 29/4/2023 at several places. This respondent alleging that the campaign has gone on beyond hours, beyond the prescribed hours of the election commission, seeks to register a private complaint under section 123 for offence punishable under section 123(2) of the Representation of Peoples Act 1951 and 188 of the IPC. Therefore, it is an amalgam of 188 and 123(2) of the said act. The learned counsel for the petitioner submits that the respondent was not the authority who could have registered the private complaint against the petitioner. It is the person who had promulgated prohibitive orders under section 188 could be the only person who could do it. He would seek to place reliance upon the judgment of this court in criminal petition 12996 of 2023, disposed on 22nd August 2024. This court has held as follows.
Para 7.
Para 7 matra, yes. Para 7 haki. Therefore, it is necessary in the light of the issue the legality standing answered, whether it would become applicable to the facts obtaining in the case at hand is necessary to be noticed. The complaint, as observed herein above, is the assistant engineer working in a particular ward in the BBMP. The rally continued beyond the prescribed.
Permission ಇಲ್ಲ ಅಂತ.
The rally was conducted without permission from the hands of the competent authority. Therefore, it was the competent authority alone that ought to have a complaint and not the respondent. The issue standing completely on the admitted fact that the respondent is not the competent authority and complaint is not registered by anybody else. The petition deserves to succeed as it stands answered by the aforesaid judgment. Allowed cost. ನೆಕ್ಸ್ಟ್ ಎಲೆಕ್ಷನ್ ಇಟ್ಕೊಳ್ಳಿ ಅಲ್ಲ, ಒಂದ್ ಎಲೆಕ್ಷನ್ ನೆಕ್ಸ್ಟ್ ಎಲೆಕ್ಷನ್ ಅಲ್ಲಿ ಮುಗಿದು ಬಿಡ್ಬೇಕು, ಆಮೇಲೆ ಹೊಸದಾಗ ಆಗತ್ತಲ್ಲ. Yes, Dheeraj.
Page 66 is the allegation.
Respond number 2, my lord. Senior is not well, my lord. Kindly please short.
Purchaser of the property.
It's entry model.
28th, finally, at the request of the council appearing for the respondent.
Great.
Intermod continues. Next.
27.
Appear for the petitioner, my lords.
For the respondent.
Suit is filed by the complainant, my lords, for specific performance of the agreement. During the pendency of the suit, my lords, a private complaint is filed, saying that I have received the advance amount and I have not repaid it, and I have not executed this contract.
Some submissions. 6922 is the agreement with me for 1,53,60,000. For 3 months time was there. Well, within 2 months, he has sold it for lesser value of rupees 1,10,00,000.
Oh, he has sold it before that, is it?
Before that.
Yes, sir.
Well, within the
My lords, may kindly see the plaint.
For a lesser value.
Lesser value. Agreement with me is for 1 crore.
ದುಡ್ಡು ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರಿ?
ನಾನು 20 ಲಕ್ಷ ಅಡ್ವಾನ್ಸ್ ಕೊಟ್ಟಿದ್ದೆ. 1,53,00,000. 3 months plus 1 month grace period was there to obtain the sale deed. Within that is on 69/2022 is the agreement. They sold it on 21/11/2022 itself.
ದುಡ್ಡು ವಾಪಸ್ ಕೊಟ್ಟಿಲ್ವಾ?
ದುಡ್ಡು ವಾಪಸ್ ಕೊಟ್ಟಿಲ್ಲ. We have filed the suit for specific performance and that is pending consideration.
ದುಡ್ಡು ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ.
Please.
We are ready to purchase the property also.
Yo, he's already sold it, sir. ಇನ್ಯಾರ್ದು ಯಾಕೆ?
No, I had executed a general power of attorney in favor of my
GPA. He has sold
holder
it.
has sold it
To him.
Not to him.
To the third party.
holder has executed.
You stand.
No, I am ready to pay the amount.
Pay the amount with interest, whatever.
Please.
Yes, ಅಷ್ಟೇ. ಈಗ ಇನ್ನೊಂದು ಯಾರು ಕೊಟ್ಟಾಗ ಹೋಗಿದೆ.
ಅಲ್ಲ ಕೊಟ್ಟಾಗ ಹೋಗಿದೆ. My submission is that my kindly receive. It is well within the period they have sold it.
We may hold it. That's a different thing. You will not get the property. A sale deed is already executed. Sale deed has to be annulled. You're already there.
Yes, sir. For that, the suit is pending consideration.
Correct. You totally without prejudice to your rights.
One submission ಇದ್ರಲ್ಲಿ. They are not even contesting the suit also. They have left everything on the purchaser. They are not even contesting.
No,
they
whatever.
are not taken any
Without prejudice to your rights in the specific performance, you take this money. ಅಲ್ಲಾದ್ರೆ ಆಮೇಲೆ ನೋಡ್ಕೊಳ್ಳೋಣ.
I'll just contact.
Secure instruction.
Secure instruction.
That's the solution for this. ಬೇರೆ ಏನು? ಯಾಕಂದ್ರೆ ಇನ್ನೊಬ್ರಿಗೆ ಸೇಲ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ.
I'll secure instruction.
Yes. List the matter on 28th. You also secure instructions and ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ.
Interim order to be.
Interim order will continue. Yes, next.
28.
And for the petitioner, the petitioner and others not as sitting the hunger strike, my lord. The one of complaint is the not one of the fan of the ex-MLA. As filed a complaint.
You are?
Now MLA.
ಏನ್ ಹೇಳಿ ಈಗ? ವ್ಯಾನ್
Complainant.
ಆಯ್ತು, ಏನಾಯ್ತು ಹೇಳಿ ಈಗ?
55 my lord, the complainant.
ಏನ್ ಮಾತಾಡಿದ್ರಿ ಸರ್?
ಇದನ್ನು 55 my lord, ಪ್ಯಾರಾ ನಂಬರ್ 3 my lord. ಆಗ ಅಲ್ಲಿ ಕೆಲವರು ಯಾವುದೋ ಒಂದು ದುರುದ್ದೇಶದಿಂದ ಎಲ್ಲರೂ ಒಂದೆಡೆ ಸೇರಿದ್ದರು. ಇದರಿಂದ ಅಲ್ಲಿ ಭಯದ ವಾತಾವರಣ ನಿರ್ಮಾಣವಾಗಿತ್ತು. ನಾನು ಇದನ್ನು ಸೂಕ್ಷ್ಮವಾಗಿ ಗಮನಿಸುತ್ತಿದ್ದಾಗ ಅಲ್ಲಿ ಜಮಾವಣೆಗೊಂಡಿದ್ದ ಹಲವರು ಸಭೆ ಸೇರಿ ಮಾತನಾಡತೊಡಗಿದ್ದರು. ಇದನ್ನು ಕಂಡ ನಾನು ಏನು ಮಾತಾಡಿದ್ದೆಂದು ಕೇಳಿಸಿಕೊಳ್ಳಲು ಗಮನಿಸಿದೆ.
You are appearing. ನೇಮ್ ತೋರಿಸಿಲ್ಲ? ಗವರ್ಮೆಂಟ್. ಅಡಿಷನಲ್. ಸಾರಿ. 28 ತಗೊಳ್ಳು. ಏನು ಕವರ್ಡ್? ಕೊಡಿ ಏನು ನೋಡಿ. ಎಸ್. Same model, close it. Yes. Disposed. Next.
And I have
ನೀವು ಇದ್ದೀರಾ? Next
special
matter.
public, next 29.
29.
Special public.
There's some inconvenience, my lord, seniors and can I request for an accommodation? Lords, appear for the petitioner, some inconvenience, my lord, seniors unwell, can I please request for an accommodation?
Ashok Hanali sir.
ಇಲ್ಲ, ಶ್ರೀನಿವಾಸ್ sir. ಶ್ರೀನಿವಾಸ್ ರಾವ್ sir.
Srinivas Rao.
ಏನ್ matter?
My lord, this is 376 2N, my lord.
376
Allegation
to
against
N.
this petition, yes, my lord. Multiple times on the same victim.
Accused number 3.
Accused number 3, my lord.
ಇವ್ರ ಮೇಲೆ ಏನು?
Your mele that he has set up cameras in the place wherever the incident took place, and he has also published it.
Published also.
Published also. And used that same thing to threat the people and blackmail them.
There is no entry mode also.
There's no entry model.
No entry mode.
Request for next week, my lord.
Proceedings are on there.
Proceedings are going on.
Listed on Monday, my lords.
List the matter on 28th. Finally, in the event no submissions would be made, the petition would be dismissed for its non-prosecution.
If not, my name must be shown.
The registry to print the name of Pradeep SS.
Pradeep CS.
CS, sorry. Pradeep
Special
CS as
prosecutor.
appearing special prosecutor for the respondent. State.
State.
Yes,
Great, my lords.
for the state. Next.
30.
Grateful.
Yes, sir.
Proceeding arising out of warrant case, otherwise the
Defamation,
police
huh?
report. ಇಲ್ಲ my lords, ಇದು 417 of 506 FIR of 2014 my lords, B report filed between 2022 EBC commences proceeding state. Thereafter my lords, first application under 311 right with 360.
311 application da idu.
ಅಲ್ಲ, dismiss ಆಯ್ತು first one.
Ah.
Same prayer my lords made second time.
That is allowed.
ಹೌದು. Page number 140 is the first application. 140 my lords, first application.
Even proceeding stay ಆಗಿದೆಯಾ?
Stay ಆಗಿದೆ.
Because of the application.
In fact, my lords, the arguments on discharge application had commenced. They sought time, they did not argue. Then the change of counsel. Again, my lords, arguments heard, in fact, there was an order passed. Subsequently, again, the arguments commenced, again, one more application filed, change of counsel, my lords, and again, the same application comes to be allowed.
Heard the learned counsel of the petitioner, Amar Korea. There is no representation on behalf of the respondent. As a last chance, list the matter on 28th. In the event there would be no representation, the petition would be disposed on hearing the counsel for the petitioner. Interim order subsisting will continue to the next date. Next.
31.
Let's appear for the respondent in this matter.
Lordship, on the last date of occasion.
File my, I'm sorry,
ಹಾಕಿದಾರಾ?
ಹಾಕಿಲ್ಲ objection, ಹಾಕಿಲ್ಲ. ಒಂದ್ 2 ದಿನ ಟೈಮ್ ಕೊಟ್ರೆ 27th ಕೊಡಿ ಫೈನಲಿ.
List on 28th in the fresh matters, in the same stage, objections if any by the respondent by then.
Interim order may be.
Interim order subsisting will continue to the next date of hearing. Yes.
Obliged, Lordship.
Yes, sir.
My lord, I beg to appear for the respondent number 2.
Yes, sir.
My lord, a question of law, my lord, in this case will have to be determined by my lordship. My lord, I'm aware of my lordship's judgments, wherein my lordship had remanded
What
the
is
matter
this?
back.
Oh, one moment, sir. One moment, sir.
Lord, in a civil suit, injunction is granted. There is a trespass, private complaint has been filed as against the petitioner. Last time, Lord, it was indicated 175(3) report.
175(3), if it is not followed, I'm sending it back, sir.
Yes, my lord. My lord, my lord, can I submit a compendium of cases? I am aware of my
No, sir.
lordship judgment.
175(3) straight away, I'll send it back for redoing the exercise. That's all.
My lord, kindly consider my submission, my lord. Then I leave
Yes,
it to
sir.
my lordship.
No,
My
no,
lordship had.
why fight on that when it is settled?
No, my lord, my contention is it is not.
No.
For a moment, my lord, because my lordship
I
had
will not
relied
go
upon
against the Supreme Court orders,
No,
sir.
my lord. In fact, a subsequent Supreme Court judgment differentiated the previous judgment. My lordship had relied upon Om Prakash Ambedkar judgment of Justice
Correct.
Pardiwala, paragraph 29, 30 and 31. In a subsequent judgment by Dipankar Datta, my lord, he considered the same judgment and differentiates the same. In that, my lord, so the question remains whether it is directory or obligatory is to be considered. My lord, a contention was raised. My lord, I'll take my lordship to the relevant paragraphs of the said judgment and I'll leave it to my lordship. Now, because, my lord, the contention was raised, my lord, the subsequent judgment, a contention was raised that subclause 3 and subclause 4 will have to be considered to be disjunctive in nature. Let it be considered disjunctive. So the Honorable Apex Court held the substantive, this is a procedural law and the mandate of a substantive law cannot be curtailed. And two judgments was discussed by the Supreme Court. One is Lalita Kumari's case. Second is Priyanka Srivastav's case. The Supreme Court held that if we are going to consider both of it to be disjunctive in nature and cannot be read as conjointly, then the substantive law which is enumerated in these two judgments will essentially not be given effect to. My lord, hence, my lord, assume for this for a moment, my lord, a cognizable offence is made out. The police does not register an FIR. I prefer a complaint before the honorable magistrate. Do I need to consult or hear the police need to be heard? The right of audience at that stage, my lord, for those offences where cognizable offence is made out is not required. My lord, can I take my lordship to the said judgment? But my lord, because it is a matter, and also in one other judgment, it held that it is only direct, it is not obligatory, it is only directory. It is a matter of procedure. My lord, imagine a proposition. Let me test this proposition in an extreme case. Assume a rape victim, my lord, goes to the police and lodges a complaint. The police refuses to register a complaint. I prefer a 156 subclause 3 application before the magistrate. Should the police be necessarily be heard before an order is passed? Well, according to me, the answer to that question is negative. Can I please take my lordship to the relevant
It will
paragraph?
be diluting the purport of 175 itself, sir.
No, my lord. No, my lord. It is
It will
not.
be diluting the purport of the
In
statute.
fact, my lord, the Supreme Court, while analyzing the subsequent judgment, says, my lord, that the enactment qua the said provision itself is confusing. I'll take my lordship to the relevant paragraphs, my lord, and then I leave it to my lordship for an authoritative pronouncement on the same. In fact, my lord, the first judgment of Justice Pardiwala, my lord, the list in question was not whether the requirement of section 175 subclause 3 is directory or obligatory. Where there, my lord, it was a case where a lawyer had lodged a complaint against a policeman. In that circumstance, my lord, the only question which was to be considered was 175 subclause 4 and not 175 subclause 3. So, my lord, an observation which is there in 29, 30 and 31, if I apply the doctrine of inversion, it cannot be said to be a law which is laid down by the Honorable Apex Court. My lord, it will have an impact wherein every case, in spite of a cognizable offence being made out, if it is not registered, the magistrate is devoid of powers to direct investigation till the police is heard. In many cases, time-sensitive investigation would be scuttled. My lord, it is in the teeth of other judgments, catena of judgments of the Apex Court. My lord, I would request my lordship to consider the judgment in XXX versus State of Kerala, which is a subsequent judgment, my lord. My lord, is my lordship having the compendium which I have circulated, my
He
lord?
is a second salaried holder.
Well,
My learned
can I
friend is
complete?
wasting your
I
time.
request my learned senior to allow me to complete qua the question of law. Then I'll come to the facts.
The person who has
He is
got
the
a-
complainant.
I'm
Yes,
the
my
complainant.
lord.
Then he has a right to argue. Yes.
No.
But after you finish anyway.
No,
Yes.
no, 2023, his sale deed. My sale deed is 98, 15/5, 98.
No, that's a matter. No, we are at this threshold whether 175(3) should be stricto sensu complied with prior to referring the matter for investigation.
My lord, is my lordship having the compendium, my lord?
I have the compendium.
Yes, my lord. Kindly come to, I am referring to the
No,
judgment
I'll
49.
take this on. I'll take this on 28th. I'll
Yes, my
also
lord.
go through this. Yes.
49, my lord. It is a subsequent judgment by Dipankar Datta.
Page.
Fact, page 49, my lord. Page 49. In fact, my lord, this is a case, it's an extreme case. My lord, every procedure, especially criminal procedure, will have to be tested in the extreme. Now, if you come to page 63, at
Oh,
paragraph
this is that
22.
Anmol. Anmol.
Not Anmol. No, my lord,
No,
it
the
is
name is
XHS.
masked.
Yes, my lord.
The name is masked, but it's.
Yes, ma'am. My lord, kindly come to.
Well, wait, well, and I'll see, I'll go through it and 28th we'll decide this.
Yes, my lord. One paragraph in that, my lord, 22, it specifically
Idhal
take note.
paragraphs mark ಮಾಡಿ. Why you don't get reported judgments? Easy to pull down judgments on Supreme Court's website. Get it. Bidi.
Even that judgment, according to me, my lord, I've read this judgment, okay, it's given a compilation, doesn't speak in a
I have
manner
circulated much prior
Huh?
to my.
doesn't speak in a manner,
No,
manner
no.
in which he speaks.
We will be diluting the statute itself.
No, well,
We'll see,
actually, it
I'll
is
answer
not.
it. No problem. We'll
Yes,
answer.
my lord. Because, my lord, assume for a moment, my lord, it is at 156 subclause 3, it is a precognizant stage. So, my lord, the police does not have otherwise a right to be heard. Now, whether the very registration of the FIR, the
We'll
police has
see.
a right to be heard. My lord, will
That
it
is
not
exactly the mandate of BNSS.
No, my lord, it is not. It has to be
That
interpreted in
we'll
the
see, we'll
backdrop of
answer.
Lalita Kumari's case.
We'll answer it, sir. We'll answer it. Yes.
In fact, my lord, even in paragraph 18, the said judgment
We'll
talks
answer it.
what is the mandate of
Anyway,
Lalita
we'll
Kumari.
answer it. Any one of you will test it. We'll see. Yes.
Yes, my lord.
28th.
Yes, my lord.
Interim order.
That will continue.
33.
Heard senior counsel.
My lord, the only vague allegation against the petition number 1 is that he made a political speech. My lord, insofar as the issue of whether a speaker can be held liable under this act, my lord, that is the Religious Institution Prevention of Misuse Act, has already been answered by this court.
ಅದಕ್ಕೆ ಬರೋದೇ ಇಲ್ಲ ಕೊಡಿ. ಎಲ್ಲಿ ಇದು what's this serial number?
33, my lord.
Interim order ಇದೆಯಲ್ಲ?
ಇದೆ, my lord.
Complainant ಯಾರು?
The state itself, my lord. Officer of the state.
Yes, sir.
Election time, my lords. Flying squad in the religious place ಅಲ್ಲಿ election canvas ಮಾಡಿದ್ದಾರೆ.
My lord, there is no allegation of election canvas at all, my lord. There is no allegation
Religious
of
Institution Prevention of Misuse Act cannot be brought into this at all. It is for a specific purpose that act was enacted. ಇಲ್ಲಿ judgment ಕೊಡಿ.
My lord, your lordship. This is the Arif.
There are so many.
There are many, my lords. I have a complaint. My lords, the petition number 2 to my lord 8 are members, my lord. My main contention is that mere statement that he gave a political speech does not come within the scope of political activity as defined under section 2D, my lord. It is ambiguous. There is no allegation of making canvassing for votes or soliciting for votes or canvassing for any political party. Nothing at all, my lord. He came with his wife to seek the blessings of the God.
The petitioner is before the court seeking the following prayer. Heard, so and so. The petitioners accused 1 to 11.
Petitioner number 1, my lord, is the
petitioners 9 in number. So, few of the accused in CC 2862 of 2025 are before the court calling in question the proceedings as aforesaid for offences punishable under section 3, 6 and 7 of the Religious Institutions Prevention of Misuse Act 1988. The fulcrum of the complaint is that Adi Ranganatha Swami temple situated in Shivamogga city was being used for political activities is the complaint registered by the second respondent, the flying squad, during the elections for the assembly, Karnataka Lok Sabha, no? For the parliamentary elections of the year 2024. This becomes a complaint for the aforesaid offences, and the complaint is cognizance is taken on the said complaint and CC 2862 of 2025 is registered. Registration of the CC is what drives the petitioners to this court in the subject petition. The learned counsel appearing for the petitioner submits that the very provisions of the said act would not become applicable to the facts of the case, as what is alleged is the petitioner, the second petitioner, along with others, had visited a particular religious place to take the blessings of the deity therein, and that would not amount to the misuse of the act. He would also seek to place reliance upon plethora of judgments rendered by coordinate benches of this court, which is followed by this court as well. The learned additional SPP would, however, refute the submission contending that the investigation has led to filing of the charge sheet and therefore further proceedings must be permitted to be continued against the petitioners. He would seek dismissal of the petition. I have given my source. The aforenarrated facts are not in dispute, are a matter of record. The flying squad on 30th March 2024 registers a complaint on the score that the second petitioner, along with others, has visited the religious place.
Petitioner number 1, my lord. Petitioner number 1 has visited. Petitioner number 2 to 8 are, my lord, the members of the committee. And 9 is a random.
The first petitioner has visited the said religious place, and 2 to 8 are the members of the committee of the said religious place. All of them are dragged into the web of the proceedings pursuant to the registration of the crime on 30th March 2024. The complaint reads as follows. The complaint reads as follows. The police, the investigation ensues, and a charge sheet is filed against these petitioners. The summary of the charge sheet reads as follows. In identical circumstances, the coordinate benches of this court have quashed the proceedings on wherein the same provisions had been invoked to become the fulcrum of the crime. In that light, the allowed cost is nalak.
Great.
Next.
34.
The petitioner was the former MP, my lord, and allegation is that he has made a speech in a program regarding Balidan Divas. Not this Fumoto complaint, my lord, registered as FIR.
Yes, sorry.
After.
No, it's a transcript of the. It's speech minutes.
Transcript.
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ?
ಇಲ್ಲ, transcript ಇಲ್ಲ, but the Somoto complaint itself is, my lord, narrated everything.
Yes, list on 28 in the fresh matter in the same stage. Interim order subsisting will continue to the next date of hearing. Yes, next.
Lord, may I pass on the judgments?
No, ಕೊಟ್ಬಿಡಿ.
35.
Our counsel on record has met with an accident. My lord. She's not keeping well. Kindly have the matter in the end of September.
What happened? Accident.
She has met with an accident. She's
Interim order.
interim order has to be extended till the next date.
Learned counsel representing the counsel on record would submit that the counsel on record is indisposed. Next week?
End of September, my lord. 3 weeks.
End of September.
At least after 15th of September.
List on last week September ಅನ್ಕೊಡಿ madam date.
Grateful.
30th September.
Grateful.
Interim order continues.
36.
But this is challenging the B report accepted by the learned magistrate.
First matter I appear for respond number 5, your lordship.
Not having.
B report accept ಮಾಡ್ಕೊಂಡಿದ್ದಕ್ಕ ನಿಮ್ಗೇನ್ ಪ್ರಾಬ್ಲಮ್?
I am the complainant.
ನಿಮ್ಮನ್ನ ಹಿಯರ್ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ ಮಾಡಿದ್ದಾರೆ, but sworn statement based on the protest petition, no statement was recorded. And though the learned magistrate would hold that offense has been committed, my lord, instead of directing further investigation, the learned magistrate would accept the B report, saying that the police should have done the further investigation. Page 17, internal page 9 of the order.
ಏನು offense ಏನು?
It's 420, 465. The FSL, my lord, what happens is I contest for a directorship of a sugar factory.
Yes.
I contest for a directorship of a sugar factory, my lord. My signature is forged and nomination is withdrawn. Well, later I come to
Fourth signature, nomination is withdrawn.
nomination. I, my lords, file a complaint. FSL report says my signature is forced. Learned magistrate would say that they should have done CCTV investigation and all those things.
Special court ಯಾಕಾಯ್ತಿದು?
My lord, one of the person is second respondent.
MLA.
And the connected matter is during pendency, my lord, I had filed a petition requesting transfer to the CBI.
ಇದನ್ನ
The connected matter.
ನಿಮ್ ಫೋರ್ಜರಿನಾ?
Num forgery.
FBI ಬೇಡವಾ?
My lord, now the B report is accepted. Last time, my lords,
Federal Bureau of Investigation ಬೇಕಾದ್ರೆ ಇನ್ವಾಲ್ವ್ ಮಾಡಿ.
they ask for a sky.
What sir? Ask for the sky, you will get at least a tree top ಅಂತ.
Yes. That's the mindset of litigants.
Good
But
cause.
my request is this. The order of the learned magistrate, my lords, without recording this own statement and accepting a B report, it's contrary to the law.
ಅಷ್ಟು ಸಾಕು. ಈ CBI, FBI ಎಲ್ಲ ಬೇಡ.
And my lord, if it is possible, my lords, because the respondent number 2 is a MLA, my lord, let this matter be shifted to CCB, my lords. I can't make a same request to the learned magistrate because it is a
No,
different.
that you can't, definitely.
So therefore, my lord,
We'll
lordship
see.
would consider.
SPP ಅವರೇ?
CCB will not have jurisdiction.
CID ಯಾ?
The CCB is jurisdiction of Bangalore. Offense is not.
Offense ಎಲ್ಲಿದು?
ಬಿಜಾಪುರ್.
Job.
ಹಂಗಾರೆ CID.
The examination of one document.
ಫರ್ದರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ಲಿ ಬಿಡಿ.
I'll file my statement of objection.
ನೀವು ಮಾಡಿ.
For
But having prima facie seen that there is forgery, where is the question of acceptance of B report? Further investigation.
My lord, he has made an allegation on the third party. Lord, may kindly see, my lord, the specific.
ಆಯ್ತು, objections ಹಾಕಿ.
Objection.
Please, Lord.
We'll take it on 3rd September.
Please.
List on 3rd September, objections if any by then, by the respondent by then.
Please,
ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ಎಲ್ಲಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಬೇಕು ನೋಡೋಣ.
Please, Lord.
Lord, this is complainant's petition.
ಯಾವ್ದಿದು?
Lord, the defamation against
Fear for the
RSS.
respondent, my lord. I pray for a time to file my objection, my lord.
Lord, this
ಸರ್ವ್
A2
ಆಯ್ತು,
has
ಕೊನೆಗೂ
been,
ಸರ್ವ್ಡಾ? All right.
That
Lord,
is, they have not
A2
served the full petition, my lord. They have served only
ಹೆಸರೇ ಕೊಡ್ತಾನೆ.
without annexure was served.
ಕೊಟ್ಬಿಡಿ ಸರ್. ಏನ್ ಬೇಕೀಗ?
Okay, my lord, I'll file my objection, my lord, 2 weeks.
Lord, there
2
is,
weeks? No, ಇದರಲ್ಲೇನಿದೆ
Lord,
2
there is
weeks?
some urgency because 29th, the A1 and A3 are, they have to appear before the trial, learned trial magistrate.
List on 28 objections if any by the respondent by then. Yes.
Direct to serve
No,
the
I will
full
do
set of the,
ಈಗ್ಲೇ.
I will do it.
Yes.
much obliged.
ಪೂರ್ತಿ ಸೆಟ್ ಕೊಡಿ. 2 ಸೆಟ್ ಕೊಡಿ.
3 ಕೊಟ್ಬಿಡು.
ಅಷ್ಟ್ ಮಾಡಿ. Yes.
ಕೊಟ್ಟಿಲ್ಲ.
38.
Is the predicate offense, my lords have reserved it for judgment.
We will take this on 28th.
Meanwhile, my lords, the
28th.
proceedings maybe deferred, my lords, because trial.
Still at
before-
the
ಏನ್
state
ಆಗ್ತಾ
of
ಇದೆ?
summons. Still
Plus
at the
the
state
trial
of
court-
summons.
No, no,
On
my lords, trial
24th.
court has already taken a cognizance and issued summons to me, my lords.
My lords,
And
still
at the
List,
time of,
list on 28, by then you'll get it. Yes.
39.
ಅದ್ರ ಮೇಲೆ ಇದಾಗಿರೋದಾ?
Yes, my lords.
Then
After conviction.
28.
39.
Case of 308 proceedings, your lordships. Approver has turned hostile. Hence, we've approached this court.
Cross examination.
No, your lordships. He's gone against his voluntary statement, your lordships.
ಯಾವ್ದ್ರಲ್ಲಿ ಇದು? Oh, that ವಿನಯ್ ಕುಲಕರ್ಣಿ.
Yes, sir.
Respondent ಯಾರು ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ? I've already directed service.
Yes, your lordships. We've tried to serve them. They have not
The
responded.
counsel for the petitioner seeks a week's, 1 more week's time to comply with the order dated 31/7/2026. Yes.
Obliged, your
List on 28th. Next.
40.
Fear for petitioners. No.
First time,
There is an interim protection granted, my lord. Ladies protested, my lord, in front of a
Oh,
political
ಇದು
party.
ಕಲ್ಲು ಹೊಡೆದಿದ್ದೀರಾ?
ಕಲ್ಲು ಹೊಡೆದಿಲ್ಲ, ಕಲ್ಲು ಇಟ್ಕೊಂಡಿರೋ ಫೋಟೋ
ಅಲ್ಲಿ
ಇಟ್ಕೊಂಡು.
ಹೊಡೆದಿದ್ದಾರೆ.
There is no damage caused.
ಲೇಡೀಸ್ ಅಂದ್ರೆ 3 ಜನ ಬಿಟ್ಟರೆ ಲೇಡೀಸ್ ಇರ್ಲಿಲ್ಲ.
ಇಲ್ಲಿ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
ಶ್ರೀಮತಿ, ಜಯಶ್ರೀ, ವಾಣಿಶ್ರೀ, ಕೀರ್ತಿ, ಶೋಭಾ, ಮಲ್ಲಮ್ಮ.
ಎಲ್ಲರೂ ಅವರೇ ಎಕ್ಸೆಪ್ಟ್ ಪುಟ್ಟರಾಜು.
ಅದು
ಅಲ್ಲ 1 to 6 ಅವರೇ.
ಹೌದು, ಅವರೇ ಇದ್ದಾರೆ. Only few, my lord. Last time your lordship asked, my lord, we said moral support, my lord.
ಮಾರಲ್ ಸಪೋರ್ಟ್ ಅಲ್ಲ, ನೀವು ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ರಲ್ಲ, ಅಟ್ಲೀಸ್ಟ್ ಈಗ ಬಂದು ಕಲ್ಲು ಹೊಡಿತಾ ಇದ್ದಾರೆ. ಹಂಗೆಲ್ಲ ಹೇಳಕ್ಕಾಗತ್ತೆ?
Secure the records, man.
ಕೊಡಿ ಕೊಡಿ. ಪ್ರೊಟೆಕ್ಷನ್ ಕೊಟ್ಟಿದೀವಲ್ಲ?
Protection is there.
ಏನ್ ತೊಂದ್ರೆ ಕೊಟ್ಟಿಲ್ಲಲ್ವಾ?
ಇಲ್ಲ, ಈಗೇನು.
28th ಕೊಡಿ, ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ.
Please.
28th in the fresh matters list. Yes. Heard the learned senior counsel. Yes, next.
41,
For the petition of my.
41, my lords.
Covered by.
Covered by?
Nalla Balu case, my lord. The complaint is
occasion, my
lodged
lords.
by one third party.
Third party.
Seeing the social media post, my lord. Not any
Hmm.
covered by.
The allegations, my
Nalla
lords,
Balu.
the words used by the petitioner, my lords, against an IAS officer.
Tomotona?
Pakistani.
ಅಲ್ಲ ಇದು based on complaint by one third party looking at the.
One minute. Oh,
that
idu.
is-
Yes, sir. No, this I will not spell.
ಅಲ್ಲ,
Secure the
I
records,
pray
my
for a
lords.
week's time to file.
This
the
I am
order.
not going.
My lord, I pray for a week's time to
Last time
file.
itself, I made it clear that I am not going to
I will
interfere with
file.
this man who has called the IPS officer,
IAS officer.
IAS officer, a woman from Pakistan,
My lord,
just because she's a Muslim.
ಅಲ್ಲ ಅದ್ರ ಬಗ್ಗೆ ಅಲ್ಲ question of law that
No.
complaint is lodged by. My lord, I pray for 2 weeks time to file.
Oh, yes, bench escape.
ಅಲ್ಲ ಅಲ್ಲ
Bench and
ಆ
change
ಥರ
ಆಗಲ್ಲ.
ಅಲ್ಲ 29th ಗೆ ಆಗ್ಲಿ ನಾನು ಅದ್ರ ಸ್ಯಾಂಕ್ಷನ್ ಆರ್ಡರ್ ಕಾಪಿ ಒಂದು ಪೋಸ್ಟ್.
There was a direction, my lords, to furnish the, secure the records.
ಕೊಡಿ.
The Tiranga Yatra permission, Tiranga Yatra permission.
ಅದು ಹೇಳಿದೆ ನಾನು.
ಕೊಟ್ಟೇ ಇಲ್ಲ.
And holding the flag, if you have committed any, if you have stopped it, and I am not going to spare you
That
also.
was not the representation given, my lords.
The representation ಅಲ್ಲ, you lordship may kindly see the speech. I may be permitted to read the entire
Wait,
speech,
yes.
which clearly shows I was about to do Tiranga Yatra, that they have prevented, my lord.
That if they have prevented, we'll see.
It is the
Plus
case. For that,
Tiranga-
even I may be permitted
happened
to
in
produce
another
some documents.
constituency, much before a week. My lords, there the said opposition party leader volunteers, my lords, that he is not willing to go outside for the Yatra.
Lord,
No, my
yes.
lord, it's-
Subsequent to which,
Less
my
the
lords,
matter.
after 1 week, my
hours
lords,
and
this
the-
protest happens.
List the matter on 28th.
Please, ma'am.
Yes.
Please.
Much of.
42,
42, my lord, this is a
ಏನ್ ಇಷ್ಟೊಂದು?
batch that matter, my lord. I thought time to file my objections.
ಏನಿದು?
KPSC matter.
This is KPSC
Oh,
matter where
yes,
we
sir.
sought for transfer of this.
ಈಗ ಯಾವ್ಯಾವ್ದು ಒಂದ್ ನಿಮಿಷ ಇಷ್ಟೊಂದು ಯಾಕೆ ಕನೆಕ್ಟ್ ಆಗಿದೆ?
Some of the candidates have.
One minute. ವೆಂಕಟೇಶ್ ದಳ್ವೆ ಅವರೇ ಯಾವ್ಯಾವ್ದು ಹೇಳಿ? 42 ಏನು?
My lord, 42 is the
Accused challenging the
ಅಲ್ಲ,
registration.
ಕ್ಯಾಂಡಿಡೇಟ್ ಸಕ್ಸಸ್ಫುಲ್ ಅನ್ಸಕ್ಸಸ್ಫುಲ್? 1 minute. 42.1 ಏನು? ಸಕ್ಸಸ್ಫುಲ್. 42.2 ಏನು? 42.3 ಏನು?
My lord, this is
Seeking transfer of investigation.
Speaking of transfer of investigation of Vidhan Sabha FIR to CBI.
This is the chairman's.
Yes, ma'am. That is still with Vidhan CID, Vidhan Sabha police.
Vidhan.
All right. It's not at transfer. Yes. Which is this 42.4?
Lord, this is by the complainant.
ಯಾವ್ದಿದು?
There is the veterinary doctors.
Veterinary doctors. Yes, sir.
I have to file objections, my lord.
Last time I ಹೇಳಿದ್ದೆ
I know.
ಮಾಡಿ ಅಂತ.
No, there is some small last minute corrections. All
Ready
I am
ಇದೆಯಾ?
asking, almost ready, my sir, some small corrections. All I am asking, my lord, your lordship, may I have it? I'll serve as advance copy.
I'll
And
take
your
it on
lordship-
Tuesday. You serve it on them. Wednesday is a holiday ಅದಕ್ಕೆ.
I'll have it on 28th, but I'll serve a copy before.
Earlier.
I'll serve a
Tuesday,
copy
Burley,
before.
if he is not able to file, then your lordship can.
Yes,
No, I'll serve a copy on Monday.
You serve a copy on Monday. I'll take it on Tuesday. This ಇವ್ರ 3 ಜನದ್ದು 42.1, 42.2, 42.3. ಈ 42 will post it for further hearing ಎಲ್ಲ.
It is already heard in part.
There for further hearing.
May I make one submission? In 42.2, my lords, they are all successful candidates who have not, my lords, secured any marks, my lords, out of dubious means. I am producing, my lords, the copy of the OMR.
No, ನೀವು ಎಲ್ಲ ಕೊಡಿ. That's precisely why I have protected you.
May I just be permitted to say this? Yesterday and day before, my lords, the ED has conducted raids
On you?
on me, my lords.
Hmm.
So far as, my lords, they have utilized, my lords, this case as a predicate offense. And they have come and, my lords, they have investigated into my house. My house, my lords, there was a program
Why?
going on.
You challenge that.
But I don't know, my lords, if the ECIR I would not have. I would
ಅಲ್ಲ,
not have.
ECIR ಕಾಪಿ ಇರಲ್ಲ.
And I.
ಯಾರು ಸರ್ಚ್ ಕಂಡಕ್ಟ್ ಮಾಡಿದ್ದೀರಾ? ಹೌದಾ?
Yesterday there was search conducted on chairman's house and other.
Chairman's house and all the my lords candidates.
Candidate's house also.
And so far as I am concerned, my lords, the ED officials conducted a test inside the house and they questioned me for 20 marks. And my lords, I have been successful in the 20 marks.
Oh,
By the
in
ED
ED
officials.
test also.
By the ED officials, my lord. And but my only submission is, my lords, I have secured government employments in other exams where I have been successful. And because of this pending FIR, my lords, I am not able to secure government employment.
No, we'll see.
Please.
Ultimately, we'll have to solve the problem.
I am caught in this luck, my
This,
lords, between.
no, maybe, but this must stop. This institution getting maligned like this must stop. There should be something. But the VD then challenge madi, so what?
What basis they have recorded my
No,
channel.
whatever it is, if there is anything, you challenge it, we'll
Inside my
see.
house. When there was a function going on, my lords, inside my house.
The function going on, when I'm hearing, we'll see. ಅದು ಮಂಗಳವಾರ ತಗೊಂತೀನಿ ಅಷ್ಟ್ರಲ್ಲಿ ಹಾಕಿ
No, I'll fill it on Monday only, but what I'm asking
ಆಯ್ತು
is
ಗುರುವಾರ ಬೆಳಗ್ಗೆ
whatever convenient.
Thursday at 2:30 PM for the hearing.
All the OMR sheets, not so far as these petitions are concerned, everything is filled. Nothing is left blank for somebody else to petition.
We'll see.
Please.
Yes, we'll see. List the matter on 28th, 27th at 2:30 PM for further hearing. Heard so and so ಎಲ್ಲ ಹಾಕಿ ಹಾಕ್ಬಿಟ್ಟು
Interim order is there.
interim orders wherever subsisting, interim stroke protective orders wherever subsisting shall continue till the next date of hearing.
Great.
ನೀವೇ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
I'll also place that.
Records ಕೊಡಿ ಎಲ್ಲ.
I'll place that.
Whatever investigation you are doing, please place the records. ED ಯಾವ್ದಿಲ್ಲ ಅಲ್ಲ ಇದರಲ್ಲಿ?
43.
SFIO
I seek a short accommodation.
next week, 28th. As a last chance.
I've been discharged, so.
They know their case.
Main accused citizens have been acquitted, so therefore perhaps nothing more may.
Anuparna madam, next week.
44.
We appear for petition, my lords. The respondent was convicted by the trial court.
Let me pronounce those orders. Yes. 28th.
Yes.
45.
This is identical mining SIT investigation.
Revision petitions.
Revision against rejection of discharge application. Lord, my synopsis is ready.
Kodi, all on 3rd. 3rd September. Yes.
Lord, there's an interim order.
That will continue, sir.
Please.
Yes. You can straight away submit and walk away. No worries about continuation of it. That will definitely be continued. No, yes, like.
Great.
Yes.
46.
All on 3rd. Up to 50. All revision petitions on 3rd.
Hearing on IA 51.
This is the case where end up please.
Correct. We'll have to decide. 28 ತಗೊಂತೀನಿ ಅವತ್ತ ಡಿಕ್ಟೇಟ್ ಮಾಡಿ.
Covered by judgment of this honorable court and Supreme Court.
ಯಾವುದು ಕವರ್ಡ್?
This very issue is covered, please. So I produce the judgment.
Yes, madam. ಪ್ರಸನ್ನ ಕುಮಾರ್ ಇಲ್ಲಿ.
Your Lordship, seeking time.
ಅದೇ 28 ತಗೊಂತೀನಿ. Not well. Yes. List the matter on 28th. Heard, that's interim order will continue.
Lordship, this is that matter with respect to illegal iron ore mining. Only 14,000, not 50,000. And your Lordships, even your Lordship's judgment in that matter which went up to the Supreme Court.
Yes.
In that they had distinguished stating there were other cases pending, therefore cumulatively it would come to.
No,
above
again
50.
I've written that only.
Please. And in ours it won't even come to that.
Again
Because
I've
in
written that. I think that
that again might be in round 2. I'm not too sure, but what I'm saying is ours will not even come to that because we do not have any other case pending. Ours is put together only 14,000. Now, what the Learned Council tried to submit is they filed a memo stating there's some 1,60,000. None of it is on ours. Our name doesn't come in primary. It comes in the subsequent additional charge sheet.
yeah, you've seen the subsequent judgment of mine. Second time.
Second one, do we have it? 2025 one.
26.
26, no, we haven't.
Because it was remanded from the apex court. I've written the same thing.
please. Then that should
And it
cover.
went back, not remanded now. Yes.
But we are a step further that we would not even fall in that.
It's confirmed now.
Please, your lordship, it could be reserved then because if we'd be bound by it.
ಅಯ್ಯೋ 28ಕ್ಕೆ ಮಾಡಿದ್ದು ತುಂಬಾ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ.
Your lordship, every other matter is 28th today, so
29th will take. Let's on 29th.
yes, please.
When working Saturday.
Please.
Yes, 29th.
Obliged.
We'll dictate on that day. Heard the learned senior council. Interim orders continues 29th.
53.
Yes, for petitioner. Not the only order which could survive in this matter is, my lord, order of invocation of section 144, 163, my lord, squarely covered by Anuradha Bhashan. The state was directed to, my lord, file objections and produce records. They have not
Yes, sir.
produced.
Surya.
Sufficient opportunity has been given, my lord, 3-4 occasions. And as I said, my lord, Pratyon Sari Obavur Barthar.
Go to the records, minutes.
Go through the records, sir.
Please.
ಇದು ಹೊಸ submission ಈಗ.
ಆಯ್ತು, ನಂಗೆ ಬೇರೆ ಮ್ಯಾಟ್ರ್ ಇದೆ.
Only thing is, my lord,
28ಕ್ಕೆ ಅವತ್ತು ಮುಗಿಸು. ಅವತ್ತು ರೆಡಿ ಇರಿ ಬೆಳಗ್ಗೆಯಿಂದ.
ಒಂದು ಲಿಸ್ಟೇ ಮಾಡ್ಬೇಕು.
ಹಾ, ಸೆಪರೇಟ್. ಎಸ್, ಅವತ್ತು ಯಾವ್ದಕ್ಕೂ ಟೈಮ್ ಕೊಡಲ್ಲ.
Sorry, my lord, in seal number 51 and connected matters, the interim order may kindly be extended. Sorry, my lord, I'm sorry.
ನಾನು ಯಾವಾಗ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿಲ್ಲ ಸರ್. Don't have that fear at all.
Please, obliged.
None of you need have that fear that I will not extend the interim order.
But my lord, we shall bring to your lordship notice.
No, that's why I said you can submit and walk away. Interim order iದ್ರೆ continue.
So great.
Interim order request. I'm sorry.
ಇದೆಯಾ ಇಲ್ಲಿ ಕೊಡ್ಬೇಕಾ ಇದೆಯಾ? ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಬಿಡಿ ಸರ್. That's the instruction I've given to everybody who come here. If there is an interim order, it should continue. ಒಂದ್ಸರಿ ಇಲ್ಲದೆ ಇರೋದು ಕಂಟಿನ್ಯೂ ಆಗಿರುತ್ತೆ. Yes.
54.
I appear in 54.1, my lords.
ಏನಿದೆ?
Lords, so far as 54.1 is concerned, I am the exporter. And the predicate offense is also stayed. It was argued at length, my lords, earlier.
Last time,
The senior counsel, Mr. Pasha, has argued before your lords.
let him come. We'll see. Next week, 28th.
55.
ಎಲ್ಲ interim orders will continue. Nishant, next week ತಗೊಂಡು.
Please.
Interim order continue.
56.
Same. ಇನ್ನೇನು?
Plus they are seeking CBI investigation. In the very same case, he has already been convicted. And this honorable court has stayed his conviction and granted the suspension of sentence.
ಯಾವ್ದಿದು?
But Vinay Kulkarni's matter, Millers, the
ಮತ್ತೇನು CBI ತಾನೇ ಮಾಡಿರೋದು ಅದು?
CBI ಮಾಡಿದಾರೆ. ಮತ್ತೆ your brother of the deceased, Millers, he has filed one more complaint.
Once more CBI.
Yes, Millers. And the very same allegation, Millers, the local police.
ಇಲ್ಲ ಆಯ್ತು, ಮತ್ತೇನು ಬಂದು CBI ಸರಿ ಆದ್ಮೇಲೆ.
He has already been convicted, Millers.
There is no representation behalf of the petitioner. In the event there would be no representation on the next date, the matter would be dismissed. Yes. 28th. Yes.
Further hearing 57.
Happy for the petition.
The case is that 380, 379.
Senior is not. 57 and 58.
Appeals ಎಲ್ಲ 29. All these appeals on 29th. Yes.
59.
ಎಲ್ಲ all the appeals on 29th. Petition ಯಾವ್ದು ಮೇಡಮ್?
59.
Oh, sorry. A criminal petition. Mahesh.
Held up in another court hall, my lordship. May I see?
28ಕ್ಕೆ ತಗೊಳ್ಳು.
Please, interim order may be extended.
Yeah, 28th.
60.
Yes. 6 ಎಲ್ಲ 29th ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್.
28.
28th, 29th, whatever.
61.
ಅದು ಅಷ್ಟೇ.
61, Your Lordships.
Interim orders ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬಿಡಿ.
Yes, Your Lordships.
Yes.
Your Lordships posted on 3rd, Your Lordships, the other matter. This is also
All
seeing
right.
criminal revision on discharge, Your Lordships.
ಆಯ್ತು, third, ಇದು third.
Much right.
This number 2. Fresh matter, seal number 1.
Serial number 1, Madam. KPID Act, Buds Act, sorry. The properties were attached. On an undertaking given by us, my lord, that we will be returning the money back to depositors.
Where's the SPP?
For filing in My lord, what has happened, my lord, the properties, my lord, have been released pursuant to orders of this honorable court.
ಆಗಿದೆಯಾ?
Release agide. Now, my lord, in spite of the orders of this honorable court, my lord, the trial court did not release. Thereafter, my lord, we brought it to your lordship's knowledge. There is a specific order passed. Now it has been released. We are trying to raise some funds on that, my lord. We require another 2-3 weeks time, my lord. We are filing a memo to that.
ರಿಲೀಸ್ ಆಗಿದೆಯಾ?
Release agide.
ಅದು ಆನ್ ದಿ ಅಫಿಡವಿಟ್ ಐ ಡೈರೆಕ್ಟೆಡ್ ರಿಲೀಸ್ ಅದೇ ಅಲ್ವಾ?
Yes. On undertaking given that we'll be returning the money back to depositors.
ದಿ ಯಾವ್ಯಾವ್ದು ಆರ್ಡರ್ಸ್ ಅದು? ವೇರ್ ಇಸ್ ಮೈ ಆರ್ಡರ್ ಆಫ್ ರಿಲೀಸ್ ಅದು? This court on 25/4/2026 had passed the following order. Again on 19/6. Hello, sorry. 19/6. The following order. The accounts, the attachment,
Please, attachment.
defreezement attachment. The defreezement of the accounts happened pursuant to the orders as afore quoted. The learned counsel, Shivaprasad Shantangowda,
Freezing
representing
of accounts and deattachment of properties, both.
defreezement and deattachment. The ಏನ್ memo ಇದು?
But now, only to show that, my lord, we are trying to raise funds and there is somebody who's
The
come
learned
forward.
counsel for the petitioner has filed a memo and would submit on the strength of the memo that they are wanting to raise funds. They wanting to raise funds for the purpose of clearing the dues or raise funds to comply with the earlier orders that are quoted supra. In that light, list this matter on 18th September.
Earlier, my lord, the matter was to come up before lordships because undertaking was given, it may be taken up.
18th September for further hearing.
Please.
Yes.
But if you don't, my lord, comply, then, my lord, everything.
It is needless to observe in the event of non-compliance of the undertaking in the affidavit, the petitions would be dismissed.
Please.
Yes. Next.
Number 2.
Krishi Infratech case.
Your Lordship, there are two connected matters. Might I start with the writ, Your Lordship, first?
2.1.
In 2.2, I'll just seek an accommodation.
One moment. Ian, what's the matter?
Your Lordship, this is a matter after 12 years. CBI registers suo moto, probably through a disgruntled, unsuccessful bidder. They claim that measurements were in excess. Your Lordship, for that, after 12 years, this man not only is asked
Krishi something.
Please.
Krishi
Infotech.
Please. Your Lordship, what's happening is not only he's been asked to refund some 58 lakhs in excess, what they claim, excess measurements. They say that his subsequent, all the other tenders that he's participated in and he's successful, from those amounts, they will seize it, Your Lordship. And practically
Yes, madam.
blacklisting him also, which is covered by Your Lordship's judgment.
Blacklisting, yes.
Yes,
Not
that
a
death
problem.
knell, as Your Lordship stated, that's virtually in this. 12 years later, Your
Interim order
Lordship.
is there.
Please.
Why do you, Prasanna Kumar Relly?
Prasanna Kumar, Delhi allowed your lordships.
This learned ASG in the connected matters also.
We'll do it on the shortest accommodation.
27th.
Oblige your lordships.
27th, no time beyond that.
Oblige.
Heard the learned senior counsel, Srimati Lakshmi Iyengar, appearing for the petitioner. This court on 6/8/2026 had passed the following order. The interim order granted was extended. The learned AGA? ASG. ASG?
But as the ASG is led in this
Oh,
matter.
ASG is up.
Manoj.
The learned,
Connected petition.
the learned CGC seeks time on this court that the ASG would be making submissions. List the matter on 27th.
But as may I seek for 28th, Manoj?
28th, Tumbai, madam. 27th, yes.
Your Lordship, in the connected criminal matter, in fact, Your Lordship had dictated the interim order, didn't find its way in the order, Your Lordship. The connected criminal matter.
Oh, same order ಅಂತ ಹೇಳಿದಿನಲ್ಲ?
Please.
It's a writ petition.
Last time I ಹೇಳಿದ್ದೀನಿ.
It's a writ petition in the connected matter.
Writ petition ಲೇನಿ same
The other one, the quashing matter I'm talking about.
ವಾಷಿಂಗ್ ಮ್ಯಾಟರ್ interim order ಇದೆ.
Please.
ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ? interim order ಇಲ್ವಾ? ಓ interim order granted ಇಲ್ವಾ? ಏನೋ ಇರುತ್ತೆ ಹಂಗಾರೆ. Prayer ಇರಲ್ಲ, something will be there.
It is there.
With the interim order.
Interim order.
It's here, see.
Obliged.
ನೀವು ಕೊನೆಯವರೆಗೂ ಬಂದ್ಬಿಟ್ಟು ಓದೋದ್ ನಿಲ್ಸ್ಬಿಟ್ಟಿದ್ದೀರಾ. Delete the name of?
Your Lordship.
Oh, register to delete the name of Shanti
Your
Bhushan
Lordship, in
H.
the
Yes.
criminal petition, there was no interim order, Your Lordship. There's only a direction of no precipitative
ಅಷ್ಟೇ
action.
ಅಪ್ಪ, ಅದನ್ನ ಏನಿದೆ ಅದನ್ನೇ ಮಾಡ್ರಿ.
Obliged.
One humble sir, my name may be shown, my lord.
Register to print the name of Swamini, initial,
Mohan Ambal.
so and so, as appearing for the as CGC representing the respondent. Yes.
Grateful.
Made please, my lords.
Very
Lords,
for
the
respondent to.
matter has been settled with the only named complainant. And my lord had given us time to settle with the others. We have settled with all 7.
Agidya?
One person, my lord, we are declining to settle. She has already proceeded against the company and the directors under section 72 Consumer Protection Act. Which
Who is that?
That, my lord, is Nirmala Gundlur, my lord.
Team number 3.
She has already proceeded, my lords, under order, under section 72, which itself is a criminal proceeding.
No, one moment. The complainant ಯಾರಿಲ್ಲಿ Sunanda Hosur. You have got your money?
Settled.
Yes. Anything else?
With respect
Don't,
to
you can't hold brief for everybody.
other victims,
Other
liberty may be
victims
given.
ಇದಾರಾ ಇಲ್ಲಿ?
Observation.
They never
including
made a
applicant.
complaint, my lord. They never made a statement, my lord. Asked them last time. They never made any statement.
I filed implementing IA for victim number 5.
For all others, huh?
So observation may be made.
What observations?
Still one payment is pending from their side. 3/9 is the due date.
Whatever observation, that complainant will come and make. Why are you worried?
Well, she's already proceeded against the company and the directors under
Then ಅಲ್ಲೇ
72,
ಆಗತ್ತೆ ಬಿಡಿ.
which is a criminal
My
proceeding.
observation may be because
No.
I got instructions.
No. Will not
And my
make that.
friend has not served us
Don't
with any
create,
treatment.
don't get an order in your favor in their petition. You can't do that.
With respect to victim number 5, at least I'm
Yeah,
including
this,
applicant.
whoever has been, whosoever's case is settled will close it. ಅಷ್ಟೇ. The petitioner is before the court seeking the following prayer. During the subsistence of the petition, it transpires that this dispute has been settled with the respondent complainant. This is admitted by the petition, by the counsel appearing for the complainant. The submission is that other victims are there and therefore their cases also should be considered. The said submission is noted only to be rejected. If the other complainants are there to whom the money is due, it is for those persons to initiate proceedings in accordance with law, or if initiated, to continue in accordance with law. The settlement herein would not come in the way of them prosecuting other cases. Them prosecuting other cases will not come in the way of closure of this petition on account of a settlement. With the aforesaid observations, the petition stands disposed. As a matter of form, the crime stands quashed.
Lordship, accused number 6, who's the priest in the temple. On the last occasion, learned SPP said they'll close it as against us because they didn't
Close the
find.
temple.
They close the case as against us in
Oh,
view of the
correct.
fact that they didn't find any material against us. And as a result of that.
Then close
time was
ಮಾಡಿದ್ರಾ?
granted.
Close ಮಾಡಿದ್ರಾ?
ಇಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡಿಲ್ಲ madam.
Close ಮಾಡಿಲ್ಲ.
Lordship, might as well be quashed, Your Lordship.
ಅಲ್ಲ ಏನು ಇಲ್ಲ ಅಂದ್ರೆ ಇದು ಹುಂಡಿಯಿಂದ ತಗೊಂಡಿರೋ ದುಡ್ಡಲ್ವಾ? Allegedly.
Allegedly, and even that they, during the lunch break hours when none of the priests are there. So through the CCTV camera, learned
Camera
SPP
off
said
ಮಾಡಿ
that.
CCTV footage.
Camera off ಮಾಡಿದ್ರಾ?
No, they claim that that camera itself was stolen. This is what they claim. Yes. That was a secret camera kept there to see who steals from the hundi, and somebody seems to have stolen that itself.
Secret camera is stolen.
Secret camera itself is stolen, and that's why the FIR came about. They seem to have now information through other CCTV cameras who are the actual culprits. So last time the submission was made that nothing as against A6 and that they will on the next occasion close it. But
Where is SPP? ಎಲ್ಲಿ instructions of closure?
ಟೆಂಪಲ್ ಲಾಕ್ ಮಾಡಿದಾಗ ಇಬ್ರು ಒಳಗಿದ್ರು ಅಂತ just that some 2 persons are inside the
Some 2 persons. ಇವರಲ್ಲ ಅಂತ SPP ಹೇಳಿದ್ರು ಲಾಸ್ಟ್ ಟೈಮ್. ಪಾಸ್ ಓವರ್ ಮಾಡು, ಕ್ಲೋಸ್ ಮಾಡೋಣ. Yes. If they say they're not going to proceed, I'll record that and close it. I've already recorded. I'll just amplify that and close it.
close.
Yes.
Number 5.
Petitioner, my lord.
Atrocities Act, my
Copy is
lord.
not served on me, my lord. Yes, in respect of the R2, my lord, order, notice has not been ordered, my lord.
Not been ordered.
Please, my lord.
Serial number?
5, my lord.
5.
Atrocities Act, my
ವಕಾಲತ್
lord.
ಯಾರು ಹಾಕಿದ್ರು?
I filed a wakalat.
Who asked you to file?
But my colleague is instructed to file the wakalat. Is representing R2 in
matter
the
was
trial
heard.
court.
ಬೇಲ್ ಏನ್ ಮಾಡಿದ್ರು?
Bail is considered, my lord.
ಕೊಟ್ರಾ?
Please, my lord.
ಹಾ ಸರಿ. Emergent notice to the respondent. List the matter on
The investigation.
first September.
Yes, may I make
Objections
small
if any
submission?
by then.
Yes,
ಬೇಲ್
yes.
ಇದಿರಲ್ಲ ಈಗ.
ಅಲ್ಲ petition on student every
ಹಾ.
week attendance ಹಾಕಿ ಅಂತ ಹೇಳಿದಾರೆ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ.
ಆಯ್ತು ಎವ್ರಿ ವೀಕ್.
Please, my lord.
ಒಂದೇ ವೀಕ್ ಕೊಟ್ರದು ಒಂದ್ಸರಿ ಹಾಕಿ.
ಅಲ್ಲ within 6 months ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ತೊಂದ್ರೆ ಇಲ್ಲ. List on first.
Incident ಮೇಲೆ has been recording CCTV.
First in the fresh matters list. ಇದು ಕೊಡಿ. Investigation papers ತಗೊಳ್ಳಿ ಮೇಡಮ್. CCTV footage ಇದೆಯಾ?
ಇದೆ ಮೇಲೆ.
ಅದ್ರಲ್ಲಿ
Nothing is
just
happened,
pass
my lord.
ಯಾರು ಕಂಪ್ಲೇನೆಂಟ್ ಇವರಾ? ಕೊಡಿ. ಯಾಕೆ ಮೇಡಮ್ ಸೆಟಲ್ಮೆಂಟ್ ಕರೆದಿದ್ದೀವಾ ಮತ್ತೆ?
ಜಸ್ಟ್ ಕ್ರಾಸ್ ಆಗೋದಷ್ಟೇ.
ತುಂಬಾ ಹೇಳ್ಬಿಟ್ಟಿದ್ದೀರಾ? ಏನು ಟಾರ್ಚರ್ ಮಾಡಿದ್ರ ನಿಮ್ಗೆ?
There is attack on the
Attack?
Attack on the respondent complaint, my lord.
If I find nothing is there in the CCTV, I will impose exemplary costs on you, on the complainant, whoever has registered the complaint. If frivolous ಕೇಸ್ಗಳನ್ನೆಲ್ಲ ಮಾಡಿದ್ರೆ, if I find nothing in the CCTV, you will face it.
Nothing is there.
We'll see. Yes. ಸುಮ್ನೆ ಕೇಸ್ ಹಾಕೋದು, ಅಟ್ರಾಸಿಟೀಸ್ ಕೇಸ್ ಹಾಕೋದು ಅಂಡ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ರೈಟರ್ ಕರೆಕ್ಟ್ ಆಗಿರ್ತದೆ 74 ಅಲ್ಲಿ ಬಟ್ಟೆ ಹೇಳಿದ್ರು, ಕೂದಲು ಹೇಳಿದ್ರು, ಬಟ್ಟೆ ಹೇಳಿದ್ರು. ಆ ರೈಟರ್ನ ಸ್ವಲ್ಪ ಲ್ಯಾಂಗ್ವೇಜ್ ಚೇಂಜ್ ಮಾಡಕ್ ಹೇಳಿ. ಎಷ್ಟು ವರ್ಷ ಅಂತ ಇದನ್ನೇ ಬರೀತಾರೆ ಅವರು. ಎಲ್ಲಾ ಕೇಸ್ಗೂ ಕೂದಲು ಹೇಳಿದ್ರು, ಬಟ್ಟೆ ಹೇಳಿದ್ರು. ಹಾ, ಸ್ವಲ್ಪ ಚೇಂಜ್ ಮಾಡ್ಬೇಕು ನೀವು. ಈಗ if I find cases are frivolous, we'll start a new thing of imposition of costs on the complainants. ಅವಾಗಲೇ ಸ್ಟಾಪ್ ಆಗೋದು ಎಲ್ಲ ಫ್ರಿವೋಲಸ್ ಕೇಸಸ್. ಅದೇ ಆಕ್ಟ್ ಆಲ್ಸೋ ಅಲ್ವಾ? ಕರೆಕ್ಟ್. ಅದನ್ನ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿ ಬರೀತೀನಿ ಸರ್. ಎಸ್ ಸರ್, ಗೆಟ್ ರೆಡಿ ಸರ್. ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತೀರಾ ಸರ್? ಹಾಕಿ ಸರ್. ರಿಜಿಸ್ಟ್ರೇಟ್ ಆಗ್ಲೇ ವಕಾಲತ್ ಹಾಕಿದಿರಲ್ಲ, ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕ್ಬಿಡಿ. ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆನ್ 31st in the fresh matters list. ಕಾಪಿ ಕೊಟ್ಬಿಡಿ ಸರ್. There shall be an interim order of stay of all investigation qua the petitioner till the next date of hearing.
Obligations.
Bill number 6.
Petitioner, my lord.
I appear for
85
second
VNS, my
respondent.
lord.
I appear for second respondent.
ನೋಟಿಸ್ ಆಗಿದೆಯಾ, ಸುಮ್ಮನೆ ಬಂದಿದ್ದೀರಾ?
Notice ಆಗಿದೆ, my
I
lord.
filed
We have
wakalat
served it.
few days
Second
back.
respondent and the husband both are present, my
ಏನ್
lord.
ಸೆಟಲ್ಮೆಂಟ್?
My lord, settlement ಇಲ್ಲ, 2 ವರ್ಷ ಆದ್ಮೇಲೆ complaint comes to be filed.
ಹಾ.
15 days criminal miscellaneous has been filed before the family court, my lord.
ಹಾ.
I have been requesting her to come and stay with me. I issue a notice the time she deserts me. ಮನೆ ಬೇರೆ ಬೇಕು ಅಂತ ಒಂದೇ ಅವ್ರ ಡಿಮ್ಯಾಂಡ್ ಇರೋದು. I have a widowed mother, so I am not able to
ಈಗ ಏನ್
provide.
ಪ್ರಾಬ್ಲಮ್ ಸೆಟಲ್ ಮಾಡಿ?
ಆಮೇಲೆ
My party is also.
What is all this?
ಇವಾಗವರೆಗೂ ಮಗುನ ಕೈಲಿ ಎತ್ಕೊಳ್ಳೋಕ್ಕೂ ಬಿಟ್ಟಿಲ್ಲ, my lord. Before the judge, family court judge ಮುಂದೆ ಆಗಿರೋ ಅಂತ ಇನ್ಸಿಡೆಂಟ್.
It's all, no, he is having illicit, there are lot of allegations.
They have not filed for divorce, my lord. ಆ ತರ ಇದ್ರೆ divorce ಹಾಕೇ ಇಲ್ಲ ಅವರು. Maintenance
I will file
ಹಾಕೊಂಡಿದ್ದಾರೆ.
my
ಇದು
objection.
best thing is
I am ready to take her back. I have
no
been
problem.
requesting her.
The best thing is September 8th in the fresh matters list.
My lord, ಅಲ್ಲಿವರೆಗೂ stay ಇರ್ಲಿ.
ಇಲ್ಲ ಏನಿಲ್ಲ,
File my
ಅವತ್ತು ಎಲ್ಲ
objections.
ಮಾಡ್ಕೊಂಬಿಡಿ. ಎಸ್,
My lord, please.
ಕ್ಲೋಸೇ ಮಾಡ್ಬೇಡ ಅವತ್ತು.
No, my lord.
ಎಸ್ ನೆಕ್ಸ್ಟ್.
Seven.
ರಂಗನಾಥ್ ರೆಡ್ಡಿ.
Petitioner is the non-custodial father, my lord. I'm appearing on behalf of the respondent number 2 complainant mother, my lords.
I have filed an application seeking to vacate the interim order passed by this honorable court, my lords. My lords, the offense
Who is that? In settlement?
No, my lords.
Then why both of them are standing?
Pokso.
POCSO, my lords. Section 8 and Section 10 are involved. Conveniently, the father who has approached this honorable court files a petition without disclosing any of the medical documents that have been produced before this honorable court while seeking modification of the order. It is portrayed before this honorable court that the only reason for the institution of a criminal complaint is to circumvent the visitation orders passed by this honorable court. However, my lords, if I may request my lords to kindly take my application seeking vacating the interim order, my lord. If I may only request my lords to ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಒಂದೇ ನಿಮಿಷ.
Please. If I may, my lords, this is portrayed or projected in such a manner that this is a one-off incident wherein the mother has tried to circumvent the orders passed by this honorable court in a writ petition in which they were granted visitation, my lords. However, this has been a continuing aspect that is practiced by the father. And in order to establish this, my lords, I have filed document number 1 affixing, which is attached along with the IA, my lords. If I may request my lords to directly come to page number 13. Are my lords there?
Yes.
Please, my lords. Para number 8 nalli, sub-para number 1. If I may read that, my lords.
Yes.
During the period of interim custody, to give a little bit of brief, my lords.
Don't read it. I'll read it here.
Please.
Yes, tell me.
My lords, this was objections that the mother had filed before the trial court when they had sought for the visitation, my lords. However, I have clearly detailed here that the child was subjected to unnecessary, inappropriate physical touch by the father himself. And this is one aspect that I would like to bring to the notice of this honorable court.
So what? In which proceeding is this?
This is in the GNWC proceedings instituted by the father before the family court. If I may
What
only-
is the order of the court?
The court rejects it. The court rejects the application filed by the
Now,
father.
in whose custody is the child?
The child is in the custody of the mother, my lords.
All right.
And along with this, I would only request my lords to kindly look at the doctor's report. I have produced it at page 24 and 25. ಏನಾಗುತ್ತೆ ಸ್ವಾಮಿ ಇಲ್ಲಿ, the child comes back from visitation.
ಒಂದೇ ನಿಮಿಷ.
Please. Objectives ಕೆಳಗಡೆ ನೋಡಿದ್ರೆ ಸ್ವಾಮಿ ನೀವು.
Wait.
Please.
ಆಮೇಲೆ
Objectives ಕೆಳಗಡೆ ಸ್ವಾಮಿ, redness seen in perineal area.
ಅದನ್ನ ನೋಡ್ಕೊ.
Please. The pediatrician that is whose report is produced at 24 does not stop there. She says, please consult a gynecologist.
All right.
Due to which we also consult a gynecologist.
Where is that?
25. She also says that
I'll read that.
Please.
Yes.
Under such circumstances, we are here before this honorable court that the child is complaining and she is completely terrified of even approaching the or going back to the father, my lords.
Cloud9.
Please, Cloud9 Hospital. Under such circumstances, if this interim order is allowed to continue, then the very objective of POCSO Act will be defeated, is my humble submission, my lords. The child has come back and complained of certain discomfort with respect to her private parts under such circumstances. Please.
Yes, Rangnath.
Please. But in fact, pursuant to the order passed by this honorable court, which is, my lord, forthcoming at in page 26 of my petition. But there were 6 dates, my lord, on which, my lord, the petitioner was permitted to exercise his visitation rights from 10 a.m. to 5 p.m. But thereafter, once he exercised his 3rd day of visitation, now this allegation came to be made the next following day. That is on 18/5/2016. The complaint which is forthcoming at page 22, my lord. My lords may kindly peruse the complaint. At page 22, my lord. Lord, in the complaint, if my lords may kindly peruse the The second paragraph, my lord, at page 22.
Hmm.
As per High Court direction, no, this is all on the factual side of it. Page 23, my lord. When the child was written by her father, so and so, the child was upset and feeling low. After inquiring the child about uneasiness, she pointed out towards her private parts, complaining about the difficulty to sit comfortably. I took her to Cloud9 Hospital on 18/5/2026.
Who took?
The mother.
Hmm.
Mother is the de facto complainant.
Correct.
Please. It was confirmed by the doctor that there was exorcisation and redness of vulva. The child was so and so. On suspicion of so and so, kindly register the case and bring the culprit under the law and provide us justice. I strongly suspect Prithvi and his family members, Kiran Sunku, the father, Gayatri mother, Dharti Sunku, the sister, involved in this crime. So the paternal grandfather, paternal grandmother, paternal aunt, and the father, my lord, are accused of.
All are accused petitioners here.
All are petitioners. All are petitioners.
Pokso alla ಅವ್ರಿಗೇನ್ ಸರ್ ಸಂಬಂಧ?
My lords, under,
That apart,
with respect to
the
that.
first allegation.
Why have you invoked Pokso against the grandmother, grandfather?
With respect to that, my lords.
Why, sir?
Please, my lords, if I may make the submission. My instructions are that under, when the complaint was being lodged, the question that was posed to the de facto complainant was that, whom do you suspect? To which.
Grandfather
No,
also,
to which
grandmother also.
Please, if I may complete, my lord. To which she answered, the child visited the father as per the court's orders, and ಆ ಮನೇಲಿ ಯಾರ್ಯಾರು ಇದ್ದಾರೆ ಅಂತ ಹೇಳಿ ಅವರು ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ.
ಅವ್ರ ಮೇಲೆಲ್ಲ accused?
ಇಲ್ಲ, ಆ ರೀತಿ ಅಲ್ಲ ಸ್ವಾಮಿ. ಆ ರೀತಿ ಅಲ್ಲ.
There should be some limit.
I bow down before this honorable
Your
court.
bona fides will be suspect if you go on doing all this.
No, my lords. And so far as that is concerned, I bow down before this honorable court.
Yes.
Not that apart. Bald and reckless allegations, my lord, were made.
No,
in
wait.
Family court.
That's all right. Family court bidi will resolve the issue.
Please.
Make Cloud9 a party here.
Please.
Implicate Cloud9.
Please.
Let the doctor of the Cloud9 who checked this child file an affidavit.
Please.
Madi.
But in so far as vulva and exorcisation
Yes,
is concerned.
Archana madam.
Lord, what would this exactly mean is the.
Whatever, let the doctor file it.
Please. No, just to bring it to the notice of the.
You appear for Cloud9 alva. You take notice, implead Madi, then take notice. There is serve a copy. Both of you serve a copy.
Please.
Get an affidavit of the doctor who has examined the child
Please.
as to what has happened. We'll decide the issue.
This is a dangerous trend, my lord, that is.
No,
fast
that is
emerging.
precisely why I want the hospital to come in. Yes.
The trend is fast emerging, my lord. No
No,
father would be
that is
safe.
precisely why I want the doctor who has examined the child to file an affidavit of the examination along with the
But
records.
even on the face of it, my lord, if the medical report is to be believed, kindly, my lord.
ಅರೆ ಆಯ್ತು ಅವ್ರ affidavit ಹಾಕಕ್ಕೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್? ಹಾಕ್ಲಿ ಬಿಡಿ, ಆಮೇಲೆ ತೀರ್ಮಾನ ಮಾಡುವ. Yes. In so far as the others are concerned, definitely there is no case. Only the husband will be retained.
Please,
If there is something.
Please.
Yes.
Please.
Others gone. Sumsumne don't drag every family member into the POCSO case also.
No,
But it is the new 498A. my lord.
No, that's
Also,
all
it's
right.
The new 498A.
No, ಅದು ಇನ್ನೊಂದಿದೆ, ಅದು 354 ಇದೆ. Yes.
Date may kindly be
Please,
fixed.
in short date.
Serve, both of you serve the objections and the copy both. Implead ಮಾಡಿ ಈಗಲೇ. Cloud9 Hospital. Address ಅದರಲ್ಲೇ ಇದೆ.
Please.
The petitioner is directed to implead the Cloud9 Hospital as a party respondent to these proceedings. The counsel Archana KM, who represents Cloud9, is directed to accept notice for the respondent petitioner and the respondent to serve respective set of copies of the petition and the objections to the counsel Archana KM. An affidavit of the doctor who examined the child as found in the report shall be filed before this court by the next date, 27th, fresh matters.
Unless there are two doctors, one
Whoever,
pediatrician
both
and
are
one gynecologist.
Cloud9.
Please,
ಅಲ್ಲೇ
please.
ಇದೆ, ನೇಮ್ ಇದೆ madam ಅಲ್ಲಿ. From them you just get what has happened. Yes.
Grateful.
Carry out the amendment.
Yes, ಈಗಲೇ ಮಾಡಿ.
Please.
Yes. List 27th, fresh matters. Interim order of any kind subsisting will continue till the next date of.
Grateful.
Yes.
8.
Private complaint filed, my lord. He has not filed
2
affidavit.
weeks IVO. Yes, next.
Stay ಇದೆ sir.
ಅದೇ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿದೆ ಸರ್. ಬೇಡವಾ? ಮತ್ತೆ
Number 9.
The petitioners are foreign nationals, my lords. They want to go back to.
You want to go back?
Yes, my lords.
Where? SOP, Aditya.
Your Lordship, I accept notice for respondent number 3. As per SOP, Your Lordship has passed orders in criminal petition 10772 of 2026. The same order. Similar orders.
Number is okay.
10772 of 2026.
Same order.
Same order, Your Lordship.
Same order.
State SOP is there, state
Disposed.
committees are there.
Whatever, disposed in terms of the same order. Ellide order? ನೀವು ತರಬೇಕು ತಾನೆ? ಎಲ್ಲಿದೆ? ಕೊಡಿ. SOP ಪ್ರಕಾರ to appear before the committee first.
Committee, please, Your Lordship.
Yes.
Number 10.
Please. Withdraw it. With liberty to file a charge. Adavul.
ಏನ್ ಮಾಡ್ತೀರಾ?
We will withdraw it.
Withdraw. ಆದ್ಮೇಲೆ ಮೂರ್ ಇರ್ಬೇಕಲ್ಲ?
10 and 12, my lords.
10 and 12. ಎಲ್ಲ ಆದ್ಮೇಲೆ ಬನ್ನಿ.
Please.
Yes.
Discharge.
Discharge.
Please.
Discharge format ಎರಡು. Yes.
11.
Petition plus the dispute matters arising out of business transactions plus last date of hearing matters ಅವರು ಬೇರೆ ಅಡ್ವೊಕೇಟ್ ಬೇರೆ ಮ್ಯಾಟರ್ಗೆ ಅಪೇರ್ ಆಗೋರು ಬಂದು ನಮ್ಮ ಕೇಸಲ್ಲಿ ಅಪೇರ್ ಆದ್ರು.
ಅಡ್ಡ ಹಾಕ್ಬಿಟ್ರ ಎಂಟ್ರಿ ಮಾಡ್ರ ಕೊಡೋದನ್ನ?
ಎಂಟ್ರಿ ಮಾಡ್ರ ಕೊಟ್ಟಿದ್ರಿ, ಅದು
ನಿಮ್ ಕೇಸ್ ಅಲ್ವಲ್ಲ ಅದು?
CMP pending ಇದೆ matters as well as matters they are initiated check bounce.
The meantime, yes. Next. ಈ ಸರಿ ಯಾರು ಇಲ್ಲ.
13.
406, 420.
Appear for the petitioner.
ಇದೆ 92.
Factory side. Connected matter, my lord.
My lord,
Connected matter ಅಲ್ಲಿ?
Connected matter is regarding the crime registered by the police of the mishap occurred. For that it has been stayed. Here the petitioner has been hauled as the accused number 2 as a factory manager, which she was not on the specific date. She has been made an accused under the Factories Act. Agreed by that, my petition, I filed it. The stay which has been granted is for the criminal case filed against the private contractor who has taken the contract of execution of work in the power corporation. The petitioner herein is a superintending engineer. She was earlier working in Jog and transferred from Jog to Bidadi. On fateful day, she was on leave. On 5th, when the incident has occurred, she has come back and she was not declared as a factory
Now,
manager.
you were in charge of the affairs, you are the contractor. Then?
The commissioning has not yet happened. It's the handover from, my lords, the person who is in charge of the factory has not yet happened to me, my lords. I am the person, my lords, who will run the plant eventually. That this, my lords, is the waste to electricity plant, my lords, which after the handover, my lords, I will run the plant. In fact, my lords, as against me, under the Factories Act, my lords, the private complaint has been filed. That proceedings, my lords, is now stayed by the revision court. The order taking cognizance has come to be stayed. My lords, my petition is only on the fact that, my lords, IPC offence and, my lords, factories offence against the same person cannot, my lords, parallelly go on. And I'm covered by, my lords, judgment.
IPC is already registered.
Yes, my lords, but
Now under the Factories Act, the other accused are also bought in.
No,
FIR lu ide. No, under the Factories Act, both can go hand in hand. It's not that.
They can go parallel in nature.
Yes.
My submission is, as on the fateful day, I have been hauled up as factory manager, which I was not. I even on document.
Had you not assumed charge as a superintending engineer there?
I have assumed charge as a superintending engineer on, though I have assumed the charge as a superintending engineer, intimation of my responsibility as the factory manager has to be intimated on factory.
You take that it is not intimated at all.
Then I'm no way connected with that.
How can I escape liabilities?
No, my lord, I am not, because on the fateful day I was on leave, number one. Number two.
Thing is, you had assumed charge.
No, I have
Assumed charge prior to the fateful day.
I have not.
Correct. ಅಲ್ಲ ಹೌದಾ ಇಲ್ವಾ? ಚಾರ್ಜ್ ಅಸ್ಯೂಮ್ ಮಾಡಿದ್ರೋ ಇಲ್ವಾ?
On 5th, even the documentation on 5th I have assumed charge.
What is the date of the incident?
4th.
Then if charge is not even taken charge ಅಂದ್ರೆ ಆಗಲ್ಲ.
According to your lordship, you see the synopsis, my lord. The petitioner takes charge of this place on 2012-2024.
Transferred, not charged. Transferred.
2012-24. When did you
24.
take charge?
Fifth. Fifth, I have taken charge. Even fifth, the intimation to the factories inspector was given under form number 7. In that, form number 3. In that, as a superintending engineer, I have signed it, but I have not been intimated as a factory manager, which is a separate proceedings. By virtue of superintending engineer, I will not become a factory manager.
No, that's not, I'm not on that. Had you assumed charge or not anyway?
No,
Yes.
I assumed charge on
Heard
fifth.
the learned,
I assume charge, no, your lordship, is the one
on
from
20th itself,
20th itself, your lordship, is a synopsis.
synopsis biಡಿ, document ಎಲ್ಲಿದೆ?
Their own petition, my lord.
Document of assumption of charge.
Page 1, their own petition, transfer on 12/12/2024, joining this place on 20.
Applied, one was granted.
My lord,
Joined KPC gas power pursuant to the transfer or joining report did not designate the appointed petition factory manager.
This is prior to the.
Applied for leave on 1/1.
1/1 for vacating a resident from Jog to Bangalore.
Assumption of charge is not on 5. It is on 20th itself.
No, my lord, kindly pay though.
Document ಕೊಡಿ ಅದಕ್ಕೆ. Where is the document?
Page 456.
Existing factory manager on 20th. It's been backdated. On 5th.
Page 456.
Annexure K.
Annexure K.
It's been backdated.
Backdated.
Date of appointment is.
Date of appointment of the new manager
On
20th 12/2024.
Correct.
But it's been backdated. Because this has been
But-
filed on 5th.
This report has been filed on 5th.
After the incident.
After the incident, they have filled the report. In that, they have stated 20th.
The only issue is,
The only issue
how
is,
can escaping liability ಅಷ್ಟೇ ಬೇರೆ ಏನಿಲ್ಲ. ಈಗ ಯಾರು ಡೆತ್ ಆಗಿರೋದ ಏನು?
death, accidental death of 5 persons.
5 persons.
5 persons.
Yes, sir.
What happened, my lord? It was a contractor given to outsource the employees are doing it. There was a factory, occupier of the factory, and I was transferred
This
there.
was a Sunday.
On Sunday, this annexure K, which had been given on 5th of next month, on the date of when the
No,
intimation.
intimation may have been given. You assumed charge on 12th.
No, my
On
lord.
20th, you took leave from 1st.
My assumption of charge as a superintending engineer
We'll answer that.
is
We'll
not
answer.
correlated with the
We'll answer that.
factory's
We'll
manager.
And what is your case?
My lords, my case, my lords, is on the score that, my lords, once the proceedings under, my lords, the Factories Act is already initiated, my lords, because the punishable offense, what is alleged against me,
Oh, you're on that score that once Factories Act is initiated, IPC offences cannot spring?
parallelly, because, my lords, my lords, I'm covered by my lord's judgment that, my lords,
What
because
My lord, rule is very clear. Rule 7 is very clear. Subclass 4.
No, 5 people have died here. That's the thing.
lords, we come to the first.
Our citation, take the file.
ಅದು ಕಾಪಿ ಕೊಡಿ ಅವ್ರು, SPP ಅವರು ಕಾಪಿ ಕೊಡಿ. That's what I've held.
In fact,
We'll see.
there are judgments, my lord, I'll place.
ಇಲ್ಲ
those
ಅದಕ್ಕೆ this needs to be
Yes.
2022 ಧಾರವಾಡದಲ್ಲಿ ಬರ್ದಿರೋದ್ರ ಬಗ್ಗೆ.
My lord,
22, correct.
rule 7 is very clear. Whenever anybody assumes the charge, kindly peruse rule 7 of the Factories Act 7, section 7,
Madam, Factories Act
subclass 4. Whenever a new manager is appointed, the occupier shall send to the inspector of written notice of chief inspector a copy within 7 days from the date on which such person takes over charge. If I have assumed charge on 20th, their occupier is duty bound to send the intimation.
We'll see.
7 subclass 4 failure of this.
Sir, failure adu idu irli. Lives are lost. 5
No,
people have
lives
died.
are, my lord, lives are lost. There is a contract employees have died.
Whoever, sir, life
No,
is lost, whether it is a contract employee or a permanent employee.
Human life is very
Human
precious.
life is precious,
Very
it is
precious.
lost.
But at the same time, for the offense not committed by me, why
We'll
should
see.
I?
Not completely convinced.
No, my lord, I have been the scapegoat, even the judgment of
Kodi,
your lordship.
Ella kodi. Yes.
He may have not reported, my lord, that
No, that's
doesn't
what,
mean that-
whether non-reporting would take away the position of the occupier under the sections.
No. Reporting has been done on 5th immediately.
5th immediately, Allah. 20th you have taken
No,
charge.
the presumption that occupier is deemed a superintending engineer, is the deemed factory manager, that presumption is wrong, my lord, because it
We'll
has to
see.
be intimated within, suppose if I have taken charge on 20th, occupier is duty bound to intimate within 7 days. And failing which, occupier has to continue. And another thing, kindly peruse my para 12 of the, para 11 of the page number 12 of the judgment, my lord, kindly.
Which judgment, sir?
First judgment.
Prabhakar Shastri avarda.
Prabhakar Shastri.
Justice Prabhakar Shastri. Yes.
Para 11. A reading of the said section would go to show that no doubt the occupier is under the obligation to send the inspector a written notice to the chief inspector in 7 days from the date on which there is a taking over charge of the factory, and if he fails to do so, the occupier himself would be treated as the manager of the said factory.
We'll see. Yes. Monday haki. List on Monday in the other judgments code. Monday on the fresh matters list. Yes. Yes.
My lord, two aspects, my lord. Once, though I have been transferred as a superintending engineer, by virtue of my position, I will not become a factory manager, is my first claim of submission. Second thing.
In 304A proceedings, you are an accused?
No, I am not an accused.
Yes.
In 304A proceedings, I am not an accused.
Only you are the accused.
No, in 304A, they say company personals and unknown other people. So they have not.
What is the mishap? What is the mishap that happened? Fly catcher.
That spilled over on the people who are cleaning the manhole, and that spilling
Manhole.
there is a place, the place.
Who went inside the manhole?
Not the manhole, it's a place to clean the blockage. What happens is
Clean what?
the blockage. Once the
How do you clean the blockage?
by somebody has to go physically there and clean it.
Why?
Because it's a very narrow space to clean it. So one or two people will
No, you still send human beings down.
Yes.
To clean? To clean the block. Avurdalla, one nimisham.
It is like
Cleaning of what? Furnace?
Furnace. It is a furnace. I say manual because it is in the nature of a tunnel where they'll have to go and clean it. Here the ash which is there in one of the components above, it spilled accidentally and it fell on the people. These are after the burning of the waste, which will cause the steam thereafter. That spilled over. That was the accident.
It was not an accident. The door shelter was not closed and not locked. And knowing well that it is not closed, it is not locked, the people have sent. That has collapsed and then came. It is not accidentally, it was not.
So how did 5 people die? All 5 were inside the cleaning the furnace?
To clear the
you don't have machinery to clean it?
My lord,
Well, Allah, a human hand can do it, a machine can't do it. Why? The human beings can go in? No, what do you mean such? See, a human being can go in a furnace with all protection or no protection and clean the furnace and come back. Machine cannot do it, or you're just sitting following conventional method still. What is being done? Let's see.
No, my lord, we have given all the details of manufacturing.
You don't worry, sir. I mean, a larger picture. We'll see. Yes.
The incident happened on 4th, they updated on 5th and they scapegoat.
No, nothing will be detached, sir. Right? Yes. No problem. Don't worry about it.
No,
Yes.
my only submission, when the incident has occurred on 4th, 5th the report has been done. 5th I was not a factory manager. Statutorily, even on 4th also I was on leave. I was not a factory manager. So I cannot be hauled up as an accused in this case. If at all, accountability is from the occupier, not by me, my submission.
So earlier occupier.
Earlier there was a manager. What this thing, the earlier manager has not been, it has not been surfaced in the document for the reasons best known for them.
The manager who got transferred on 20th December 2024 has to be brought back and then prosecuted. That's a submission.
Yes, we'll see. Yes. But this method of getting the furnace cleaned by human beings by letting them inside the so-called manhole, I think must stop forthwith.
No, my lord, it's the entire new technology.
Is the new technology, yeah?
Solid waste management has been used to generate power.
Correct, sir. Why, if the machinery can do it, why a human being should go down and do it? Lives are lost like this.
Technology has improved.
Technology has improved and still in the conventional way. We'll see. Let's the matter on Tuesday at 4:30 p.m. for further hearing. Yes. But don't take any coercive steps. ಅಲ್ಲ entry order ಇವ್ರಿಗೂ ಕೊಟ್ರೇಣ. List the matter on Tuesday at 4:30 p.m. Companion petition ಅಲ್ಲೂ interim order ಇರಲಿ. That's Tuesday larger picture we have to decide.
No, I agree, my lord, but only thing is that.
The only concern is about human lives.
No, I agree. Yes. Human life is precious in nature. At the same time, innocent cannot be galled up with the case.
No, the thing is that how have you let them into the furnace? Let me see. If that is the only method that is there, you better change it. Yes, we'll see. Yes.
Indulgence.
1:30, yes.
My lord, yesterday, my lord, petitioner has taken into custody, my lord, without following the due process, my lord.
Monday?
Monday, please, my lord.
Monday. Sorry. ನಿಮ್ದು ಮೆಮೊ ಇದೆಯಾ?
That will be complied today, my lords. Petition ಆಗಲ್ಲ ಸ್ವಾಮಿ. Until and unless, my lords, your lordship order on the listing, petition number won't be numbered, my lords.
One matter civil in nature, my lords.
Urgency ಏನೋ?
Lords, civil suits is pending, my lord. On Monday, I'm just. Fresh matter.
FR?
Fresh ಅಲ್ಲ. Fresh ಅಲ್ಲ, check ಮಾಡಿ.
Pronouncement of order, list one, still number one.
ಫ್ಲಾಗ್ ಹಾಕಿದ್ದೀವಿ ಫ್ಲಾಗ್ ಹಾಕಿದ್ದೀರಾ ಫ್ಲಾಗ್ ಹಾಕಿದ್ದೀವಿ.
Bill 1156 of 2022 and the Bill 1164 of 2022. The references are allowed. The order of Lawrence single judge dated 29/11/2021 possible petition number 228 of 21 and 229 of 2021 is set aside and the petitions are allowed in entirety. The final notification is 3/10/18 insofar as it concerns scheduled lands owned by the appellant stands quashed. It is declared that the appellants are entitled to all consequential benefits which flow from quashment of the final notification. Consequently, pending applications, if any, also stands disposal.
Bill number two.
Petition is allowed. The input notification dated 30/10/18 insofar as regards to the land of the petitioner subject land stands quashed. All further steps taken pursuant to the issues of the final notification also stand quashed. The petitioner is declared entitled to all consequential benefits that will flow from the said order.
Being spoken to ಅಂದಿರ್ಬೇಕಲ್ಲ.
Being spoken to.
ಏನ್ being spoken to? ವಿಶ್ ಎಲ್ಲಿಗೆ? To the single judge. This court on 2/7/2026 had passed the following order. The learned counsel appearing for the petitioner moves a memo of being spoken to on the score that the matter ought to have been remitted to the hands of the learned single judge, as what was called in question is not the acquisition but the quantum of compensation. In the light of the said circumstance, the order dated so and so stands recalled. The petitioner liberty ಕೊಡೋದು ಅಷ್ಟೇ. The petitioner is at liberty to move the appropriate bench for the relief that he has sought in the subject petition. Ordered according. ಹೌದು. Which order? Only in so far as structures. No, that we will clarify. Then we'll post these all the matters on 27th. We'll clarify en masse. En masse. We'll clarify that because Apex Court has directed status quo only in so far as structures are concerned. Yes. No, that will clarify. Not ನಿಮ್ದ್ರಲ್ಲ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಮುಂದೆ ಹೋಗಕ್ಕೆ ಎಂಟ್ರಿ ಮಾಡ್ರಲ್ಲಿಂದ ಬರುತ್ತೆ ಕಾಂಪೆನ್ಸೇಷನ್ ಅದು ಅಕ್ವಿಸಿಷನ್ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಸ್ಟೇಟಸ್ ಕೋ ಏನಕ್ಕೆ ನೋ ಇನ್ ಬಿಟ್ವೀನ್ ಯು ಹ್ಯಾವ್ ಟು ಗೋ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಅಷ್ಟೇ ಅದೆಲ್ಲ ಅಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ ತೊಂದರೆ ಆಸ್ ಫಾರ್ as this is concerned it's disposed. Yes ಅಷ್ಟೇ ಮೇಡಮ್. ಯಾವುದು? ಹಾ. ಏನ್ ಬೇಕು ಸರ್? ಯಾವತ್ತಿಗಿದೆ? ಮಂಡೇ ಮೂವ್ ಮಾಡಿ ಬೆಳಿಗ್ಗೆ. ಮಂಡೇ ಮೂವ್ ಮಾಡಿ ಬೆಟರ್ ಹೇಳ್ತೇನೆ. ಇಲ್ಲ ಕೊಡಿ. ಮೆಮೊ ಹೋಗ್ಬಿಡುತ್ತೆ 3 days. ಅದು FR? ಏನ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ತೆಗಿಬೇಡಿ ಅಂತನಾ? ಆಲ್ ರೈಟ್, ಎಸ್.
List number 3, orders. Number 1 to 19.
All these are faceless matters.
Please, Manoj.
We'll go before this. Arvind, those faceless matters ಎಲ್ಲ earlier order ಏನ್ ಮಾಡಿದ್ರೆ go before the. ಅದಲ್ಲ ಸರ್, ಥರ್ಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅದು. ಹೌದಾ? ಯಾವ್ದು? ಟೊಬ್ಯಾಕೋ? Then ಒಂದು ನಿಮಿಷ. ಲಿಸ್ಟ್ ನಂಬರ್ 3 ಅಲ್ಲ, ಸೀರಿಯಲ್ ನಂಬರ್ ಇದೇನು? ಅಷ್ಟೇನಾ? ಅದು ಕರೆಕ್ಷನ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅದಿರ್ಲಿ. ಇನ್ನೆರಡು ರೀಕಾಲಿಂಗ್ ಅಪ್ ಟು 17 ಮೇಡಮ್ ಎನ್ ವಿಜಯ್, ಅಪ್ ಟು 17 ಸೇಮ್ ಆರ್ಡರ್. ಇಟ್ ವಿಲ್ ಗೋ ಬಿಫೋರ್ ದಿ ಆನರಬಲ್ ಜಡ್ಜ್. ಎಸ್ ಮೇಡಮ್. ಹಾ, correct. 148A faceless. I had passed some orders. Then the apex court has sent it back, or division bench, or whatever. ಅಲ್ಲಿಗೆ ಹೋಗ್ಲಿ, ಅಲ್ಲೇ ಮಾಡಿ. ಅಲ್ಲಿ ಮಾಡಿ ಮೇಡಮ್, ಟ್ಯಾಕ್ಸ್ ಬೆಂಚ್ ಅಲ್ಲೇ ಮಾಡಿ, ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡಿ, ಎಲ್ಲ ಅಲ್ಲಿಗೆ ಹೋಗ್ಲಿ. Correction. What correction? Nobody is here. Anyway, list these matters on 28, 18 and 19. Recalling ಇದೆ.
19 ಅಲ್ಲಿ ಮೈಲಜ್ 19 ಅಲ್ಲಿ ರಿಕಾಲಿಂಗ್ ಇದೆ.
19 ಸೇಮ್ ಆರ್ಡರ್, ಅಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು. ಅದು 18 ಒಂದ್ ಬಿಟ್ಟು ಮಿಕ್ಕಿದೆಲ್ಲ ಅಲ್ಲಿ.
ಅಬ್ಲೈಜ್ ಮೈಲಜ್.
ಎಸ್ ಸರ್.
List number
ಅಲ್ಲ,
list number 1.
ಒನ್ನ
ಅಲ್ಲ, list number 2, 110 fresh matters at 2:30 PM.
Hello, why was the IO asked to be present? And you have complained it to the IO? What is the IO doing? Who is he? 1 minute, who is he? Is he the IO? Where is the IO? We'll ask the Commissioner of Police to be present. Yes, sir. Where is the IO? Where is he? This court on 12/8/2026 had directed the investigating officer of the station house, investigating officer or the station house officer of Turuvannur Police Station, Chitradurga, to be present before the court. He is neither present nor has filed any exemption for being absent. Therefore, the earlier Commissioner of Police, the Superintendent of Police be present before the court on Monday at 2:30 p.m. Superintendent of Police of Chitradurga Zone Ayanadu. Chitradurga be present before the court on the next day, on Monday at 2:30 p.m. The ಆಟಗಳು ಆಡ್ತಿದ್ದೀರಾ ಇಲ್ಲಿ. Who is this man? Who asked him to come? ಏನ್ ASI? He has sent ASI ಅಂದ್ರೆ ಅದಕ್ಕೆ ಬರ್ಲಿ. Let the SP come. Yes.
Further hearing 2:30 PM, 111.
Indicated that the first petitioner does not figure in the charge sheet.
A charge sheet file ಮಾಡಿದಾರಾ?
ನಮ್ ಕಾಪಿ ಸಿಕ್ಕಿಲ್ಲ ಇನ್ನು. We have not received any.
Then we'll take it on 28th.
My lord, there are certain objections that we have to the charge sheet because they have taken witness
Not here,
statements.
you should file it
The
there.
trial court, so that's what my lord,
Yes,
we
that
wanted to
you
seek
can-
permission to.
That you can do always. Whatever you want, you can do there. Then we'll close this.
Yes. Allah, in the sense.
Allah, in law, whatever liberty they have, they have.
If your lordship is going to record that the first petitioner is dropped from the charge.
I've already recorded that.
Oh, then.
Last time orderly record ಮಾಡಿದ್ದೀನಿ. First petition is already dropped. Therefore, the charge sheet be filed before the concerned court. I've already recorded. You want me to read it? ಯಾವತ್ madam? 11/8.
Maybe lordship made an oral observation. So
ಹೌದಾ?
when Vinay says it was not dictated.
Vinay is saying ಅಂದ್ರೆ ಇಲ್ಲ ಅಂತ.
Lordship had in fact first mentioned that it will be recorded. Then your lordship said first you file it in the trial court.
ಈಗ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ? ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ? ಆಯ್ತು. This court on will dispose it, reserving liberty to them to have recourse to law. The complainant's rights.
Yes. After
I
observing that.
cannot curtail the complainant's rights anyway.
No, but would your lordship observe that the first
That I will
petitioner.
say, yes. This court has from time to time passed spate of orders, SPAT. The orders read as follows. The investigation stands complete and the charge sheet is filed before the concerned court. The charge sheet drops the first petitioner from the array of accused, retains the second petitioner, and charge sheet is filed before the concerned court on the second petitioner. The counsel for the complainant submits that the complainant has objections to the dropping of the first petition number 1 as well. Therefore, reserving liberty to the complainants to take recourse to law if they are so aggrieved by the filing of the final report before the concerned court, the subject petition stands disposed. The liberty further is reserved to the parties to knock at the doors of this court in the event of need in future.
Grateful.
Yes. I think that should be fine.
Much obliged.
Alla, illi I can't say why did you drop, why did you do it, it's not.
Appearance.
Of course, yes. The madam, heard the learned additional Solicitor General of India, Arvind Kamath, along with so and so. ಆಮೇಲೆ ಅವರು. That's the only method available.
Yes.
I can't sit and decipher why you have dropped them, why you have dropped them.
Very grateful.
Senior counsel.
ASG or as ASG or senior counsel?
Yes,
Yes,
DRDO.
correct.
Defense.
DRDO, yes.
It's under the Ministry of Defense.
Yes, yes, yes.
112.
ಇದು tobacco.
Gutka.
Hookah na tobacco na?
Tobacco.
Hookah?
Section 3A of Central Excise.
The same like pan masala.
Yes, like more or less, Your Lordship, but there are some differences, Your Lordship, in terms
In
of the
Arvind?
provisions.
AG sir is going to log in.
Venkatraman sir.
Venkatraman sir.
Is
Sir
ready?
has requested that if sir completes the argument, he will reply on 28th.
And absolutely no problem. Then we'll pass it over.
I'll take about 45 minutes, 1 hour.
Then I'll have to finish and then.
That's what I'm saying. 45 minutes
no
to 1
problem.
hour. That's
No,
the-
45 minutes to 1 hour. Too much.
No, that's the maximum limit, Your Lordship, I keep to myself. May I conclude it even earlier?
Yes, yes.
Great.
Much.
Let's continue.
2:30 ಯಾವ್ದಿಲ್ವಾ?
330.
Huh?
330.
3:30 ಯಾವ್ದು? 114 is at 3:30. ಕರೀರಿ.
113.
But before 113 starts, let me clarify one misunderstanding, my lords. I never mentioned.
No worries,
in court-
sir. No worries.
No, but
at all.
I must
Yes.
clarify my position. I
No,
never
no, sir.
mentioned in number one, my
Never
lord, I
ever,
never
sir.
mentioned.
No,
All-
even if
all-
that we'll never ever think anything, sir. That's not
No, no,
good.
but
You
I
won't have to
never
worry about
mentioned,
that.
I would be the last person to mention that it has to go before. I said all the matters to come before one court. Unfortunately, in the note, it was mentioned that, but I never mentioned that it has to go to another court.
No problem, sir. No problem. Not at all, sir. You need not clarify it also. Sir. Yes, sir. Raju, sir, I'm not saying today. Yes, sir. Yes, sir.
My lords, 113, they may argue, my lords. I will reply if my lords give me a short date, my lord, today. I
Yes,
have
sir.
some-
They will finish their submissions. For your submissions, whenever you want, you can take it, sir.
I'll give the date, my lord.
Lord,
7th,
113 lords.
Idu.
Last time, lords compilation I had given.
Is it possible if my lords can give me 7th, my lords?
Yes, sir. No problem, sir. 7th of September.
7th of September.
Yes, sir. Yes, sir.
Yeah.
At 4 p.m.
4 p.m.
Yes,
Grateful.
we'll do that. You finish your arguments.
Lords, I had given my list of authorities and the
It is here, sir.
reasons to believe. First, I'll take it, lords, because the search is under section 17.
Correct.
Lords, the reasons to believe is furnished to us subsequent to the filing of the petition. Can I just, Lord, so far as I am concerned, Lords, the chain of events, what they are trying to make out is, Lords, under section 7, there was a trap case as against one Mr. Manjunath. Sorry, Jagdish Naik.
Yes.
Now, Lords, from Jagdish Naik, the reasons to believe order says, if your lordship takes that reasons to believe, my lords, they talk at 1.3 and 1.3 the trap. But if your lordship turns proceeds of crime which they have recovered in the trap as against Jagdish Naik, please come to point number 6. That's my lord's page number 4. The lordship will find the difficulty in page number because it's in the bottom.
ಅಲ್ಲ ಇಂಕ್ ಪೇಜಾ
ಅದು ಇಂಕ್ ಪೇಜ್ ಮಾಡಿಲ್ಲ ನಮ್ಮವರು.
ಮಾಡಿದ್ದೀರಾ? ಇಲ್ಲ ಇದೆ ಪೇಜ್ ಸೈಡ್ ಅಲ್ಲಿ ಇದೆ. ಇಂಕ್ ಪೇಜ್ 10 11 ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದೀರಾ? Lord 6 clause 6.
ಅಲ್ಲ ಇದು ಪ್ರಿಂಟೆಡ್ ಪೇಜ್ ಹೇಳಿ ಕೆಳಗಡೆ ಇರೋದು.
4 my lords.
All right. Yes, I am there.
On top, your lordships would get 6. Subsequent complaint received at this office and allegations therein.
Yes, sir.
Now they say subsequent to the recording of the ECIR, this office received a written complaint forwarded to the Director Enforcement Directorate and received in the Bengaluru Zonal Office on 19/5/2026 seeking investigation under the Prevention of Money Laundering Act 2002 against Sri Y.D. Manjunath, Additional Commissioner, State Excise Department, Karnataka, Belagavi. The complaint alleges that the said officer has acquired
movable and immovable assets grossly disproportionate to his known sources of income, and that such assets have been accumulated. That's their thing. Now, my lords, kindly see the table at 6.3.1, bottom page 5, my lords. There's what is known as family and Benami layer.
Right. What do you want to?
No, the chain, how they, my lords, because 17, my lords, says reasons to believe. Now, reasons to believe is this. Now, your lordships cannot decide on the reasons to believe if there are grounds. But whether there is belief, the chain of judgments which I, my lords, have placed before my lords would show the court has the jurisdiction to see whether there is any belief. Lords, because I am appearing, my lords, in 113 for one Yamuna, not Manjunath or anyone else. The petitioner is Yamuna.
Manjunath is not the petitioner here.
In the other matters.
All right. Yes.
I just wanted to show your lordship 6.3.1 table at page 5.
I am there.
They give the names.
ಹೌದು.
ಅದರಲ್ಲಿ ಫಸ್ಟ್ ಒನ್ ಅಣ್ಣಪ್ಪ ಅಂತ ಬರುತ್ತೆ.
ಹೌದು, ನೀವಿರೋದು page 6 ಅಲ್ಲಿ ಇದ್ದೀರಾ.
ಇದೀನಿ. ನಾವು ಅದರಲ್ಲಿ ಐಡೆಂಟಿಫೈ
ಕ್ಲೋಸ್ ಅಸೋಸಿಯೇಟ್.
Alleged close associate of YD Manjunath, former excise.
You are not a public servant.
I'm not. My lords, I was working in the excise department. Then, my lords, I have taken voluntary retirement somewhere in, my lords, 2025 May. And the fact of the matter, in my petition, I've said I had worked under Jagdish Naik for a brief period in 2010. That's the only thing, so far as I am concerned.
Purported connection.
So they say alleged close associate of YD Manjunath, former excise minister, inspector, designated partner with YD Annappa in Haripriya Consultants, LLP, Malleshwaram. The last one is alleged association with YD Manjunath. They say direct documentary partnership link with Annappa in Haripriya Consultants, LLP, establishes association. That's now, my lords, please turn over to CDR analysis at page 9, clause 7.
Page?
Internal page 9.
Clause 7.
7.
Yes, sir.
7.2. My lords, the link, because this is the link which they are relying on. The critical link as per CDR, FIR accused Jagdish Naik and the complaint subject, Manjunath, please see.
Was in contact.
Lords, CDR contact. Andre, Jagdish Naik, our mel predicate offense irodu. Trap case, 7 ಅಲ್ಲಿ.
ಮಾತಾಡಬಾರ್ದು ಅಂತಿದ್ಯಾ?
ಮಾತಾಡಿರೋದು ಎಷ್ಟು ಅಂತ your lordships will get now.
300 seconds.
Lords, I have calculated total call for 1.5 years from their thing.
1.5?
For 1.5 years, 6.5 minutes, their own thing.
Alert. Period of 1.5 years.
Please see the period during 18/6/24 to 1/10/25. Lords, the trap is somewhere in 26. January 26. So this CDR is 18/6/24 to 1/10/2025. Total talk time about 332 seconds. That is, my lords, in that also they have divided. In, my lords, 6.5 minutes, 4 minutes is spoken to in one call on 18/6/24.
This is season to believe. Yes.
Now, then, my lords, your lordship may kindly turn. They talk about the calls with the excise minister, all those things. My lord, I'm not bothered. Then again, your lordship may kindly come in page 10, just above the chart, unnumbered second para from top. It is further noted anta shuru agutte.
What is this dated?
Lords, this is reasons to be believed must be before the search only, my lords. It is dated 25/6 anta.
Search munchane. It is 23rd July 2026. Alla.
Date irodu 25/6 anta ide.
Yes, heli.
Lords, the second unnumbered para, again, my lords, it said, it is further noted that examination of CDRs, again they give CDR of Jagdish Naik and Manjunath, which is about 1,805 4 seconds. Now, my lords, that call of 4 times on 23/9/24, as per their chart, is for 4 minutes.
All right.
Then next page at 7.4, after 7.4, your lordships would get another chart of who all had spoken. We are not for any of them, they are not there. But if your lordship sees those calls also, what I am seeing, my lords, from 24 May to 26, so far as Meligiri, whom I am not concerned, they say in lakh seconds they give 1.2 lakh seconds. Anta. That is for 2 years, 35 hours. I have friends here within 1 month. I know, my lords, I have lawyer friend who will complete conversation of about 2 hours in 1 day. So, my lords, 24 seconds, some 30 seconds call, 6
ಡ್ಯಾಮೇಜಿಂಗ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲ ಮಾಡಬೇಡಿ.
ಅದು ಇವರಲ್ಲ, ಬೇರೆಯವರು ಇದ್ದಾರೆ ಅಂದಿದ್ದು. Lords, then, ಏನ್ ಬೇಕಾದ್ರು. Lords, your lordship, my learned friend want me to read page 9, last para, bottom 9, bottom para, unnumbered para.
Yes.
This contact anta shuru agatadu. If your lordships have page, internal page 9.
Yes.
This contact is significant because Sri Jagdish Naik is the Deputy Commissioner Excise Bengaluru and the main accused in the predicate trap, while YD Manjunath is the Additional Commissioner of Excise for North Karnataka and the principal subject of the subsequent complaint.
But one factum is admitted that the only predicate offence is offence under 7A.
7.
Against Jagdish Naik. There is no other crime registered.
And that the reasons to believe, first thing itself says that the amount which was recovered, that is already seized. It's a trap case
from Jagdish Naik.
From Jagdish Naik. So, so far as I am concerned, from all this, there's nothing except to say that I'm in partnership with Manjunath's brother. That's the only thing, my lords. This is the background. Now, my lord, 17, if your lordship says, I don't know, if your lordship just glances 17, the words used are reasons to believe.
I have considered it in extenso and Gamescraft.
Gamescraft. Yes. Now, my lords, I've given one compilation, if your lordship takes that compilation. On the reasons to believe, my lords. The first one is 1960 SCC Online SC10. That's Calcutta discount, which, my lords, reason to believe, I think, is still holding the field from this judgment, where they say, my lords, reason to believe is not reason to suspicion. My lords, the other judgment which I just wanted to point, I have given the para numbers 5. Can I take your lordships?
There are many others.
No, I have given, my lords, the others also. Even Delhi High Court, my lords, has please come to the second judgment at page number, running page 26.
Even Arvind Kejriwal,
Kejriwal also there
explains
compilation
that was concerning arrest, but what is reasons to believe is amplified.
Lords, this Deputy Commissioner of Income Tax.
There is, I think there is a line. Reasons to believe can never become reasons to suspect.
That's, lords, from Calcutta discount. If your lordship takes, that is also culled out in Rustagi, my lords, if your lordship takes for a moment, running page 26. That's a division bench judgment of Delhi High Court. ಅದು ಕೇಜ್ರಿವಾಲ್ ಕೊಟ್ಟಿದೀವಿ ಹಳೆ ಕಂಪೈಲೇಷನ್
ಹಳೇದಿದೆ ಇಲ್ಲೇ
ಅದರಲ್ಲಿ ರನ್ನಿಂಗ್ ಪೇಜ್ 26 ತಾವು ಒಂದು ನಿಮಿಷ ತಗೊಂಡ್ರೆ
ಅದೇ ರುಸ್ತುಂಜಿ ರುಸ್ತಗಿ ಇಂಜಿನಿಯರಿಂಗ್
yes my lords, that is my lords by the division bench. In that para 21 where they say, if your lordship culls it out, para 21 they say reason to believe is not reason to suspect. That is following the Supreme Court's judgment, and also there should be some live link or a close link. And that's what is reiterated in Kejriwal's judgment, my lords. Ultimately, that was 19, which also uses the word reason to believe. 17 uses the words reasons to believe. 5 also uses the word reasons to believe. My lord, the only thing is the courts have consistently held, if there are grounds, you don't need to go, but the belief can be definitely be interpreted. These are the lines of judgments, my lords, Kejriwal and the other judgment also. In fact, the other judgment which is given, the compilation, that is by the Delhi High Court again, then was headed, now the present Chief Justice's judgment under PMLA itself. That is reiterated. So our case is, my lords,
that Mahavir.
Please. And that has attained finality to best of our information because that's not been
No, that was
challenged.
not challenged.
That is not challenged. That's the line of thing is reasons to believe is not, even if it is there, nothing, there is no belief at all. That's how the Supreme Court's hold. You can't go behind it, but you can definitely interpret. There is nothing so far as this Yamuna is concerned. And that partnership today, because of this entire episode, I have to close down also because I had entered into contracts. My lords, I had to return. Of course, in their seizure in my house, they seized 1.85 crore cash in my house. We have said my income tax return shows cash on hand. The returns itself shows my annual returns is shown with cash on hand because I'm in the business of liquor.
So everything happens in cash?
Lords, there is cash transaction and income tax return shows cash on hand. It is, my lords, that is 2 crores is shown as cash on hand as on that day. That is a different aspect. But to link Jagdish Naik into Manjunath in the Inyargo, there's absolutely no live link at all. That's the sum and substance of so far as 113 is concerned.
They've just connected the dots.
But there is no dot is my, the submission is there is no dot. They are trying to make a line.
Yes, sir.
May I just take a supplemental role, Mulats? My learned friend has dealt with some of it. I just have.
I don't think he'll accept that. Yes.
I don't think I'll only accept as a supplementary role.
Yes, sir.
What I wish to do, Mulats, and I don't wish to carry coal to Newcastle. There are short propositions, and I wish to just make my submissions. The first, as an elementary proposition for myself as a student of money laundering law, is that without scheduled offense, there cannot be any action under the PMLA of any nature whatsoever. Now, here is a case where an action under section 17 has been initiated. The test remains the same, whether it is a 17 action, it is a 5 action, it is a 3 and 4 action. The test still remains, is there a scheduled offense to which it is relatable enough for it to reach the threshold of reasons to believe. Now, when I ask the enforcement directorate this question, when I came to this court, the threshold was crossed in the form of a press release which has been put with my petition. We did not have access to the ECIR, etc. And the press release indicated to your lordships that this is a case where we are looking at a large-scale corruption in the department where everybody is under investigation for crimes that are being committed or are being perceived to be committed. If there is an FIR of that nature, that may or may not allow the enforcement directorate to enter into this territory and treat everybody as having possible proceeds of crime. In terms of FIR, which is the threshold that Vijay Madan Lal Chaudhary tells us to follow, it says without FIR, without there being an investigation of the predicate offense, there should not be anything else. When it comes to the FIR, your lordship's query that we are here, is there any FIR other than that FIR for 7A? The answer is no. A particular individual asks for a particular amount of bribe to undertake a particular transaction. That bribe is paid, and according to them, it is caught at the time when the transaction is taking place. Because there's a larger issue here which I don't wish to trouble your lordships, but it's very interesting. In trap cases, how can there be money laundering? When, according to me, the proceeds of crime, which is the amount which has been transacted as a bribe or as illegal gratification, the proceeds of crime are stillborn. They are born in the moment they are actually seized or protected. So from a larger standpoint, even this 25 lakhs, could there have been a situation of proceeds of crime or not is one question. But here is a case where we are not connected to that 25 lakhs in either prior or subsequent action. The case that is now put up in the reply that has been filed is that the entire department, the money has to be transacted between different people at different hierarchies, and hence I am entitled to investigate. My understanding, Lord, again as a student of the law, is we must follow the money trail. We must follow everything and anybody who has touched it, who has dealt with it, who has in any manner, there are various adjectives, Lords, in section 3, in section 4 of the PMLA, anybody who has done anything with reference to those proceeds of crime. But those proceeds of crime are defined and definite. They are the 25 lakhs which have been transacted in the instant case. But your lordship's view in Parvati, the SLP dismissed. I don't, again, as I said, there's a lot of what I have to say. In fact, on the reasons to believe, I don't need to look beyond your lordship's judgment again in Gamescraft, where your lordship say it is more than suspicion, less than conclusive proof, based on tangible material. And so I can't put it better than that, and that's why there's no. I find myself very short of words that I can actually contribute, and that's why I said let me make it very short and simple. The last part, and significant, there are only two parts. One is the fact that the FIR in question does not pertain and hence does not give jurisdictional basis. But the second is the reply makes for very interesting reading. What it says is that on 19th of May 2026, I, as the Enforcement Directorate, received a complaint. And I received this complaint. Their lordships will just note page 38, para 42 and 43 of their counter affidavit, which will say that I have received a complaint qua the petitioners. Please just have this for a moment.
Yes.
Page 38, paragraph 42. Further, before the searches in question, the directorate.
Yes.
I'm so sorry.
Yes, and there.
The directorate received a detailed written complaint on 19th of May 2026, repeated by email on 1st of June 26, against petitioner number 2, additional commissioner for excise in North Karnataka, based at so and so. Complaint alleged that although he does not assign himself so and so, he controls excise licenses, makes applicants settle with him before their files move, collects money regularly, so on and so forth. Paragraph 43, complainant appeared. So it is evident that in the reply, it is demonstrable that actually the action being initiated or taken against me has nothing to do with the predicate offense which is indicated in the document, nothing to do with that FIR, but some other complaint that they have received from 19th of May. If that be so, please follow the same test as Vijay Madan Lal Chaudhary to say, till the time this particular complaint fructifies into an FIR, the question of starting an investigation under the PMLA or any proceedings under the PMLA would be a misadventure. To link it to a different accused and dovetail it into their particular investigation would be worse. But most importantly, the Enforcement Directorate has the power under Section 66. That power has not yet been exercised. So in anticipation of everything, in my humble submission, this entire position, complete lack of jurisdiction, is the only phrase that comes to mind in the proceedings that have been initiated by the Enforcement Directorate. The last portion, Milords, as I said, this particular paragraph 4, para 6 was read to your lordships of the reasons to believe. If your lordships just mark paragraph 4, which actually defines what the predicate offense for this case is, and that predicate offense is restricted only to these two issues.
Yes.
3 small sentences I'll say, and I'll conclude with that, Milords. Whether reasons to believe should be given to a person at any stage, not done. Whether videography in terms of CRPC being dovetailed into this, not done. Both in the exercise of jurisdiction, in the existence of jurisdiction, or in the exercise of that power, there has been a complete fault. The last thing was your lordships passed an interim order, and I pointed this out on the last occasion. Your lordship said not to precipitate the matter in any manner. Despite that, the Enforcement Directorate has gone ahead and filed an original application for confirmation of this action under Section 17. My submission is it should not have been done. So I would request your lordship, since the Enforcement Directorate is likely to take time for their reply, the lordships may specifically stay that position also. Otherwise, they will come and say that, oh, now the adjudicating proceedings are going on, etc., so on and so forth. So I am submitting that your lordship's first order protects me enough for this action not to have been taken by them, and your lordships will just clarify that position as well. Those are my submissions.
Yes.
to us on the last date. I don't know, my lords, who has served the reason to believe. We have not served them reason to believe.
The council has not served. It is
To
the
the-
ED has served.
My lords,
That's
ED
that's the
has,
submission.
my lords, ED has served because we have not served them. That's what our instruction is. We
No.
have not served them.
Our affidavit hakli.
We have not
Hello,
served
you have
them.
not served.
Reason to believe.
Hello, your officers have not served on him.
No, my lords.
Your officers have not.
It's an internal doc. We have not served.
Well, that
Then how?
my learned friend may take instructions as
Yes.
part of
We have got
the
it from registered post is my instructions. Let
No,
them
no,
file
what
some
I-
affidavit.
I'll
Through
indicate what has
registered
happened.
post. My lords, I'll take
As-
it to my officer.
As part of the original application filed
We
before
To
the
registered post.
at page
Yes.
15 of the original application filed by them before the adjudicating authority, copy of which has been supplied to us under an index. The reasons to believe have been provided. Neither have I manufactured them nor have I obtained them illegally. They have.
What is
It
this,
is.
man?
We'll check, my lords, because so far as my
Why come up with such submissions?
we have
Where
not-
will they get the reasons to believe of that flows from your office?
From PMLA. ED ಇಂದ ಸಿಗೋದು ಅಂದ್ರೆ ಅದಕ್ಕೊಂದು predicate offense ಆಗಿ
Yes. But why are you precipitating with the adjudicatory proceedings?
what that complaint might have been filed, my lords, where there was no stay.
Huh.
I will clarify, my lords.
Yes.
I'll clarify. There was no stay, my lords, when this complaint.
Now
might
there
have
is
been-
an interim order
My
now.
lords, I think when this was filed, that point of
I'm
time,
sorry.
the was not.
It was filed on 23rd of July 26. This is after your lordship's order.
No, there was no stay. my lords.
Yes. They heard the learned senior counsel Siddharth Agarwal appearing for the petitioners and learned senior counsel K.N. Panindra representing few of the petitioners in all these cases along with so and the learned Raju sir
Yes, ma'am.
and the learned additional Solicitor General of India Sri S.V. Raju along with so. The learned senior counsel Siddharth Agarwal would submit that the respondent enforcement directorate should not go ahead with the proceedings of attachment before the adjudicating authority as they are, notwithstanding the orders passed by this court of not taking any precipitative action against the precipitative action qua these petitioners. The learned counsel Anupama Bhanuparna submits that the proceedings may have begun at the time when there was no interim order, but would undertake that no precipitative action would be taken till further orders would be passed at the hands of this court. The submission is placed on record. The learned additional solicitor has sought time up to 7th of September, September the 7th, 2026, for his reply submissions. List the matter at 4 p.m. on 7th of September 2026 for further hearing.
Right. Yes, we'll come.
I am obliged.
Yes, sir.
I am obliged.
Huh? ಅಲ್ಲ ಸಾರಿ ಅದು ಹೇಳಿದ್ನಲ್ಲ ಕಂಪ್ಲೀಟ್ ಸಾರಿ ದಿ ಲರ್ನೆಡ್ ಅದು ಮಧ್ಯದಲ್ಲಿ ಹಾಕೊಳ್ಳಿ ದಿ ಲರ್ನೆಡ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಶ್ರೀ K.N. Panindra completes his submissions and would reserve his right for rejoinder submissions after the submissions of the learned additional Solicitor General of India. ಅದು ಹಾಕ್ಬಿಟ್ಟು ಆಮೇಲೆ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಹಾಕಿ ಸಾರಿ ಸರ್ ಎಸ್ ಫ್ಲೋ ಅಲ್ಲಿ ಒಂದೊಂದು ಸರಿ
For us also, your lordship may note that I have concluded and.
Sir, yes, sir.
Your lordship may also note that I have also concluded and my
Completed. Both your submissions have already noted.
I'm obliged.
Yes, completed the submissions. Yes, heard in part. List on place for further hearing on 7th at 4 p.m. Yes, sir. Interim order subsisting shall continue till the next date. 3:30 to current.
Further hearing,
3:30 na idu karpidi.
114.
Lord, this is the matter, my lord. 19-year-old psychiatric person tied to a pole and was assaulted.
Yes, sir. SPP ಅವರೇ.
My learned friend made a serious statement against Superintendent of Police who was present.
He displayed the video also.
Display the video, but he did not give a context in which that video was being captured.
Yes.
Mob of about 400 people are gathered in the village, surrounding by the village, because of whatever incident happened. The superintendent of police was somewhere else, came there to pacify the situation. While pacifying, he made the statement. That statement cannot be taken as out of turn and make the statement here.
All right, we'll take it. How was a person of unsound mind tied to the pole and beaten?
We have, in
What
fact,
what is the investigation that you have conducted
investigation
on that
is done, my lord. In fact, my lord, we are the people rescued him. We rescued.
Who beat him?
Villagers.
What action have you taken against
We are investigating. They had given names.
100 names were given last time.
100 names have given. We have circulated the name. In fact, the videos are also. We have asked him to identify the people with the video. In fact, there are videos. He need not give the names. There are videos.
An identification parade ಬೇಕಾಗಿಲ್ಲ because
there are videos.
Videos ಇರೋದ್ರಿಂದ you have to track
Names
them.
will not help us because the videos are there. We are asking the people to identify these people and then take action. And my learned friend has to assist us.
We are not.
He has identified only 3 people or 4 people, my lord. Then there is one other issue, my lord. There is a medical reason. We have been asked. I can.
What medical reason?
His client as a medical reason. The doctor advised us not to show the photographs to him.
All right.
Lord, he is suffering from a bipolar disorder.
All right.
Lord, from prior to this particular, on the date of incident itself, he is under medications and pursuant to this.
He is the one who was beaten.
Yes.
Was the one who was beaten.
So there
Now,
is a
please, my lord, I
report,
was
my lord,
being
which
told
says that,
and instructed, please, my lord, to say that, please,
fact,
my lord,
your
for
lordship,
the
this is
another
a-
period of 3 years is concerned, he has to be kept under, my lord, medications is concerned.
Because of this.
No, no, no. if we
Prior
have
to
the-
that, my lord, he
there is-
was suffering from a bipolar disorder.
No, but what all my request, my lord, my learned friend should have been fair enough to say that when we went there and we have rescued the
Lord,
people.
no
and
doubt,
then-
please, my lord. Even I'll also today, I'll make a statement.
SP's role, you leave it, no problem. But this man beating a person, tying him to the pole, beating a person who was of unsound mind is
it's
those
not correct,
people. No, the persons who have done it must be brought to books.
That's correct.
Your lordship may kindly for a moment, kindly see the status of the complaint in the complaint itself. He says, please, my lord.
No, what's the investigation
In
conducted?
fact, my lord, I got the entire text of this, the SP's speech on that day. Your lordship may see, it is not that.
I too will see. But
in fact, my lord, I've been told in a earlier occasion when similar incident happened, there are the riots in the district, and the SP has successfully prevented that.
It's all right, that we'll see. Now, this is an ancillary issue now, with the main issue being this. And what's the investigation?
The investigation, we recorded various statements. The only person, my lord.
No, now in such cases, it should not proceed at a snail's pace.
No, it's not, my lord.
It should.
Yes.
It should proceed fast.
I've been told, my lord, no
Objection
notice is also issued to
on the
those
next date of
persons who have been named.
No notices.
It is what my instructions are, my lord.
No, I'm saying.
Only, my lord, the petitioners were taken to the hospital is concerned. The investigating officer, my lord, sought the, my lord, permission of the doctor to, my lord, to investigate the petitioner is concerned. Doctor has reported to the, my lord, investigating officer, do not show at any point of time, do not show those particular videos nor the photographs. My lord, why? Because his situation may worsen for another period of 3 years. Pursuant to the incident, please, my lord, he was under medication for 1 month is concerned under psychiatric department.
I will.
No, in fact, names he has given, my lord. He has given entire village name. We need not go into the names because the videos are there.
Okay,
That
everything,
itself is-
videos are there. You just have to nab them and
identify the
bring them to
people.
books, that's all.
Identify the people and then book them in this thing. That's all is required. And
No doubt.
since your lordship has protected them.
No doubt, my lord,
100
it is
people's
an
name
instance of
ಏನಿದೆ ಅದ್ರಲ್ಲೆಲ್ಲ ನೋಡೋರ್ನೆಲ್ಲ ಬರ್ದು ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಯಾರು ನಿಂತ್ಕೊಂಡು ನೋಡ್ತಾ ಇದ್ದಾರೆ
I have
ಎಲ್ಲಾರನ್ನೂ
the other
ಸೇರಿಸಿ
videos.
100 people's name ಬರ್ದು ಕೊಟ್ಟಿದ್ದಾರೆ
Yes.
No doubt, please, my lord, at the instance of the police, petitioner was secured. But please, my lord, the speech of the SP is as what
No,
is-
that's all right. That we will consider later. Transcript is here. I will consider it.
144, my lord, was imposed.
Wait, sir.
Yes, but in all earlier occasion where similar incidents have happened in the district, there are the riots in the district.
I thought. No, I am not
My
saying.
officer has
We will
prevented
see. We will see what the SP has done right, wrong later. First, You
That's
have to
correct.
catch hold of all those people who have beaten this man.
Your lordship has protected them.
Yes.
Lordship vacate the protection, we will also arrest them.
What protection?
Not to take coercive.
Your ಮೇಲೆ.
ಇಬ್ರು ಮೇಲೆ.
ಅಲ್ಲ, I am an unsound person, please.
ಅವ್ರ ಮೇಲೆ ಏನ್ ಮಾಡ್ತೀರಾ?
Two case ಅಲ್ಲಿ ಇದೆ partnership. That is what I initially also.
ಅಲ್ಲ, only the unsound mind ಅವ್ರಿಗೆ ಮಾತ್ರ protection.
Then the lordship clarify.
ಅಷ್ಟೇ ಅಲ್ಲ, ಯಾರಿಗೂ ಏನ್ ಸ್ಟೇ ಇಲ್ಲ.
Before the 2 days, before the incident.
This court on
medical slip
37/20/26 had passed the following order. Again, the following order on, 24/6 first, Amal 37/26. It is clarified that the interim order would operate only against the petitioner, Chandru Nadu.
Chandru, please.
Petitioner Chandru and not any others. All the others shall cooperate with the investigation. Indian Bank.
Lordship, that's clarified.
Cooperate with the investigation. The report of the investigation be placed before this court up to the date that it is conducted. List the matter on 2nd September at 4 p.m. for further hearing. ಇದು ವಾಪಸ್ ಕೊಡಿ SPP ಅವರು. ಇದು ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಕೊಟ್ಟಿರಿ, ಹಂಗೆ ಆಮೇಲಿಂದ ಕೊಡಿ.
Those paper, the papers also lordship can keep.
ಇಲ್ಲ, ಫೈಲ್ ಅಲ್ಲೇ ಇಟ್ಬಿಡಿ. Yes. Next.
115.
ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ಸ್ ಕೊಟ್ರೆ ನಾನು ನೋಡ್ತೀನಿ whether it would match the video
No, I can give.
statement.
ಕೊಡಿ, ಅದಕ್ಕೇನು, ನೋ ಪ್ರಾಬ್ಲಮ್. ಎಸ್.
ಅದು ಒಂದು ಲಿಸ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲ, ನೀವು ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಮೇಲೆ ಒಂದು ಸ್ಕ್ರಿಪ್ಟ್ ಬರಿಬೇಡಿ.
ಇಲ್ಲ.
And I don't know why my learned friend about sent here, but I
Illa, my lord, this
I have not.
my lord, I was on the point of the statement is concerned. It is no doubt, please, my lord, at the instance of the police, my lord, petitioner was secured alive.
All right.
But the
Yes.
statement is
Otherwise,
what, my lord.
otherwise he would have been beaten.
And
There are other videos, please, my lord, which I would also, my
no,
lord.
and my learned friend may not know.
Is concerned. My lord, father gave a statement the otherwise.
Mm-hmm.
My lord, he was.
Reason is that by imposing the 144, the petitioner was escaped from the custody of
ಎಲ್ಲ
the public.
ಎಲ್ಲ ಕೈಗೆ ಬರ್ಲಿ, ಆಮೇಲೆ ಬರೆಯೋಣ. ಏನ್ ಬರಿಬೇಕು ಬರೆಯೋಣ. ಎಸ್. ನೆಕ್ಸ್ಟ್.
Please, my lord. My lord, on the previous occasion had directed the Hebbal police station to produce the bank statements. We have also tried to, we pulled out 2 bank statements. One bank statement I still cannot because the phone is still with Hebbal police station.
ಫೋನ್ ಅಲ್ಲಿ ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕಂಪ್ಯೂಟರ್ ಅಲ್ಲಿ ಇರುತ್ತೆ, ಫೋನ್ ಅಲ್ಲ. What is this?
My lord, phone.
Don't try to put flower show here.
Not at all. Only one statement. Only for one.
ಎಲ್ಲಿದೆ ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
911/6 of 2025.
ಕೊಡಿ, ಕೊಡಿ, ಅದಿಲ್ಲ. ಎಲ್ಲ ಬರೀ ಇದೆ.
That case, I have filed a statement of objections.
And what is under, one ನಿಮಿಷ, what is under challenge?
The FIR, my lord. Only what, so what I'm.
Fine. Yes, we'll answer it on merit.
Please, one submission, one submission, my lord.
We'll
I'm
answer
not,
it on
my
merits,
lord, I'm not going anywhere else. One submission which I'm
No
making.
problems. Sir?
My lords, my kindly
ಈಗಲೂ
see my.
ಫೋನ್ ಅಲ್ಲಿ ಇದೆ, ಏನು ಡೀಟೇಲ್ಸ್.
Phone is with them, my Emirates
Sir,
ID is also with
please
them,
sir,
my lord. I have two.
ಬ್ಯಾಂಕ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿರೋದು ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಇರಲ್ವಾ?
2, my lord, I have one more.
2 ಅಲ್ಲ, let it be 10.
My lord, I don't have the last.
Why you don't have the last ಅಂದ್ರೆ?
Trying to get one.
What
Only
trying
one
to
more
get?
is
Go
there.
to the bank and get it, sir.
My lords had given a direction on the previous
No,
occasion.
don't worry about it. I'll answer
Lords,
on
can you
it.
see the
No
previous
problem.
order?
No problem.
My lords, can you see the previous order, my lord?
No problem.
My lord, I'm not saying I'm not giving it back. My lords,
No
can you see the
worries.
previous order? We'll have to just reconcile what amounts are
No worries.
balanced.
Yes, heard reserved. Yes.
My lord, balance amount I'm ready to pay, my lord. My lords have to just see the previous order.
My lord, may I make one submission?
Yes, sir.
The lead case in this, my lord, in which they are given 9 to 10 posted checks, those are also bounced.
File 138.
Yes, my lord, this is your lordship's order. Your
Kotti
lordship,
Deve, my lord. He's in constant touch with us.
let them, my lord, say that they
I
have
can show
repaid.
that also.
I have the 2 checks
I've
which
paid
are
that
bounced.
also, my lord.
The lordship's order, my lord,
Give it, sir.
giving liberty to reopen the case.
That's the case, but it may be reopened, my lord.
Checks would get dishonored for whatsoever reason, the entire crime would get revived. It's dishonored now?
Yes, my lord.
Oh,
5
revive
lakhs,
it.
my lord.
Yes.
5 lakhs only is
Revive
remaining.
it, no problems. Even
That
a
is the
rupee,
case.
even a rupee will end up in revival.
May I
Yes.
make one submission?
Heard
my lord?
reserved, yes.
My lord, make one submission, my lord.
Yes, sir.
My lords, may permit me to make one submission.
No,
That's all.
sir. You can
I'm
make,
ready
sir,
to pay the
whatever.
amount back, my lord. My
No
lords had, on the
problems.
previous occasion, these bank statements had to come only to ascertain what is the amount.
Yes.
Whatever that amount is, I'm ready to repay it. I'm not shying away from it, my lord. It's only one
very
bank
good,
statement, my lord.
absolutely, sir. Ad nauseam, it cannot be repeated,
Lord,
sir. There should be some
only
limit. Yes.
one bank statement.
No, sir.
Two
nothing.
are there.
I'll pass orders and merits. You can't
My
stop
lord,
me for that, sir.
My lord, not that, my lord. I'm ready to settle the matter.
No problems. Nothing. Yes, we'll pass orders and merits. Yes.
my lord, then the amount which I want to repay, if I were to be given liberty at least, my lord, I'll then move the matter. If
Please move, sir. Entire thing you repay the entire
I
thing. and
am,
move
my
the
lord,
matter.
which is why I am. Because insofar as
Admitted amount ಕೊಟ್ಟಿಲ್ಲ.
that is exactly what I'm
There
ready
is
to pay.
admitted amount in the petition.
Well, pass orders
That,
and
my
merits.
lord, the bank statements on the previous occasion, Hepal police station was supposed to bring it.
It's,
If they brought it,
enough. Period.
I will repay
Yes.
it, my lord.
No, pay it, sir.
My lord, it is reserved. That's the only issue, my lord. I cannot move it
ರಿಸರ್ವ್
then.
ಮಾಡಿದ್ರೆ ಪೇ ಮಾಡಬಾರ್ದು ಅಂತಿದ್ಯಾ?
ಇಲ್ಲ, then I'll have to move because I'll have to give a scheme, my lord, as to how I'm going to repay it.
Oh, no problem, sir. Your scheme I've been seeing for the last few months.
I'm not, my lord. I'm ready to make payments
The
there.
scheme is only to take time.
My lord, not to take. I'm not taking time today, my
No
lord.
problem, sir.
I'm not seeking for
Give
time
the
at all.
entire amount, sir.
Please, my lord. So which is why that amount, my lord, because that bank statement, if they give it to
Oh,
me,
bank statement phone ಅಲ್ಲಿ ಇದೆ, bank ಅಲ್ಲಿ ಇಲ್ಲ, computer ಅಲ್ಲಿ
my
ಇಲ್ಲ.
lord, one bank statement only.
Flower show ಆಗಿ ಬಹಳ ಹೊತ್ತಾಯ್ತು.
My lord, it's an Emirates ID, my lord. Emirates ID is also
Kindly see the WhatsApp chat. They have replied that order may be vacated ಅಂತ ಅವರೇ ಹೇಳಿದ್ದಾರೆ. Kindly see the chat. ನಾವು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿ ಅಂತ ನಾವು
ಅದೇನು ನಾನು ವೆಕೆಟ್ ಮಾಡೋದು ಅವ್ರ ಚಾಟ್ ನೋಡ್ಬೇಕು, ಚಾಟ್ ನೋಡಿ ವೆಕೆಟ್ ಮಾಡ್ಬೇಕು.
ಅಲ್ಲಲ್ಲ,
ಮತ್ತೆ
their intention, ಅವರ ಕಾಂಡಕ್ಟ್ ಆಫ್ ದಿ ಪಾರ್ಟಿ.
Yes, yes, heard reserved. Next matter, please.
Just one liberty, my lord.
Next matter, please.
I'll just make a submission if that is the case, my lord. If I'm settling the matter with a joint memo itself or with a memo of payment.
You can anytime move it, sir, before I pronounce.
Because we have,
yes,
that's the only thing. Whatever is remaining, I'll pay it.
Yes, whatever is the demand, you pay, whatever.
No, demand. Last occasion, my lords had clarified saying whatever is the amount which you have to repay, that amount has to be clarified. That's it.
ಅವ್ರಿಗೆ ಏನ್ ಬರ್ಬೇಕು ಅದ್ ಕೊಡಿ.
That's the only thing. Same amount itself. I'll just move it, my lord, because I'm not seeking for time.
Check ಡಿಸೈನರ್ ಆಗಿದೆಯಲ್ಲ.
ಇಲ್ಲ, my lord. We have already made the payment through bank transfer. ಅದಾಗಿದೆ. They're in touch with each other. ಒಂದ್ಸತಿ ಆಗಿತ್ತು. Yes, we made a bank transfer. It is just, my lord, to try and, my lord, prejudice.
ಅಯ್ಯೋ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಎಷ್ಟು ಪ್ರಿಜುಡಿಸ್ ಆಗದ? ಆಗಿ ಪ್ರಿಜುಡಿಸ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ.
My lord, I've always stuck to.
I told you, ad
commitments.
nauseam, don't seek
My lord,
time.
I'm not seeking for time, my lord. I'm ready to make the payment.
Make, sir. ಕೊಡಿ ಈಗಲೇ.
ತಾವು ರಿಸರ್ವ್
ಕೊಡಿ,
ಮಾಡಿದ್ರಿ.
ಬೇಡ. ಈಗ ಕೊಡಿ. I'll give you half an hour's time, make entire payment and come.
Entire payment, my lord. I'll give a scheme as to how I'm doing it.
Scheme is only adjournment.
It is not, my lord. I will
Your
give
scheme I've seen, sir.
I'll
Enough.
give a memo, my lord.
Enough. Yes, next.
I will
Reserved.
place the memo on record, my lord.
Reserved. Yes, next.
Please.
Monday.
Raghavan sir has made a submission.
Monday.
Please.
Nandu.
117.
Yes, sir. You finished your submission.
Please, our side is finished. Mr. Raju was in.
Zoheb sir had to.
Mr. Raju was to continue minutes. He had argued for an hour.
Raju sir is here, I think. Yes.
But I argued the first matter almost, my lord. The second matter, as far as the second matter is concerned, I was supposed to make the submissions.
Yes, sir.
Now kindly have a look at the. Just give me a minute. Okay, make it as bad. But their prayer at page 114.
This is serial number 118. The second matter.
Yes, 117 I have almost completed.
Yes, sir. 117 is over. 118 I am holding.
There will be a slight overlap because when I deal with
Yes,
section 17, I will cover both. My lords may kindly have a look at. But the prayer is at 114.
Yes, sir.
Yeah. Kindly have a look at the prayer, my lords.
Yes.
First two prayers are for calling of the record. Prayer number C, my lord, declare that the search and seizure operation conducted by respondent at the petitioner's office between such and such a date is illegal. That's prayer number, first effective prayer, my lord. And second is D, my lord, quash the freezing order dated 13th of May 26. And the third is declare that all statements recorded during the course of such search and seizure are illegally recorded and all movable assets are seized which are returned.
Yes.
Essentially, the challenge is to the seizure order.
Yes.
The first ground of challenge is at page 48 of their petition, my lord. And that is that the search is violative of Article 7 of Section 17(1),
Yes, sir.
and that information should be based on admissible evidence.
Yes, sir.
But as far as basing that the information should be based on admissible evidence is not a requirement of Section 17. But my lords may kindly have a look at Section 17. Information
Yes.
in his possession. So the inference that it should be admissible evidence, at whether the evidence is admissible or not, is to be decided at the trial stage, not at the stage of search, which is an early stage, which is a nascent stage of investigation. By
Yes.
the time you try to get admissible evidence, maybe the proceeds of crime would disappear. Therefore, at the stage of search, where you are required to seize proceeds of crime, you cannot insist for admissible evidence. When you are searching for evidence, one of the purposes of the search is you are searching for evidence. Kindly have a look at possessing, or not kindly have a look at section, the reason committed any act which constitutes money laundering or is in possession of proceeds of crime. The proceeds of crime itself is evidence. Possession of any records relating to money laundering. So that record itself is evidence. So you can't put the cart before the horse and say, no, you have to have evidence first and then you can do the search. That is not warranted by the wordings of Section 17(1). It may be in a given search, you may not find anything also. The person might have removed everything because he might have come to know of the search. Somebody might have leaked the search, he must have removed it. The search doesn't necessarily involve getting property or getting proceeds of crime or getting records. You may fail in a search, but the purpose of search is an attempt to try to get evidence which based on information. Therefore, this first ground is now kindly have a look, my lord. Therefore, admissible evidence is not borne out by the wordings of the PML Act or Section 17. And that reason, the second ground is that reason to believe must be communicated. Now, kindly have a look at Section 17. Section 17 does not say that reason to believe must be communicated at the time of the search or it has to be communicated at all. I understand the difficulty that even Section 19 doesn't say that it has to be communicated. But the Supreme Court in Kejriwal said that you have to give the reasons to believe. Kindly turn to Kejriwal para 41. Why?
Yes.
Because if a person wants to challenge the arrest, you have to give him the reasons to believe. Kindly have a look at Section 41 of Kejriwal, Manoj. Not section, para 41.
Yes, sir.
Yeah, yes.
My lords are having page 40, para
Yes,
41.
please.
My lord.
Yes,
Once
sir.
we hold the accused is entitled to challenge his arrest under Section 19(1) of the PML Act. So challenge his arrest. There's no question of challenging arrest at this stage.
Yes.
The court to examine the validity of arrest must categorize both the existence and soundness of reasons to believe based on the material relevant with the authorized officer. It is difficult to accept that reason to believe as recorded in writing are not to be furnished as observed above. The requirement 19(1) are the jurisdictional conditions to be satisfied for arrest the validity of which can be challenged by the accused and examined by the court. Consequently, it would be incongruous, if not wrong, to hold that the accused can be denied and not furnish the copy of the reasons to believe. In reality, this would effectively prevent the arrest from challenging their arrest. Questioning the reason to believe. We are concerned with the violation of personal liberty. So at the stage the accused challenges arrest, he may be required to rely on the reasons to believe for the purpose of saying that his arrest is bad. No such situation has arisen in the present case. Now the issue that I would also be required to answer is, what if he wants to challenge this search and seizure? Section 17, because forget arrest, because arrest is not in question in the present case. Search and seizure, maybe he won't like to say that the seizure is bad, release the property. Whether he is entitled to reasons to believe is a question which according to me should be, I should answer. But the act provides for a stage when this is to be given, and that stage is prior to the confirmation by the adjudicating authority. Now my lords will now have a look at section 17(4) of the PMLA Act.
Yes. Yes.
Before that, my lords, kindly have a look at subsection 2, my lords.
Yes.
The authority who has been authorized under subsection 1 shall immediately after the search and seizure or upon issuance of the freezing order forward a copy of the reasons so recorded along with the material in his possession referred to in that subsection. So reasons to believe has to be furnished to the adjudicating authority immediately after the search and seizure in a sealed envelope in the manner as may be prescribed, and the adjudicator shall keep such reasons and materials for the period as may be prescribed. So immediately after the search and seizure, it has to be given to the adjudicating authority. Now, if it is given to the adjudicating authority, after it is given after the search, and if anything is seized, an application has to be made under subsection 4. Now, kindly have a look at subsection 4. Authority seizing any record of property under subsection 1.
Yes.
Or property under subsection 1 or freezing any record of property under subsection 1 shall within a period of 30 days from such seizure or freezing as the case may be file an application requesting for retention of such property, record of property seized under subsection 1 or for the continuation of the order of freezing served under 1A before the adjudicating authority. So if the ED wants the property to be continued, to be frozen or retained, then an application has to be made within 30 days. If it is not made, then probably he might get a right to say that now the freezing order or retention order is bad or it is lapsed. After it is given, Marat, now have a look at section 8.
Yes.
On receipt of a subsection 1, on receipt of a complaint under subsection 5 of section 5 or an application made under subsection 4 of 17 or under section 10 of section 18, if the adjudicating authority has reason to believe that any person has committed an offence under section 3 or is in possession of proceeds of crime, he may serve a notice of not less than 30 days on such person, calling upon him to indicate the source of his income, earning or assets out of which or by which means he has acquired the property attached under subsection 1 of section 5 or seized or frozen under section 17 or 18. The evidence on which he relies and other relevant information and particular show cause why or all any of the such properties should not be declared to be properties involved in the money laundering and confiscated by the central government. So the adjudicating authority is an independent authority, not connected with the ED, Malord, is statutory authority. He gives him the opportunity to say why the property retention should not be continued or the freezing of the property should not be continued. It is at that stage that is required to exercise his right. So at that stage, before he gives a reply, he must be given an opportunity, and at that stage, he may be given a reason to believe. And that is what has been precisely done in this case. So if he wants to exercise his right, in the case of arrest, if he wants to challenge the arrest, in case of seizure of property, if he wants to challenge the seizure, and if he wants the removal of the retention or cancellation of the retention or defreezing, he has to, at that stage, he is affected, and at that stage, he has to be given the reasons to believe, which has been precisely done in this case, because the OA was given to him along with the show cause issued by the adjudicating authority. So the requirement of the statute is not that at the time of the seizure or at the time when you begin the search, you have to give the reasons to believe, is not the requirement of the statute. The statute nowhere contemplates that it has to be given. Similarly, 19 also doesn't contemplate that it has to be given at the time of arrest. But the courts have interpreted, particularly Arvind Kejriwal, the Supreme Court has interpreted that it has to be given because if he wants to challenge the arrest, he should be aware of the reasons to believe. Similarly, if he wants to challenge the seizure or search, that seizure or search can be challenged before the adjudicating authority. At that time, it should be given, and that is what has been complied with. Therefore, there is no non-compliance of, as far as giving of reasons to believe is concerned. The second submission is this. Kindly have a look at Kejriwal's judgment. Kejriwal's judgment, it's not a judgment, it's an order, it's an interim order. It's not finally disposed of.
Which one?
Kindly come to kindly come to page para 92 of Kejriwal rules. In view of the aforesaid discussion.
Yes, sir.
In view of the aforesaid discussion, and as Vijay Madanlal Chaudhary is a decision rendered by 3-judge bench, we deem it appropriate to refer the following questions of law for consideration by a larger bench: whether the need and necessity of arrest is a separate ground of challenge, is a separate ground to challenge the order of arrest passed in terms of 19(1) so and so, whether the need and necessity to arrest refers to satisfaction of formal parameters to arrest and take the person into custody and relates to other persons, grounds of reason so and so. Questions are answered in the affirmative. What are the parameters and facts that are to be taken into consideration for the court while examining the question of need and necessity to arrest? So therefore, this is not a final order. This is an interim order. The questions are left open. So therefore, an interim order can never be cited as a precedent. This is my alternative submission. If my lords are not with me in the earlier submissions which I made, Kejriwal cannot be cited for the reason that it is not a final order. The final order will come when the matter is placed before the larger bench.
Larger bench. Yes.
And in any view of the matter, Kejriwal is not an authority as far as Section 17 is concerned. This is my submission as far as.
That's Section 19.
Yes. It's not concerned with 17. 19 is different. Violation of 19 may lead to violation of fundamental rights. Violation of 17 may lead to not violation of fundamental rights, but violation of Article 300A, which is not a fundamental right. Therefore, 19 and 17 stand on a different footing. And the other is a civil action. The other is a criminal. Therefore, liberty is not involved as far as search and seizure is concerned. Therefore, the reasoning of Kejriwal will not apply. This is my submission as far as this ground is concerned. There, my lords, they said, when I said that there is an alternative remedy, they said that as far as the adjudicating authority is a quorum non juris. Kindly have a look at Section 6. They said there's only one person as an adjudicating authority. Now that has been rectified.
Yes, that is argued in the other matters.
This matter also.
Composition of the tribunal. Composition of the adjudicating authority.
Also at page 82, my lord. Kindly have a look at the petition at page 82.
Yes, sir.
They have raised this ground, Manoj. Yes.
Oh, they've raised this ground also. They've raised this
Therefore,
ground also.
they may not have, if they have not argued not allowed, then I may not, but now
No,
that
they have not
ground has
argued.
become.
Have you argued about the composition of the authority?
We've not argued.
No,
on
no,
this.
that's not, sir.
When they have not argued, then I need not. But today, Manoj,
Yes, sir.
there's a notification.
Absolutely.
I'm obliged. Now kindly have a look at the next point is there. They have argued on Poonam Malik's case, Manoj.
Yes,
Reason
Poonam
to
Malik. Yes,
suspect.
they have argued on Poonam Malik.
Yes. Now kindly have a look at page 245, Manoj, page para 55 of Poonam Malik. It is on the facts of that case. Look at the para 55 minutes. Look at the freezing order minutes.
Page, sir.
Page 245, para 55 minutes.
245 of
their
this compilation.
Of their compilation.
Of their
Compilation.
Now, my lords, please stand.
One moment, sir. Madam, compilation could you?
The present cases, my lords have got it, para 55.
Yes, sir. You read it, sir. I'll get it. Yes.
In the present cases, freezing orders dated 5th of September 2018, passed in the section 17 of PMLA, which are identically worded, have been placed before us. For ready reference, the relevant extract from one such freezing order is reproduced below. Or whereas, on the basis of authorization dated 5/9/2018, issued by the Deputy Director of Enforcement under section 17 of the PMLA, for search and seizure to be conducted by the undersigned in respect of account number so and so in the name of Poonam Malik, maintained in the Delhi State Cooperative Bank, Housecast Branch, Delhi, whereas it is suspected
Their compilation.
that amount involved in money laundering are lying in the above mentioned bank accounts. So that was a case where it was specifically stated that it is suspected.
They have
Now,
relied.
in our case, there's no suspicion. Kindly have a look at page 117, Marot. In our case, if they're involved, there's no suspicion.
No, there it was a case of suspicion, though the Apex Code, that is why it says on suspicion, you cannot indulge in these things.
Yes. So in our case, therefore, on facts, it's different. There it is suspicion. Here it is involved. Kindly have a look at page 117 of my of the rate follows. There's no such. There's categoric admission statement that they're involved. Being involved and being suspected to be involved are two different things.
Yes, sir.
Order freezing under 17(1)(a) of the 2002 Act. Kindly look at para 3, Manoj. Investigation and I'll also got it para 3, unnumbered para 3 at page 117.
Yes, sir.
Investigation of PMLA 2002 during the search revealed that the following bank accounts, escrow accounts, bonds and other financial instruments are involved, not suspected to be involved in the offense of money laundering through the above mentioned modus operandi. So categoric case that is not suspicion but actual involvement. It may be right or wrong, that's a different, but it's not based on suspicion. Right or wrong, you have an alternative remedy before the adjudicating authority, you can challenge it. The facts of our case do not match with the facts of Poonam Malik's case. Poonam Malik's case was based on suspicion and suspicion alone and not involvement, which is different. Now the last submission which they had made is this, Manoj. 32. No? That FIR which we have seen. Now kindly look at
67 other contentious.
Their case is that the 3 FIRs, the proceeds of crime in totals to only 2.26 crores, whereas your attached property was 500 crores. So it is beyond the predicate offense. That is what they argued. Now kindly have a look at the first FIR, which is at page 203. And kindly have a look at page 211 of this FIR. What are the, is it restricted to one individual who has been cheated, or is it a larger, wider, graver conspiracy, graver offense encompassing all those persons who have been cheated? Kindly have a look at the FIR at page 211. This is para 8, my lords. My lords have got it?
Yes. Yes.
Nothing but scamming and stealing from people and labeling them as skill-based games. However, these are scam-based games to lure the public and ruin their lives. So the FIR says it is not restricted to me alone. It is to cheat the general public. So large number of people have been duped. If there are large number of people are duped, it is based on the FIR itself. You cannot say we have expanded the scope of the PMLA by involving something or taking into consideration something which is not the scope of the FIR. This is answer number 1. Now kindly have a look at section 21U of the PMLA Act.
Proceeds of crime.
Proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense. So a very wide and expansive meaning has been given to proceeds of crime. It is not restricted to an individual case. If that individual case leads to is relating to a criminal activity, is also a result of criminal activity relating to a scheduled offense. So all these persons who have been cheated, large number of persons have been cheated, they would all be encompassed by this wide definition of 21U. Therefore, and in any case, this can't be at this stage. You may raise it, but today this can't be raised at this point of time. Otherwise, what would have happened? Supposing there are 5 lakh of people, this would be impractical also, because supposing 5 lakh persons have been cheated, they will require 5 lakh predicate offences. Unheard of. Unheard of. This will be impossible. This entire scheme and purpose of money laundering would be over. I'll tell you, my lords.
One is enough.
One is enough.
One predicate is enough.
All be additional statements under 161. Because the scheme is to cheat everybody. The conspiracy is to cheat everybody. Otherwise, you will have if 5 lakh persons are duped, only one person will say 5,000 rupees files a complaint. You pay him 10,000 rupees, settle then the person was duped. 5 lakh persons go scot-free. That cannot be the purpose and motive of the PMLA Act. One will have to have a look at it from a different angle and interpret this relating to the scheduled offense from this perspective. I think I've covered most of the points.
Yes. Anything in reply, sir?
And then, there is an alternative remedy. Now they have an alternative remedy. Even their objection, which they have not pressed, adjudicating authority will decide all this.
Yes.
Why rush to this honorable court? Ultimately, adjudicating authority will decide. Then the appellate tribunal will decide. Then a statutory appeal before this appellate jurisdiction of this honorable court. And in JSW, the Supreme Court has held that they must be relegated to the alternative remedy, my lords. Now kindly have a look at para 38 of JSW, my lords.
JSW is given.
We have given it to my lords. to the side.
JSW is in the compilation.
Volume 3, volume.
JSW we have separate.
2025 SCC online.
Yes, sir. Yes, it's here. Sir.
2150 para 38, my lord.
Volume 3.
Paragraph?
Paragraph 37 and 38.
Yes.
Paragraph 38, particular 38. Viewed that the appropriate course would be to permit the statutory process to run its route, to reach its logical conclusion. Interference at this stage would prejudice issues that are squarely within the domain of the appellate tribunal, including whether attached property represent proceeds of crime within a meaning of 2(1)(u) or PMLA and whether the withdrawals are in violation of law. So all this can be decided by the adjudicating authority when the show cause notice is finalized, or by the appellate tribunal in case they do not succeed, or by the High Court in the appellate side, my lords.
Statutory process to run its route.
That's all. Proceeds of crime are 19,000 crores.
That's right. In fact, I'm glad he ended with that, Manoj.
But one of the, well, I'm not saying anything, but the proceeds of crime sometimes is reflected by the stature of the lawyers. On the lighter side, or nothing.
Yes, sir. Yes, sir. Correct. Yes, sir.
On the same lighter side, Manoj, this adding zeros is just an argument of prejudice. So if everything else fails, it's a desperation of an argument to say, look at how many thousands of crores. That doesn't answer the legal points, Manoj. Just to pick up the last point, relegate to the statutory processes. I think there are enough judgments now. We've also placed that earlier. Why we come in a 226? Because, Manoj, the impact is so immediate and so severe. Just one instance which he pointed out, 2.6 crores if you add up the 3 FIRs. What is being frozen is 500 crores. It can't be brushed aside by reading that FIR. If your lordship sees the 209, which he read, he has lost, this complainant lost 53,080 rupees. The complainant is saying maybe many people have been cheated. So if the complainant in his complaint simply says many people must have been cheated, then we are supposed to imagine that there are 5 lakh people who've been duped. This is the figure that the learned ASG said. Well, it's a criminal law statute. The criminal law statute admits of only a strict interpretation. I think what is worrying the ED in case after case is the narrow, according to them, a narrow reading of proceeds of crime, whereas they want an expansive reading of proceeds of crime. Because this is the crux of the entire litigation here. If you start reading proceeds of crime so expansively to cover the whole universe, where you reach the threshold of 19,000 crores, I'm sure in a month's time it will cross 25,000 crores. There's no difficulty. But this is the problem, which is why we keep knocking at the doors of the High Court, because we want to say that no adjudicating authority, no magistrate is going to read the statute in the way it is supposed to be read. That is, it's a criminal law statute. You don't expand the definition in the criminal law statute. That's all the principles of interpretation, that is harmonious interpretation, purposive interpretation, never apply either to taxation statute or penal statutes. And your lordships have repeatedly told us this. We are educated by Supreme Court judgments that talk of strict interpretation. And that is all we are saying. Don't expand it to a point where liberty becomes meaningless, where I'm supposed to lose everything that I have. And this is not attaching just my accounts. You're attaching fixed deposits. So if you give yourself a certification in the reasons to believe that this is all these accounts are involved, then according to the learned ASG, the word involved used in his reasons to believe should mean actual involvement. Well, as I'm at a loss to understand how the ED's self-certification should be accepted by a High Court or by any forum as the last word on whether it's suspicion or actual reasons to believe. Well, as your lordships saw the whole schedule, they've attached some fixed deposits. They've attached mutual funds. And the person has not even applied his mind. What is he freezing? And whose accounts is he freezing? Absolute non-application of mind. And we are supposed to take it as gospel truth that this actually constitutes actual material. Well, listen, when is he going to disclose this material and to whom? When he goes before the adjudicating authority, I'm sure the same argument will be there that I'm not going to show it to him, I'll show it to you. Well, this is what is happening in case after case. The actual material on the basis of which reasons are formed are not disclosed.
No, it is already disclosed in this.
No, it's not. The material is not disclosed, my lords. All your conclusions are disclosed. Poonam Malik is very clear, which is why we need to make that careful distinction. You can form so many opinions. You can form so much reasons, but when you knock at the door of the High Court is bound to ask you, okay, show me what is the basis for your concluding these reasons to believe.
Opinion making process.
Absolutely, my lords. The crucial decision making process is at question here, which is why we're saying one easy yardstick is, and he had no answer to this. When the totaling of the 3 FIRs is 2.6 crores, why are you attaching 500 crores? What is that material that makes you say 5 lakh people have been duped? What is that material which now 500 has become 19,000? Well, these are not just imaginary numbers. This is seriously involving people's life and liberty. Well, once you cut off my accounts, my sources of funds, how am I supposed to survive? Well, these are very, very serious issues, which is why this casual use of the law means you're actually weaponizing it. You're weaponizing a law which was meant to be very strictly applied and extraordinary circumstances. Because you're vesting officers who are never part of a police force. You're vesting them with powers, police powers. These are all, every one of this is police powers. And how are you shielding them? You're saying these police powers exercised by these officers will be outside the realm of section 25, 27 of the Evidence Act. Which means a greater caution, Malats. I would only say when you clothe yourself with some immunity, you have to pass a stricter threshold. So when the High Court is told, no, the statement made to this officer is admissible in evidence, which is why we're harping on admissibility. The learned ASG is saying, no question of admissibility at this stage. But prima facie, you have to demonstrate that this is not some whims and fancies of some officer. Which is why I'm saying, Malats, it's very easy to record statements and say, no, in law, these are all admissible, but this cannot constitute the material, Malats. I'm pains to emphasize this. Poonam Malik very clearly says you have to show the materials. And you have to show it when a High Court is asking you. And it can't be this your lines in the reasons to believe that so many accounts are involved. If my lords will see that one page which the learned ASG read, which is page 113 of the paper book, it is just the ED's own statement. Not 113, that first annexure. Reasons to believe. What page? The Lordship turns to 117.
That's the same reasons to believe.
Correct. Investigation during search revealed that the following bank accounts, escrow accounts, bonds, and other financial instruments are involved. Whose accounts? Which bonds? Which fixed deposits? Complete non-application of mind, Malats. Which is why this could be actually a textbook case of how powers are not to be exercised. If anybody wants to know, okay, what can and cannot be done, this is a classic case of what should not and cannot be done and should not be permitted to be done. Malats, I rest my case with that, my learned friends.
Vikram sir.
5 minutes. I, my lord, circulated a note on both the aspects on that day. I hope your lordships have, my lord.
Yeah.
Lord, I am circulating an additional note on both the aspects, concluding note with the Lord meeting the challenges. Just a quick glance, just pass it. Lord, I'll start with the seizure point first, my lord, the freezing point first. So, my lord, we are all ad item today. That, my lord, number 1, if your lordship would just have a look at the notes.
Yes.
Please have a look at, my lord, the summary in, my lord, writ petition 18285 of 26.
Yes.
Now, my lord, I've made a summary. What is the issue? The first issue, my lord, the learned ASG addressed.
There is only one matter. There are 3 persons arguing one matter.
We have many petitioners. Mr. Raju, this is the last objection we expect from you. Mr. Hussain is, my lord, waiting in wings.
Petition is only one.
You are so formidable that
What is the
three of
name?
us can't
Petition is only one person arguing.
Petitioner is arguing each. No.
But the
Each
petitioner should
petitioner
have
is
filed
engaged.
separate petitions. Petitioner should have filed separate petitions.
No. There's no need. My lord, Mr. Raju is super powerful.
No, I'm not
We-
powerful. Why should
We,
I be powerful?
we
I'm
can't
only
match
pointing
his
out
weight,
the
my lord,
law.
so we have to divide the weight.
Law is what is powerful, not me.
None of
You
us
can't
can
have
match
three
you,
persons
sir.
arguing one matter for one petition.
We have
My lord,
circulated a note.
just a quick chronology and I'll, my lord,
Otherwise, what would
quickly end
happen,
it.
my lord, what would happen is if a person with huge pockets would hire 100 laws. It happened in one case in Delhi Patiala House. 100 laws were brought because the person was very rich and affluent. 100%, all senior
Mr.
advocates
Raju,
were
you were on this
putting
side.
arguing one matter.
You were on this
Not
side
one
more than that
law.
side, and these huge pockets worked very well. My
Of
lord,
course,
that's
I am
let us
sticking
know.
to my argument. This is huge pockets, large pockets,
You have given the note.
fathomless
My
pockets.
lord, I'll just my lord, two things I wanted to say and I'll be done. My lord, on seizure, freezing, there is my
My
lord
learned
two
friend
issues
will never finish.
and both issues my lord not answered. There is violation of my lord 17.1 and 17.2 in totality. 17.1A. The officer, my lord, according to them, who has frozen this account is the assistant director. 17.1A talks of the authorized officer under 17.1. 17.1 is only director or deputy director, not below that rank. So, my lord, the entire freezing action is wrong. I will not tabulated in my note. 17.2, there is complete non-compliance. As my lord, Dr. Muralidharan just said, my lord, that no reasons to believe, and will not be reiterate, have seen the light of the day, not before this court, not before any court. And my lord, the reliance on Kejriwal was only to the extent, it my lord echoes what Constitution bench had said, that where the statute prescribes reasons to be recorded in writing, they ought to be furnished, my lord, to the affected person. So, my lord, whether material should be given or not, but material should be, my lord, placed. The second aspect is, my lord, more critical, which is, my lord, that ECIR. The second ECIR question, my lord, I prepared that note and, my lord, handed over. On two critical aspects, your lordships may even note that, my lord, the matter that, my lord, whether a pre-closure report, my lord, one of the argument was that it was a B report, it is a kind of a compounding. My lord, here is an emphatic finding by the police itself that, my lord, it is no offenses made out. After, my lord, that the complainant admitted that there is, my lord, a flaw in his understanding. Second, my lord, the closure report is not a mechanical act. It is accepted by the court, which has three recourses available. It could have rejected it, it could have asked for further investigation, or could have accepted. There is a judicial application of mind there, and I'm covered by, my lord, one of the judgments against ED by this very court, a coordinate bench called, my lord, Kapil Mohan. That, my lord, B. I have extracted in my note the relevant paragraph, my lord, passing on the judgment. My lord, this issue is covered that even a B summary report acceptance. My lord, is
Justice Krishna Kumar.
yes, my lord, Justice Krishna.
No,
The
sorry.
second, my lord, the
Shit. Oh, this.
Only one more objection, my lord.
No, my lord,
In the-
with utmost
rejoinder-
respect, my lord, that
rejoinder
reliance
regarding
was
the
placed.
fresh arguments, then I'll have to rebut. He's making fresh arguments in rejoinder. Is only rejoinder to my arguments.
My lord, there is a judgment relied upon by Mr. Raju called, my lord, Rohit Vij. My lord, now Rohit Vij is contrary to two other judgments of Delhi High Court itself. My lord, I have given in my note a short decree why it is parin.
Heard, deserved. Sir? Yes. Yes, copy court produced.
Deeply obliged.
Yes, sir.
Deeply
My lord,
obliged.
only one submission to supplement Mr. Raju, my lord, with Mr. Raju's permission.
Oh, you're also two
I'm-
of
I-
the two
No, I
senior
will answer
counsel.
it. I will give the answer.
We have deep, there are deep pockets, there are deep dockets there, my lord.
No.
Zoeb,
I don't
sir.
mind. I missed one submission, my lord. Page 62, there's a retention order where there are more reasons than the reason to
Retention
believe.
order is there. That, yes, yes. Sir.
Page 62, my lords, may I have
There is
a
a
look at page
retention
62?
order.
Retention order, my lord, reasons are not equivalent to 17.1 reasons. I'll leave it at that, my lord. I've dealt with that.
Yes.
It has to
Retention,
be read
without that,
together.
there can't be retention. That's all, man.
Yes, sir. What Zoeb, sir?
Yes, my lord, that's the point that I wanted to make. That
Yes,
17
yes.
has to be read with 20. The freezing order.
Raju sir has told it. Yes, yes.
Yes, my lord. The retention has
He
to
can
go
argue,
with.
but he is sometimes
Yes,
out of
yes,
good
yes.
That's the only point, my lord, that today the freezing order can't be read in isolation when the retention order.
Retention
has
order is
been
already
read.
passed.
And the retention order looks at all the material which Dr. Muralidhar was saying is not there.
Challenge the retention order.
The suicide.
Initial action is
No
bad.
challenge. And today, my lord, the scope of judicial review against this administrative order is very narrow. Sufficiency, adequacy, all of this can't be gone into. All that the court looks at is there material, and the material shows lakhs of complaints in the email address of the very same company. Suicides being made by.
Raju sir has told all that.
Yes, but my lord, there's material. My learned friend said on the other side, there is no material. Where is the reason to believe? There's cogent material that has been relied upon.
Material not shared, not disclosed.
Even to this.
No, no,
To
it is
his
disclosed.
imagination, he keeps the material. He is omnipotent.
I'll
and
read one
omnipresent.
line.
That's
My
the problem.
learned friend says there's no material. Read one line, my lord. Upon extraction of AWS database and from the statements of employees, it is found that there are user IDs with add cash but no cash withdrawal, no KYC. These user IDs participated in gameplay and winnings by these user IDs 1100 crores.
It's all right. Yes.
We'll leave it at
Heard
that.
result.
Grateful.
Yes, yes.
Grateful.
119.
ಏನ್ ಮೇಡಮ್ ಇದು?
119.
My lords, I appear for the petitioner, my lords. My lords have directed to file an affidavit in the.
Affidavit. ಓ ಟೈಲರ್ ಎಲ್ಲಿ? ಅಫಿಡವಿಟ್ ಎಲ್ಲಿ? ಯಾರು ಹಾಕಿದ್ದಾರೆ? ಹಾಸ್ಪಿಟಲ್ ಅಡ್ಮಿಟ್ ಆಗಿದ್ದಾನಲ್ಲ, ಹಾಸ್ಪಿಟಲ್ ಎಲ್ಲಿ? ಅಡ್ಮಿಟ್ ಆಗಿದ್ರು ಅಂತೆಲ್ಲ ಹೇಳಿದ್ರಲ್ಲ?
Not my lords.
ಅಲ್ಲಲ್ಲ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಅದೇ ಇದ್ದಿದ್ದು.
It was outpatient only, my lords.
ಅಲ್ಲ,
He was taking treatment that was.
2 ದಿನ?
3 days, your honor.
3 days ಅಲ್ಲೇ ಇದ್ರ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ?
He was taking treatment because.
What treatment?
His sugar spike level was going up and
ಡಯಾಬಿಟಿಸ್
down.
3 ದಿನ ಯಾರು ಔಟ್ ಪೇಷಂಟ್ ಆಗಿ ಕೂದಿರಲ್ಲ, ಇನ್ ಪೇಷಂಟ್ ಆಗಲ್ಲ. ಡೋಂಟ್ ಟೆಲ್ ಮಿ ಆಲ್ ದಿಸ್.
He was an outpatient.
What outpatient? You have taken the measurement of a child touching her everywhere and you are a tailor and you say you are somewhere in the hospital. Hospital says he is not an inpatient, he is only an outpatient.
My lords, I'm a gents tailor, my lords. I don't take up ladies' measurement.
That's a child, madam.
Girl, yes, please, my lords. Exclusively gents wear is only stitched at my tailor shop, my lords. And also, my lords, there is a financial transaction between the petitioner and the complainant's mother.
ಯಾರು ಅಫಿಡವಿಟ್ ಹಾಕಿದಾರ ಈಗ? ಎಲ್ಲಿ ಕೊಡಿ ಇಲ್ಲಿ? On 15th April, consultation 3 minutes. 16th April, consultation 5 minutes. 17th April, consultation 2 minutes. ಏನ್ ಮಾಡಿಲ್ಲ, ಗ್ಲೂಕೋಮೆಟ್ರಿಲಿ ಡಯಾಬಿಟಿಸ್ ಚೆಕ್ ಮಾಡಿ ಕಳಿಸಿದಾರೆ ಅಷ್ಟೇ. ನೀವು ಮನೇಲಿ ಮಾಡೋದ್ನಲ್ಲಿ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದೀರಾ? ಅದು ಟ್ರೀಟ್ಮೆಂಟಾ? ಆಲ್ಸೋ ಇಲ್ವೇ ಇಲ್ಲ, ಇದಿಷ್ಟೇ ಹಾಸ್ಪಿಟಲ್ ರೆಕಾರ್ಡ್ಸ್. ಅಫಿಡವಿಟ್ ಇಸ್ ಹಿಯರ್.
Loan transaction between.
The loan transaction, you told me that you are outside between 15th and 15th to 17th April, taking treatment in this Satya Sai Institute of Medical Science, correct? ಅವರು 2 ನಿಮಿಷ ಟ್ರೀಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಫಿಡವಿಟ್ ಇಲ್ಲಿದೆ. So it's absolutely false. The story of diabetes. ಅದಕ್ಕೆ ಕೇಳಿದೆ, ಡಯಾಬಿಟಿಕ್ ಕಿಟೋಸಿಸ್ ಆಗಿತ್ತು ಅಡ್ಮಿಟ್ ಆಗಕ್ಕೆ ಅಂತ.
No, my lords.
Then
The hospital is almost 10 kilometers away from the.
ವಾಕ್ ಮಾಡ್ಕೊಂಡು ಹೋದ್ರ ಮೇಡಮ್? ಮತ್ತೆ
But it
ವಾಕ್
takes
ಮಾಡ್ಕೊಂಡ್
almost
ಬಂದ್ರ?
an hour to 2 hours to reach the hospital and also to.
Oh, by walking?
No, my lords.
10 kilometers walk. Then ಈ ಡಯಾಬಿಟಿಸ್ ತೋರಿಸ್ತಾನೆ ಇರಲಿಲ್ಲ 10 kilometers ವಾಕ್ ಮಾಡಿದ್ರೆ. ಹೈಪೋಗ್ಲೈಸಿಮಿ ಆಗಿರ್ತಾ ಇತ್ತು.
And also, my lords, medico-legal examination was not done. My
ಅಲ್ಲ ಅವ್ರ ಪ್ರಕಾರ ಬೆಂಗಳೂರಲ್ಲಿ ವಾಕ್ ಮಾಡೋಗಿದ್ರೆ ಬೇಗ ಹೋಗ್ಬಿಡ್ತಿದ್ರು.
ಅದೇ ಬೆಂಗಳೂರು ಇದು ಅಲ್ಲಿ ಇಲ್ಲಿ ಇದರಲ್ಲಿ ವೈಟ್ ಫೀಲ್ಡ್ ಹತ್ರ.
Also there is
First to teen patient 15 to 17th. Affidavit is filed 2 minutes every day. Glucose AccuCheck ಅಲ್ಲಿ ಚೆಕ್ ಮಾಡಿ ಕಳಿಸಿದ್ದಾರೆ. ಶುಗರ್ ಸರಿ ಇದೇನೆ ಹೋಗಿ ಅಂತ. ಈಗ ಜೆಂಟ್ಸ್ ಟೈಲರ್ ಓನ್ಲಿ.
also, my lords, the complainant have refused to give medico-legal examination.
ಯಾರು?
The complainant and
You don't worry about that, madam. ಅದಕ್ಕೆ ಹೇಳ್ಬೇಕಾದ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಬೇಕು ಕೋರ್ಟ್ಗೆ. ಇನ್ಮೇಲೆ ಎಲ್ಲೆಲ್ಲಿ ಡಾಕ್ಟರ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿರ್ತಾರೆ ಅವ್ರಿಗೆಲ್ಲ ಅಫಿಡವಿಟ್ ಹಾಕಕ್ ಹೇಳ್ತೀನಿ. ಎಲ್ಲ ಆಲ್ ಸ್ಕೆಲಿಟನ್ಸ್ ವಿಲ್ ಬಿ ಔಟ್ ಆಫ್ ದ ಕಬೋರ್ಡ್. Yes, anything else?
From the 75 loan, 97,000 ಕಳಿಸಿದ್ರು ಸ್ವಾಮಿ.
ಅದೆಲ್ಲ ಬರಲ್ಲ. ಏನ ಬೇರೆ ಏನಿದೆಯಾ?
ಅವ್ರ ಅಮೌಂಟ್ ಕೇಳಕ್ ಹೋದಾಗ only to harass this petitioner they have filed this false complaint.
Absolutely. Anything else? Dismissed.
One 20.
It is that check bounce matter.
Respondent and bada. You can make a submission. Yes.
So essentially, it's a question of law. What your lordships are seeing is on a day-to-day basis, on conviction, when an appeal is filed, the appeal is filed along with an application under 389. When a 389 application is filed, courts are ordering pre-deposit, exercising powers under 148. Now the difficulty is not from Surendra Singh Deswal, the line of authority was that it was may should be read as shall, and therefore pre-deposit is mandatory. That got modified in Jambu Mandari, and in Muskan Enterprises, it's got further clarified that 148 is an exercise of discretionary power. Now, when the court is to exercise its discretion and decide whether to order and up to 20% or 30% what has to be done, I have to necessarily be heard on that question. Because as an appellant, I'll be able to demonstrate grounds to show that the discretion must be exercised in my favor, and therefore the pre-deposit ought not to be ordered. In Muskan Enterprises, in para 27, the court itself identifies at least 6 circumstances when there can be no requirement to order pre-deposit. For example, if there is a complete mandatory breach of the 143 norms while filing a complaint, ultimately he gets convicted. On a primary reading of the order, the appellate court need not order the mandatory 20% deposit, but can exempt the person from filing. Therefore, not when 389 applications are filed, the courts are exercising their power under 148 and ordering deposit. Once it is ordered, we'll have to come here in 482. Your lordship sometimes remands it back in a fresh adjudication has to happen. My only request is, if your lordships can clarify that when an appeal is filed, either there be an application filed by the complainant under 148, where I'll have an opportunity to show that the court must exercise its discretion in our favor and not order a pre-deposit, then the court will have the benefit of hearing the complainant, hearing the accused, and passing an order. Ultimately, if the court finds that there is good case to order a deposit and I have not made out the exceptional case, then
but would it not create another rung to or a ruse to drag again?
That risk is always there, my lord. And therefore, somewhere where your lordship will have to balance is, even if there is no requirement for a complainant to separately file a 148 application, because then notice will have to have.
We'll see how they did in that 143. Let me see.
Yes, Lord. In 148 itself, when the application is filed maybe under 389, the court, before it passes an order under 148, assuming it has suo motu exercise, it can suo motu enable, and it's an enabling provision, the court may exercise even without an application. At least the court must ask us to file grounds as to why the exemption benefit must be available to an appellant. Otherwise, straight away they'll order 20%. There's no reason. We'll have to come here, your lordship will remand it, and you'll only increase litigation in that sense. I'm not saying that I am not, if the court orders deposit with reasons, I have to deposit. But it cannot be a pre-deposit requirement when the court, then the act itself does not contemplate it to be a
That's what is said in Jambu Mandari.
In Jambu Bandari, Lord, it's clearly said that may will have to be read as may and not shall. So it is not a pre-deposit. In certain taxing statutes, SARFAESI, as a matter of maintainability unless the
It's
deposit
not,
amount.
maintainability, yes, it's not that.
So then, once the appeal is taken, and as a question, when I file my suspension of sentence under 389, I would not take grounds as to why I must be exempted. Otherwise, your lordship may have to hold that when a 389 application is filed, you must make out your grounds as to why the pre-deposit of 20% must not be ordered in the 389 application. Then at least the court will have the benefit of hearing me even before it orders 389. So lordship may do one of two things. In the 389 application, when it is filed, there should be specific arguments as to why the pre-deposit of 20% ought not to be ordered. Or not, if there is a separate application required, then the complainant will have to file an application, I must be heard. But when I file a 389, even without hearing me, where I can make out an exceptional case to say the 20% ought not to be ordered for whatever reasons, the courts are ordering pre-deposit, ultimately it comes with your lordship.
We'll see. We'll have to answer this.
Yes.
29th will dictate.
Yes, grateful.
Heard for dictating orders on 29th. 230 mood matter.
30 mood. So 30 mood matters. Fresh matter, seal number 1, Rajesh Gowda.
Petitioner has purchased the converted land.
Why did you purchase?
25/1/2021. Subsequent seal suit is pending, my lord. OS 1395 of 2021.
So
they also
you
issued a
230 move ಮಾಡಿದ ಕಾರಣ ಹೇಳಿ
notice
ಸರ್.
threatening to arrest the petitioner. my lord.
Arrest?
Oh, yes, my lord. Issued a notice at twice.
420 ಇಲ್ಲಿ.
Yes, actually notice of seal suit is pending, my lord.
Civil is pending since 2009, sir.
No, my lord. 2021. We purchased on 25/1/2021. Seal suit filed on 22/2/2021.
ಈಗೇನ್ ಅಲಿಗೇಷನ್ ಏನು?
But there is no allegation against.
No allegation.
Against accused number 1, 2, 3. We subsequent purchased for a sum of rupees 7 crores 48 lakhs from the accused number 1, 2, 3. With bona fide purchasers, my lord. They are claiming they purchased the same land.
Purchasers?
They are saying that they purchased the land, same land. But we purchased the conversion land, my lord. Converted in 2008, the property has been converted.
You are from Kerala, na?
Kerala. A complainant from Kerala.
Oh, complainant Kerala.
Yes. In page number 40, the property has been converted 2018 itself. And we subsequently purchased after the legal verification. They are claiming the same property. And seal suit is pending between the parties.
ಎಲ್ಲರಿಗೂ 70 ಮೇಲೆ ಆಗ್ಬಿಟ್ಟಿದೆ, ಈಗ ಹೊಡೆದಾಡ್ತಾ ಇದ್ದಾರೆ.
ಅಲ್ಲ, ಅವರು ಕಂಪ್ಲೇಂಟ್ಸ್.
ಕಂಪ್ಲೇಂಟ್ 89 ಅಷ್ಟೇ.
Complainants. We are bona fide purchase.
SPP ಅವರೇ ನೋಡಿ. Monday, fresh matters, not to take coercive steps till the next date. Yes.
Great.
Number 2.
Bona fide purchasers with mala fide intention idre ನೋಡಿ. Yes.
Note 138 proceedings. The notice is issued for check number 934.
Check number 934.
Check number.
ಅದೇ ನಂಬರ್ ತಗೊಂಡು ನನಗೇನ್ ಬೇಕು ಸರ್?
My lord, that is the issue, my lord. In the complaint, the same check number is mentioned, but the check produced before the court is different. I take up that condition.
ಏನ್ 935
amendment, my lord.
ಅಮೆಂಡ್ ಮಾಡಿದಾರ ಆಮೇಲೆ?
Amend ಮಾಡಿದ್ದಾರೆ.
ಬೇರೆ ಚೆಕ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ರಾ? ತೊಂದರೆ ಇಲ್ಲ ಬಿಡಿ.
ಅಲ್ಲ, check number is different, my lord. The cause of action from notice, it mentions different check number. In the complaint also same number.
ಈಗೇನ್ 10 ಲಕ್ಷ ಇಸ್ಕೊಂಡ್ರದ ಹೌದಾ?
ಇಲ್ಲ, I have disputed, my lord. I have when I received the notice itself, I have issued a reply asking for the copy of the check also.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings. File an acknowledgement of such service by the 21st, list on by the 24th Monday, list on 28th. Further proceedings before the concerned court shall remain stayed till the next date. Yes.
Number 3.
Prasanna Kumar.
My lords, the FIR came to be registered for the offences under 318(4) and 319 clause 2, my lords. My lords, I am the bona fide purchaser of the property, my
You
lords.
bona fide purchaser?
My lords, there is a title suit pending between the first informant and the vendor from whom I purchased, my lords. My lords, there is a status quo which is being granted by the trial court. Despite of that, after 2 months, FIR came to register where I'm accused Number two, my lords. My lords, there is no involvement of mine in this matter, my lord, because I am just a purchaser of the property, my lords.
Learned HGP Deepthi Alva is directed to accept notice, secure the investigation papers and place it before the court. Tuesday, fresh matters, no coercive steps. Madam, no coercive. Respondent shall not take coercive steps against the petition. No coercive and rather. Yes. Sagar.
Number 4.
Lords, case of POXO, gross misabuse.
Gross misuse.
Gross misabuse, my lords, of the provisions of POXO. Husband, my lords, petitioner is the husband. My lords, second complainant, my lords, de facto complainant is the wife. My lords, victim, my lords, is the stepdaughter. My lords, there is a MC petition filed just before my lords filing of the complaint. My lords, the alleged incident in the complaint, my lords, is 23/3/2026. My lords, on 34/2026, my lords, there is a conversation between the de facto complainant and my lords, sister of the petitioner. Not one word is my lords spoken about this POXO. My lords, fifth, my lords, the police from first respondent police station, they call the petitioner, call the petitioner's sister, and my lords inform that my lords, the de facto complainant has come with the POXO complaint. If matter is not settled, they would register a case. That transcripts are produced, my lords. That apart, my lords, even my lords, earlier to my lords, the de facto complainant filing the complaint, the petitioner himself, my lords, has filed a complaint. 2/5/2026. This complaint, my lords, was before the Amruthalli police station. From there, my lords, it was transferred to first respondent police station. My case, no report is filed.
Why custody dispute idea?
Custody, my lords, from marriage between the petitioner and my lords, the de facto complainant, my lords, another child is born. The victim, my lords, is the stepdaughter. She is from the first marriage of the de facto complainant. Now, with regard to the my lords, custody of the infant, my lords,
How old is the child?
my lords, few months, my lord.
Sorry?
Few months, my lord.
Few months?
Infant, my lords. My lords, the
Who is alleged?
victim, my lords, is 11 years.
Then
Stepdaughter.
Yes.
Victim, my lords, is 11 years. Victim is 11 years. This petitioner, my lords, also has a child with the de facto.
That may be an infant. That's a different thing. Yes.
The lordship, page number 189, the victims, she has briefs.
Her statement is there?
Yes, yes.
180?
189. Last.
One moment. ನಂತರ ದಿನಾಂಕನ
My lords, victim statement, my lords, is recorded, my lords, by the learned magistrate, by CWC, and my lords, by the IO. Now, your lordship may kindly see, my lords, the statement of the victim, my lords, on page number
statement.
177, my lords, is the statement before the CWC, my lords, Child Welfare Committee.
177,
my lords. My lords, there in the 177, my lords, fifth paragraph may kindly be seen, my lords.
ಇದರಲ್ಲಿ ಏನಿಲ್ವಾ ಅದು?
ಮಗುವಿನ ಕೇರ್ ಟೇಕರ್ ಪುಷ್ಪಾರವರು ನೋಡಿದ ಕಾರಣ ಅವರು ನನ್ನನ್ನು ಬಿಟ್ಟರು. My lords, the victim, my lords, when she gives her statement, my lords, before the committee, my lords, she specifically says that, my lords, that this Pushpa has seen the incident. Now, Pushpa's statement, my lords, is also recorded. Statement before the CWC, statement before the magistrate, and statement before the IO, my lords, are not consistent. There are inconsistencies, my lord.
ಈಗ ಮೂವ್ ಮಾಡಿದ್ದೆ ಯಾಕೆ?
My lords, charge, my lords, is to be framed on Saturday, my lords.
With these statements, be it before the CWC or before idu.
No, my lords, victim says that.
Why would a child of 11 years tell all this?
My lords, tutored, my lords, tutored. My lords, your lordships, my lords, have held that, my lords, that.
That's in a family disputes, not in POXO.
My lords, POXOs arising out of this family dispute.
Maybe, sir, that's a different thing. It's, the ingredients are different and what I've answered is in a family GMFC.
Now, my lords, the whole issue, my lords, is because of the MC, my lords, that is filed. If your lordships were to see the conversation, my
Maybe,
lords.
sir, how can I disbelieve a child's statement of 11 years, which gives you vivid details?
My lords,
Vivid
before
and gross.
three authorities, my lords, it is a story is different, my lords.
That's all the evidence. How can I take it here? 482 kashta, sir. Very difficult. Because of the statement. If there was no statement, yes.
Statement is, yes, statement is there, my lords, but 11-year-old my lords, they have the intelligence, my lords. If tutored, my lords, they would repeat it. Now, when I stand.
No, but if not tutored also, they may say what is the truth.
My lords, when truth is spoken, my lords, the statement, my lords, when recorded, my lords, very closely, a day after, my lords, in a short interval, my lords, there cannot be
No,
such.
Sagar, you tell me,
Yes.
with these statements in 482, can I decipher the statements, disbelieve and say, no, this was done on this, this was done on this, this was done on this? Kashta. The statement illa andidre I would have entertained. You urge all those contentions there. The learned counsel for the petitioner, after arguing the matter at length, submits that he be reserved liberty to urge every contention before the concerned court at the appropriate time. Reserving such liberty, the petition stands disposed.
Obliged.
Yes.
Number 5, Chairman Umar Shankar.
For inaction by raising boundary dispute. 39 rule 1 and 2 application was dismissed. MA was also dismissed.
ಅದಕ್ಕೆ crime
ಅದಕ್ಕೆ MA dismiss ಆದ್ಮೇಲೆ ಸೂಟು ವಿತ್ಡ್ರಾ ಮಾಡ್ಬಿಡ್ತಾರೆ ಈ ಕಂಪ್ಲೇಂಟ್ ಆಗ್ತಾರೆ
329(4) in the meantime. Yes. Next. Mahesh.
Still number 6.
The petitioner is had entered into a joint development agreement with the landowners, my lord. These landowners have initiated proceedings against second respondent of their family since year 2002. And now they have instituted this complaint, my lord, under section 31R, 325A, 31S against the petitioner who was not in the place admittedly.
14th August, sir, ಆಗಿರೋದು crime.
Already in witch hunting, my
ಅಲ್ಲ
lord.
ಇಲ್ಲ atrocities but ಬೇರೆ ಏನಿಲ್ಲ ಇಲ್ಲಿ.
351.
351, 352.
And
ಕೋರ್ಟ್ ನಲ್ಲಿ ಕೇಸ್ ನಡೀತಿದ್ದರೂ ಸಹ ನಮ್ಮನ್ನು ಬೈದಿದ್ದಾರೆ.
And moreover, petitioner was not there.
List the matter on 29th in the meantime.
Obliged.
Yes. Next.
Number 7.
What is the
Saravanan.
de facto complainant's brother purchases 850 quintals of arecanut from one Rajappa. Rajappa gives the Rajaya. He gives a complaint to the police saying that it's an act of cheating because not a single rupee is paid after 850 quintals is taken on 11/8/2025. 26. The police issue a notice to the house. This Basuraj is not there. That is the person who had taken this is not there. His brother is summoned. Now brother comes on 12/8/2025 and he gives a statement. As a counterblast saying that, can I just take your lordships to page number 15? That is the contents of the complaint. Lords, he says at the last 4-5 lines, my lords.
Pokso.
Pokso.
Arecanut Pokso.
Arecanut Pokso. Kidnap. Pokso on kidnap.
ಯಾರನ್ನ ಕರ್ಕೊಂಡು ಹೋದ್ರಿ?
ಅದು ಅವ್ರು ಹೇಳೋದೇನು ಅಂತಂದ್ರೆ ದಿ daughter of Basuraj who had purchased, these two persons went to her and said that till such time this loan is given, you will have to come and stay with us. Followed her and said this. Everything takes place on that day between 4 p.m. to 8 p.m. All incidents takes place and he is in the police station during that period. That is his statement.
Who was in the police station?
The complainant. From 4 p.m. to 8 p.m. is sitting there and everything else happens outside.
Oh, how is he in the know of all of everything?
That's the, and he gives that statement. He even gives the phone number, my lords, of the accused at page number 16.
ನೀವು ದುಡ್ಡು ಕೇಳಿದ್ ಯಾವತ್ತು?
11th. Page number 14.
He purchases 850 quintals.
850 quintals. Page number 14, my lords. ಅದರೊಳಗೆ ಲಾಸ್ಟ್ 3 lines ಅಲ್ಲಿ 6/8/26ಕ್ಕೆ ನಾವು ಹಣ ಕೇಳಿದ್ವಿ, ಅವ್ರ ಮನೆ ಬಾಗ್ಲ ಹಾಕಿದ್ರು, ಆದ್ರಿಂದ ಅವ್ರ ಮೇಲೆ ಕ್ರಮ ತಗೊಳ್ಳಿ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿರೋದಷ್ಟೇ.
ನೀವು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರಿ?
ನಾವು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದು 11ನೇ ತಾರೀಕು. 12ನೇ ತಾರೀಕು 4 ಗಂಟೆಯಿಂದ 8 ಗಂಟೆ ತನಕ ಅಲ್ಲಿ ಕೂತ್ಕೊಂಡು he describes all the incidents which has taken place outside.
Yes, SPP.
Number, my lord, number has come because.
Mobile number?
Mobile number is because the complaint is not filed the minor. Complaint is filed by the adult person.
Complaint is not filed by minor, father.
Correct.
Uncle.
Sorry. One who had, one who was sought to be the accused at the hands of this person. Heard the learned senior counsel D.R. Ravi Shankar appearing for the petitioner. The petitioner and the de facto complainant have a transaction.
De facto complainant's brother.
De facto complainant's brother has a transaction. The brother's name is one Basavaraj. The transaction is with regard to purchase of raw areca nut from several persons in the locality, including the petitioner. The petitioner seeks payment of the purchase of 850 quintals of areca nut from the hands of the brother of the complainant, which payment had not been done despite passage of 10 months. Therefore, the petitioners seek to register the complaint against the brother of the complainant on 11/8/2026. On coming to know of the same, a complaint by way of a counterblast is registered on 12/8/2026 by the brother of the person who had purchased the areca nut from the hands of the petitioners and was dodging payment, that the minor child is being harassed between 4 p.m. to 8 p.m. Therefore, it is an offense under POCSO. The learned senior counsel submits between 4 p.m. to 8 p.m. The complainant was sitting in the police station and registering the subject complaint, and comes to know at the same time all the incidents that have happened. The prima facie, it transpires the act is being misused for obviating the demand for money till the learned HCGP would secure instructions and make submissions. Further investigation shall remain stayed.
The complaint can also notice the complainant.
Emergent notice to the complainant returnable by the 3rd September.
These are all probably the case, my lord. I think your lordship may consider
Misuse of the act.
if what senior counsel is saying is true.
Correct, obviously.
That is the statement by the complainant himself.
8 and 12 POCSO, ದುಡ್ಡು ಕೊಡಿ ಅಂತಂದ್ರೆ POCSO, custody ಅಂದ್ರೆ POCSO.
Message has to go.
This is terrible. It's become misuse. Yes.
Please, my lord.
Yes, 3rd September. The emergent notice to the second respondent complainant returnable by 3rd September.
Number 8, Yatin B.
Please. My lord, the complaint is filed in India, my lords.
India,
in Mangalore.
Mangalore is in
yes,
India.
It's for
Then
this
why are
reason-
you telling it?
It's for this reason, my lord. Parties who have been in Qatar.
Doha.
Both husband till 4th August 2026, husband was there. Husband came along with the child to India, my lords. And because wife was ill-treating the child in very
In India or in Qatar?
In Qatar, and India came back here, my lords, expressed everything to the doctor, and treatment for the doctor, photographs are produced. He approached the learned family court, my lords, with all his grievance in Mangalore. In Mangalore, filed the case in Mangalore, my lord, 10th August. And my lord, wife comes on 8th August to India. Now, my lord, on 18/8/2026, she files a complaint in Mangalore stating that she was abused throughout, etc. And she also states there was an
Abused
attempt,
where? In India or Qatar?
Qatar and in India.
All right.
And she was also attempted, there was an attempt on her to finish her. ಚೂರಿ ತೆಗೆದು ಕತಾರಲ್ಲಿ ಒಮ್ಮೆ ನಮ್ಗೆ ಹಂಗ್ ಮಾಡಿದ್ರು, ಚೂರಿ ತೆಗೆದು ಪ್ರಯತ್ನ ಮಾಡಿದ್ರು ನನಗೆ ಅಂತ ಹೇಳಿ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಇಸ್ ಆಡೆಡ್. And the police now, in addition to 498A,
109 ಹಾಕಿರ್ತಾರೆ.
one that's also added, my lord. And immediately after the affair, all the police barged into his house. Luckily, he was not there. Immediately
Where
after,
you are in Qatar?
no, Mangalore.
Mangalore.
I had come to Mangalore. He is prosecuted and filed the divorce petition, my lords. Includes everybody, all the family members, my lords. And one more allegation is, while coming from Qatar, he has also taken his cash, etc. It amounts to theft. Now the police add theft sections.
ಇಲ್ಲಿ.
Howdo. And also 109 also.
You have come back from Qatar.
I had come back on
I
4th.
had or I have?
I have come back on 4th August. I have continued to be in India.
You are in Mangalore only.
I am Mangalore only, my lord. Now, my lord, after the divorce petition, etc. is filed, my lord, I also have sought for protection from the Honorable Family Court, my lords. As far the child is concerned, child is also taken treatment. The serious injuries also caused the child because of her assault. She totally,
India or Qatar?
that she assaulted the child in Qatar. Therefore, treatment is here. Now she comes and now,
Qatar ಅಲ್ಲಿ ಆಗಿದ್ದಕ್ಕೆ ಟ್ರೀಟ್ಮೆಂಟ್ ಇಲ್ಲಿ ಕೊಡಿಸಿದ್ರ?
for this reason, my lord, there is one daughter and a.
So ಅಲ್ಲಿ ಯಾರು ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡ್ಲಿಲ್ವಾ?
She started threatening, my lord. She will use the daughter and file a false complaint against, and she will say, I will also use my maid servants and file a case.
Where? India or Qatar?
In Qatar. Therefore, my lord, he had no other go to come back. And then narrated everything before the family court, filed the petition, etc. My lord.
Family court here.
How though in India? Now he is in India, my lord. Now she comes to India and says she was assaulted, an attempt to honor her, no injuries, attempt to honor her in Qatar. And police add this section, my lords. 109 is added. And if arrested, he will be in definitely in custody for several days, because 109, my lords, the learned magistrates, my lord, travel by sessions, though no injuries there, everything is outside, my lord.
So we want to go back to Qatar.
Now, my lord, with this serious situation, my lord, he will not
You
be
don't
able
want to go back.
go.
So ಇಲ್ಲೇ ಇರ್ತೀರಲ್ವಾ?
ನಮ್ಮ ದೇಶದಲ್ಲಿ ಇರೋದು ಒಳ್ಳೇದು ಅಂತ ಆಗಿದೆ. ಅಲ್ಲಿ
ಅಲ್ಲವಾ?
ಅಲ್ಲಿ ಸುಳ್ಳು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟು ಒಳಗೆ ಬಾಳಬೇಕು. ಅಲ್ಲಿ ಆಲ್ ಕಾಜಿ ನ್ಯಾಯ ಸ್ವಾಮಿ ಇದು ನ್ಯಾಯ ಸಿಗೋ ಸಾಧ್ಯತೆ ಇಲ್ಲಿ. At least we can rush to the honorable court.
Correct. Not to take coercive steps are ಹೇಳ್ತೀವಿ.
Yes, we can get justice, my lord. Otherwise, there, my lords, simply he will be inside. False complaints, my lord. At least 482 CRPC is very, very live, my lord. So people are getting justice here.
Not in Qatar. Not in Qatar.
Not in Qatar. Not at all. Not at all. This is a very. And immediately, all police are at the doorsteps. We have produced the photographs also with the timing in the CCTV footages.
No problem. Very nicely narrated story. Good pot boiler.
The child's photographs and medical reports also I have produced. My lord, even MC case which we have filed, my lords. That's on 10/8 we have filed in Mangalore. That's very, very detailed MC.
Again, ಮಾಡೋಣ?
I require and pray, my lord, to kindly protect him, my lord. Prayer.
Qatar or India?
Before India, Qatar will never get justice.
ಆಮೇಲೆ don't tell all that.
No, because he has their experience.
Crimes don't happen there.
That also, my lords, crimes happen. There also crimes happen, my lord.
Yes. Yes, people. Don't send him to Qatar.
We will not send.
Yes.
We will at least go and meet him and talk to him.
Where are you now?
I will immediately inform my lord. If lordship is to protect us.
Where are you now?
No.
ಇನ್ನು ಬೇಲ್ ತಗೊಂಡಿಲ್ಲ ಅಲ್ವಾ? ಅಲ್ಲ, ಅದಕ್ಕೆ ಎಲ್ಲಿದ್ದೀರಾ ಅಂತ ಹೇಳಿದ್ರೆ ಅವರು.
We are within the jurisdiction of my lord, completely.
My lord?
We are within the jurisdiction.
ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ? ನಮ್ jurisdiction ಇಷ್ಟೇ.
No.
Court all 14.
No. It covers the entire state. Mangalore is within my lord's jurisdiction. Is in Mangalore.
Yes. Nodi.
We'll secure the records.
Secure the records. Yes. We'll take it on 27th. Till then, arrest him.
May humbly pray for some protection, my lords. Till then.
ಹೇಳಿದ್ನಲ್ಲ ಈಗ. Yes. ಬರ್ದೇ ಬಿಟ್ಟಿರಾಮಲ್ಲ. Not to take coercive steps till then. 27th fresh matters.
Most grateful.
ಈಗ ಅಡ್ರೆಸ್ ಕೊಡ್ಬೋದು ನೀವು. ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಯಾಕೆ? ನೀವು ಎಲ್ಲಿದ್ದೀರಾ ಅಂತಾನೆ ಗೊತ್ತಿಲ್ಲ.
Police have, everybody has come to the doorsteps and we have produced.
ಡೋರ್ ಸ್ಟೆಪ್?
ಹೌದು.
ಎಲ್ಲಿದ್ದೀರಾ ಅಂತ ಗೊತ್ತೇ ಇಲ್ಲ. ಈಗ ಡೋರ್ ಸ್ಟೆಪ್ ಹೆಂಗ್ ಬಂದ್ರು?
ಆ ಮನೆಯಲ್ಲಿ ಪುಣ್ಯಕ್ಕೆ ಆ ಗಳಿಗೆಯಲ್ಲಿ ಇರ್ಲಿಲ್ಲ ಅಷ್ಟೇ.
ಆ ಗಳಿಗೆಯಲ್ಲಿ ಇರ್ಲಿಲ್ವಾ?
12 ಗಂಟೆ ರಾತ್ರಿ ಬಂದ್ಬಿಟ್ಟವ್ರೆ.
12 ಗಂಟೆ ರಾತ್ರಿಗೆ ಬಂದ್ರು.
12 ಗಂಟೆಗೆ FIR. Immediately I have produced the CCTV footages. Immediately, they are all 4 police in dress.
ಅಲ್ಲ ಅದು
They're
ಕೇಸ್
inside the house.
ನಿಜನ ಸುಳ್ಳ ಅಂತ ನೋಡಕ್ ಬಂದಿರ್ತಾರೆ, ಇವ್ರನ್ನ ಅರೆಸ್ಟ್ ಮಾಡಕ್ಕೆ ಅಂತಲ್ಲ.
ಕತಾರ್ಲಿ ಇದಾರೆ, ಇಂಡಿಯಾಲಿ ಇದಾರ?
ಇವ್ರು ಮಿಸ್ಟೇಕ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
No, no, there's no parallel to my learned friends' submissions, innovative submissions.
All right, 27th.
Please, grateful.
Bill number 9, K. Chandana Tariga.
No precipitate to.
No precipitate ಅಲ್ಲ, only cause.
Because we are always confused. Please.
Petitioner, my lords. Was DV proceedings, my lords, instituted as against the relatives of the husband.
Huh.
My lords, the only reason
DV
why.
na?
How this? Only reason, my
So,
lords, why she is.
Chetan, 2, 3, 4.
Alla,
Merge
all
and
are,
note.
all are relatives, my lords, I'm sorry.
One, the respondents 2, petitioners 1, 2 and 3 are respondents 2, 3, 4, 5 before the concerned court under the provisions of the Domestic Violence Act instituted by the wife. There shall be an interim order of stay of further proceedings qua these petitioners. It is made clear further proceedings qua others is not stayed.
Grateful.
Emergent notice to the respondent. Next.
Number 10,
ಪಿಟಿಷನರ್ಸ್
ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಒಂದು ಮೆಮೊ ಕೊಡ್ತಾ ಇದೆ.
ಏನ್ ಮೆಮೊ?
ಇದರಲ್ಲಿ ಮೆಡಿಕಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ.
ಯಾಕೆ ಬೇಲ್ ತಗೊಂತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, 2022 ನಮ್ಮ ಪಿಟಿಷನರ್ ತಾಯಿಗೆ ಹುಷಾರಿರಲ್ಲ, ಆಸ್ಪತ್ರೆಗೆ ಹೋದ್ರೆ ಸಿಟಿ ಸ್ಕ್ಯಾನ್ ಅಲ್ಲಿ ಗೊತ್ತಾಗುತ್ತೆ ಲಂಗ್ಸ್ ಕ್ಯಾನ್ಸರ್ ಅಂತ. ಅಡ್ಮಿಟ್ ಮಾಡ್ತೀವಿ, ಅಡ್ಮಿಟ್ ಮಾಡಿದಾಗ ಬಿಕಾಸ್ ಆಫ್ ರಾಂಗ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಹೆವಿ ಡೋಸ್ ಅಲ್ಲಿ ಬ್ಲಡ್ ಕ್ಲಾಟ್ ಆಗುತ್ತೆ. ಅವಾಗ ಲೆಫ್ಟ್ ಲೆಗ್ ಅಲ್ಲಿ ಬ್ಲಡ್ ಕ್ಲಾಟ್ ಆಗಿದೆ, ಟ್ರೀಟ್ಮೆಂಟ್ ಕೊಡ್ಬೇಕಂತ ಹೇಳಿ ಟ್ರೀಟ್ಮೆಂಟ್ ಮಾಡದಂತ ಡಾಕ್ಟ್ರು ಆಮೇಲೆ 2 days ಅಲ್ಲಿ ಸರಿ ಹೋಗುತ್ತೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಸರಿ ಹೋಗಲ್ಲ ಸ್ವಾಮಿ. ಆಮೇಲೆ ಹೊಟ್ಟೆ ಹತ್ರ ಮತ್ತೆ ಕ್ಲಾಟ್ ಆಗುತ್ತೆ, ಅದಕ್ಕೂ ಕೂಡ ಸ್ಟಂಟ್ ಹಾಕ್ತಾರೆ. ಅದಕ್ಕೂ ಕೂಡ ಸ್ಟಂಟ್ ಆದ್ಮೇಲೆ ಅಂಜಿಯೋಗ್ರಾಮ್ ಸ್ಟಂಟ್ ಅಂತ ಅಳವಡಿಸ್ತಾರೆ. ಅದಾದ್ಮೇಲೆ ಕೂಡ ಸರಿ ಹೋಗಲ್ಲ. ಸರಿ ಹೋಗದೆ ಇದ್ದಕ್ಕೆ ನಾವು ಬೇರೆ ಕಡೆ ಒಪಿನಿಯನ್ ತಗೊಂಡಾಗ ಲಂಗ್ಸ್ ಕ್ಯಾನ್ಸರ್ಗೆ ಇವ್ರು ಯಾಕೆ ಈ ಟ್ರೀಟ್ಮೆಂಟ್ ಕೊಟ್ರು, ಬ್ಲಡ್ ತಿನ್ನರ್ ಕೊಟ್ರೆ ಸಾಕಾಗಿತ್ತು ಅಂತ. ಮೇಲೆ ಇದು ಮತ್ತೆ ಡಿಸ್ಚಾರ್ಜ್ ಕೂಡ ಮಾಡಲ್ಲ, 14 lakh ಕಟ್ಸ್ಕೊತಾರೆ. 14 lakhs. ಅದಾದ್ಮೇಲೆ ನಾವು ಬೇರೆ ಆಸ್ಪತ್ರೆಗೆ ಹೋದಾಗ ಬಿಕಾಸ್ ಆಫ್ ದಿಸ್ ರಾಂಗ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಕಾಲ್ ಕೂಡ ಕಟ್ ಆಗುತ್ತೆ, ಮತ್ತೆ ಪೇಷಂಟ್ ಕೂಡ ಡೆತ್ ಆಗುತ್ತೆ. ನಮಗೆ ರಾಂಗ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಕೊಟ್ಟು ಈ ತರ ಆಗಿದೆ ಅನ್ನೋ ಕಾರಣಕ್ಕೋಸ್ಕರ ಅಲ್ಲಿ ನಾವು ಒಂದು ರಿವ್ಯೂ ಆಗ್ತೀವಿ ಆಸ್ಪತ್ರೆಗೆ.
ರಿವ್ಯೂ
ನೀವು ಬ್ಯಾಡ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಿ ನಮಗೆ, ಬಿಕಾಸ್ ಆಫ್ ನಿಮ್ ಬ್ಯಾಡ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಇಂದ ನಮ್ಮ ಮದರ್ ಡೆತ್ ಆಗಿದ್ದಾರೆ ಅಂತ. ಅದಕ್ಕೋಸ್ಕರ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದಾರೆ. ಲಾಸ್ಟ್ 10 years ಇಂದ ನಮ್ಮ ಪಿಟಿಷನರ್ US ಅಲ್ಲಿ ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
US ಅಲ್ಲೇ ಇದ್ದಾರೆ, ಅಲ್ಲಿಂದಾನೆ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದ್ರ ಎಲ್ಲ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ನಾವು ರಿವ್ಯೂ ಹಾಕಿದಾಗ ನಮ್ಮ ತಾಯಿ ಡೆತ್ ಆಗ ನಾವು ಅಲ್ಲಿದ್ವಿ, ನಾವು ರಿವ್ಯೂ ಹಾಕಿದೀವಿ ಅಂತ ಹೇಳಿ ನನ್ನ ಮೇಲೆ FIR ಹಾಕಿದ್ದಾರೆ. ಈಗ NBW ಆಗಿದೆ.
NBW ಆಗಿದೆಯಾ? 23 ಕ್ರೈಮ್ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ವಾ?
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿ ಸಮನ್ ಆಗಿದೆ. ಈಗ ನಾವು ಅಲ್ಲಿದೀವಿ, ನಮ್ಮ ಮೇಲೆ.
ಈಗ ಅಲ್ಲಿಂದ ಇಲ್ಲಿಗೆ ಯಾವಾಗ ಬರ್ತೀರಾ? ಅಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಇಲ್ಲಿ ಡಿಕ್ಟೇಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಐ ವಿಲ್ ಪ್ರೊಟೆಕ್ಟ್ ಯು, ಬಟ್ ಯು ಕಮ್ ವೆನ್ ಆರ್ ಯು ಕಮಿಂಗ್?
ನಾನು ಸಿಕ್ 1 month. 1 month ಟೈಮ್.
1 month ಎಲ್ಲ ಇಲ್ಲ. ಯಾವಾಗ ನೆಕ್ಸ್ಟ್ ಫ್ಲೈಟ್ ತಗೊಂಡ್ ಬನ್ನಿ. ಯಾವಾಗ?
ಲಾರ್ಡ್ಶಿಪ್, ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಏನಂದ್ರೆ
ಐ ವಿಲ್ ಟೇಕ್ ದಿಸ್ ಆನ್ 2nd September.
ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಏನಂದ್ರೆ ನಾನು ಒಂದು 2 ಸ್ಟೇಟ್ಮೆಂಟ್ ಓದ್ತೀನಿ ಇದರಲ್ಲಿ. ಏನಂದ್ರೆ ಅಲ್ಲಿ ಕಂಪ್ಲೇನೆಂಟ್ ಆದಂತ ಡಾಕ್ಟ್ರೇ ತಮ್ಮ ರಾಂಗ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಬಗ್ಗೆ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ, ಪೇಜ್ ನಂಬರ್ 40.
ಆಯ್ತು, ಯು ಆರ್ ನೌ ನಾಟ್ ದಿ ಕಂಪ್ಲೇನೆಂಟ್ ಸರ್, ಯು ಆರ್ ದಿ ಅಕ್ಯೂಸ್ಡ್. ಅದಕ್ಕೆ ಅಮೆರಿಕನ ಅಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಇಲ್ಲಿ ಹೌ ಫೈಲ್ಡ್ ದಿಸ್ ಪಿಟಿಷನ್?
ಮೆಮೊ ಆಫ್ ಅಫಿಯರೆನ್ಸ್. ಮೆಮೊ ಆಫ್ ಅಫಿಯರೆನ್ಸ್ ಫೈಲ್
ನಡೆಯಲ್ಲ, ನಾಟ್ ಇವನ್ ಮೇಂಟೈನಬಲ್. ಕಮ್ ವೆನ್ ಡು ಯು ಕಮ್? ಐ ಮೀನ್
1 month.
ಇಂಡಿಯಾಗೆ ಯಾವಾಗ ಬರ್ತೀರಾ ಅಂದ್ರೆ
ನಾನು ಅದನ್ನ 1 month ಟೈಮ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೋತೀನಿ ಕ್ಲೈಂಟ್ ಜೊತೆ ಮಾತಾಡಿ.
ಏನು ಮಾತಾಡಕ್ಕೆ ಆಗಲ್ಲ.
504, 506,
509 ಇದೆ ಸರ್.
ಅಲ್ಲಿ ಇನ್ನೊಂದು ಸ್ವಾಮಿ ಸಬ್ಮಿಷನ್ ಅಂದ್ರೆ ಪೇಜ್ ನಂಬರ್ 26 ಕಂಪ್ಲೇನೆಂಟ್. ಅಲ್ಲಿ
509 ಇಲ್ಲ ಅಂದಿದ್ರೆ ನೀವು ಅಲ್ಲೇ ಇರಿ ಅಂತ ಇದ್ದೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದನ್ನು ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ, ಪೇಜ್ ನಂಬರ್ 26 ಸ್ವಾಮಿ.
You can't sit there and ask questionment here. Maybe, but the accused cannot sit in US and say a court in this country should consider on a memo of appearance of his and
page number 40 ನಮಗೆ ಟ್ರೀಟ್ಮೆಂಟ್.
Complainant is not a doctor. They could have abused the doctor if they want, not this.
He is an accused anyway. Yes.
ಸ್ವಾಮಿ, ಏನಾಗುತ್ತೆ ನಮಗೆ ಪೇಜ್ ನಂಬರ್ 40 ನಮಗೆ ಟ್ರೀಟ್ಮೆಂಟ್ ಮಾಡಿದ ಅಜೀಜ್ ಪಾಷಾ ಅನ್ನೋ ಡಾಕ್ಟರ್. ಬಟ್ ನಮ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟವರು
ಕಂಪ್ಲೇನೆಂಟ್ ಇಸ್ ನಾಟ್ ಡಾಕ್ಟರ್.
ಇಲ್ಲ ಸ್ವಾಮಿ,
ಶಿ ಇಸ್ an actress.
ಸ್ವಾಮಿ.
ಅವ್ರಿಗೆ ನೀವು ಅದೇ ಮತ್ತೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ನಮ್ದೇನಂದ್ರೆ
ಓ ಸರಿ. ಬನ್ನಿ ಇಂಡಿಯಾಗೆ ಯಾವಾಗ ಬರ್ತೀರಾ ಸರ್? ಮೋಟರೈಸ್ಡ್ ಹೆಂಗಾರು ಕರ್ಸ್ಕೊಳ್ಳಿ, ತೊಂದರೆ ಇಲ್ಲ.
ಮತ್ತೆ ಅವರು ಇದರಲ್ಲಿ ನಾವು ಅವ್ರ ಏನು ಒಂದಿಲ್ಲ 509 ಏನು ಒಂದಿಲ್ಲ ಸ್ವಾಮಿ, ಸುಮ್ಮನೆ
ತೊಂದರೆನೇ ಇಲ್ಲ. ಇವರ್ ಎನ್ ಅಕ್ಯೂಸ್ ನೌ, ಕಮ್ ಟು ಇಂಡಿಯಾ. ನೀವು ಬಂದು ಹೋಗೋದಿರುತ್ತಲ್ಲ ಅವಾಗ ಕರೆಕ್ಟ್ ಆಗುತ್ತಲ್ಲ. ಏನ್ ಕಂಪ್ಲೇನೆಂಟ್ಗೆ ಏನ್ ಹೇಳಿದ್ರಿ?
ನಾವೇನ್ ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ, ಪೇಜ್ ನಂಬರ್ 40 ರಿವ್ಯೂ ಅಲ್ಲಿ ನಾವು ನಿಮ್ಮಿಂದ ನಮ್ಮ ತಾಯಿ ಡೆತ್ ಆದ್ರು ಇಲ್ಲಿವರೆಗೂ ಬಿಕಾಸ್ ಆಫ್ ನಿಮ್ಮ ಬ್ಯಾಡ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಇಂದ ನಮ್ದು ಪೇಜ್ ನಂಬರ್ 59
57 ಒಂದ್ ಸ್ವಲ್ಪ ನೋಡು.
ಪೇಜ್ ನಂಬರ್ 59 ನಿಮ್ಮಿಂದ ನಮ್ಮ ತಾಯಿ ಡೆತ್ ಆದ್ರು ಬಿಕಾಸ್ ಆಫ್ ನೆಗ್ಲಿಜೆನ್ಸ್ ಇಂದ 1,60,00,000 ನಮ್ಗೆ ಲಾಸ್ ಆಯ್ತು. ಅದರಿಂದ ನಾನು ಮದುವೆನೂ ಹೋಗಕ್ಕಾಗ್ಲಿಲ್ಲ, ಪ್ರಾಪರ್ಟಿನೂ ಮಾರಾಟ ಮಾಡ್ಬೇಕಾಯ್ತು. ಈ ತರ ಫೇಕ್ ರಿವ್ಯೂಗಳು ಇಟ್ಕೊಂಡು ಆಸ್ಪತ್ರೆ ನಡೆಸೋ ಡಾಕ್ಟರ್ಗಳ ಹತ್ರ ಹೋಗ್ಕೋಬೇಡಿ. ಇವರು ನಮ್ಮನ್ನ ಮೋಸ ಮಾಡಿದ್ದಾರೆ.
ಪೇಜ್
57 ಇಲ್ಲ ಇಲ್ಲಿ ಕೊಡಿ. ಇರ್ಬೋದ? ಯಾವಾಗ ಬರ್ತೀರಾ ಸರ್? ನೋಡಿದಿರಲ್ಲ ಮೆಸೇಜ್ ಇದು? ಕೊಡ್ಲಾ? ನೋಡ್ತೀರಾ? ಇದೆ ಅಲ್ವಾ? As you sow, so you reap. So you sow into the plain now, you will reap here.
Right? ಇದರಲ್ಲಿ ಇಡೀ ಫ್ಯಾಮಿಲಿನ ಅಕ್ಯೂಸ್ ಮಾಡಿತ್ತು.
ತೊಂದ್ರೆ ಇಲ್ಲ ಸರ್, ನೀವು ಹೇಳಿರೋದಕ್ಕೆ ಇಡೀ ಫ್ಯಾಮಿಲಿಗೆ ಹೇಳಿದ್ದೀರಾ.
ಬಿಕಾಸ್ ಆಫ್ ದಿಸ್ ರಾಂಗ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಇಡೀ ಎಂಟೈರ್
ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಸರ್.
ಒಂದು ಡೆತ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಸರ್? ಅದಕ್ಕೆ ಈಗ ಯಾವಾಗ ಬರ್ತೀರಾ ಅಂದ್ರೆ? ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಮಂತ್ ಇಲ್ವೇ ಇಲ್ಲ, ಬರ್ದೇರೆ NBW ರೆಡ್ ಕಾರ್ನರ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿಸ್ತೀನಿ ಇಂಟರ್ಪೋಲ್ ಇಂದ.
ನೆಕ್ಸ್ಟ್
week 2 weeks will ಏನಿಲ್ಲ. I'll take this on 1st September. If you are not here, I will direct issuance of notice by the Interpol. List the matter on 1st September in the fresh matters list. Is that the way to talk to a lady? ಫಸ್ಟ್ ನೀವು ಬನ್ನಿ, ನೀವು ಏರ್ಪೋರ್ಟ್ ಇಳಿದಾಗ ಏನ್ ತೊಂದರೆ ಮಾಡಲ್ಲ, ಬನ್ನಿ. ನಿಮ್ಮ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ರು ನಾನು ಇಲ್ಲಿ ಬಿಡ್ತೀನಿ, ಫಸ್ಟ್ ಬನ್ನಿ.
My lords, in this matter, the matter is with regard to Atrocities Act, my lords, for a transaction which has happened between the year 2012 to 17, and now the FIR has been registered. There is already stay with respect to accused number 1.
Tag along with sounds. Same order. Next.
Much obliged.
12.
Rajendra Reddy. Monday. Monday. Yes, next. ಇದೇನ್ ಸರ್ ಮತ್ತೆ ಮಧ್ಯಾಹ್ನ?
Whole defamation case. Which your lordships laid down, my lords, the procedure for now the cognizance is taken. The PW 2 and 3, my lord, they don't support the case of complainant, number 1. Secondly, my lord, the scope of 223 provision will have to be examined, my lord. There are no judgments on this issue. What kind of but there is no scope of inquiry and what kind of defense I can take and the learned judge would entertain. These things are not there.
ಈಗ ಏನ್ ಬೈದಿರ್ರಿ?
No, my lord, it's an election campaign where I make a statement that respondent has taken money in APMC market and all this. It was a counter speech, my lord, not.
ಅವರು ಸ್ಪೀಚ್ ಮಾಡಿದ್ರ?
With reference to 3-year reservation because both belong.
ನಿಮ್ದೆಲ್ಲ ಒಂದು ಕೊಟ್ಬಿಡಿ, ಒಂದು ಕಾಸ್ ಲಿಸ್ಟ್ ಮಾಡ್ಬೇಡ. ಒಂದು
ಆಲ್ಮೋಸ್ಟ್ ಮುಗಿದೋಗಿದೆ.
ಮುಗಿದೋಯ್ತಲ್ಲ?
2-3 ಇದೆ.
ಇವ್ರಿಗೋಸ್ಕರ ಬೇರೆ ಒಂದು ಹೊಸ ಕೋಡ್ ನ ಕ್ರಿಯೇಟ್
ಒಂದು ಕೋರ್ಟ್ ಸಪರೇಟ್ ಕಾಸ್ ಲಿಸ್ಟ್ ಎವ್ರಿ ಡೇ. ಅದು ಈಗಲ್ಲ, ಈಗ ಎಲೆಕ್ಷನ್ ಬರ್ತಾ ಇದೆಯಲ್ಲ
ಅದಕ್ಕೆ.
ಈಗ ಎಲೆಕ್ಷನ್ 1 year ಮುಂಚೆ, 1 year ಆದ್ಮೇಲೆ. Yes, one HCGP.
ಇಲ್ಲ, private.
Oh, sorry. Emergent notice to the respondent returnable by the 3rd September. The petitioner is also at liberty to serve on the counsel who represents the respondent in the trial proceedings. That shall be an interim order of stay of further proceedings where the petitioners till the next date of hearing. 13, 14, same.
Number 15.
The petitioner.
Mayur,
138 matter.
what made you move 230?
Malaj, this is the connected matter of that 69 Malaj, offense.
69 ah?
54-year-old lady files a complaint against a 30-year-old. Your lordships was pleased to dispose it off.
Yaudadu?
Malaj, if your lordships gets annexure E, Malaj, your lordships order is a part of the petition.
Yoga teacher da?
No, no, Malaj.
Alva?
Malaj, she had at least about 6 to 7 degrees.
6 to 7 degrees?
Yes, Malaj. Very, very well educated complainant.
ನಾನು ಯಾವ dispose ಮಾಡಿದೆ
But
Mayur?
annexure E is your lordship's order.
Page?
Page number 745.
745 ah?
Well, there are 3 volumes, Malaj. The reason why there are 3 volumes, it's a 138 matter. It's a charge sheet of the SC case that is attached along with this file. The reason why we have attached this is the check is filed for 35 lakhs. The charge sheet is very clear.
Adakku she says, don't call and torture me.
That's the case. That's now the complaint under 138 is filed for 35 lakhs, Malaj. The only transaction is 8 lakhs and I have paid in excess of 10 lakhs.
Oh, one ನಿಮಿಷ sir. ಏನ್ ಇದ್ಯಾವುದು ಮೊನ್ನೆ ಮಾಡ್ದಂಗಿದೆಯಲ್ಲ
Yes, Malaj.
ಇದಿಲ್ಲ co-accused ah?
No, Malaj. Malaj, this is a 138 matter by the same complainant against the same petitioner. The reason why I filed that order and the charge sheet is because the charge sheet has also gone into the issue of this money transaction.
Oh.
Yes. Now, 8 lakhs was the amount that is paid by her. She calculates interest at the rate of 24% per annum and she's filed for 35 lakhs.
Principal?
Yes.
14%.
Yes.
Yes. ಅವ್ರಿಗೆ ಹೆಂಗ್ ಸರ್ವ್ ಮಾಡ್ತೀರಾ ಈಗ?
The advocate appearing in the trial court, Malaj.
ಅದಕ್ಕೆ ಕೇಳಿದ್ದು, ಅದಕ್ಕೆ ಸರ್ವ್ ಹೆಂಗ್ ಮಾಡ್ತೀರಾ ಅಂತ ಕೇಳಿದ್ದು. ಯಾಕಂದ್ರೆ ಅಡ್ವೊಕೇಟ್ ಮೇಲೆ ಕೇಸ್ ಡೆಫಿನೆಟ್.
My lord, I'll ask the SPP's assistance in that.
SPP ಮೇಲೆ ಹಾಕ್ಬಿಡ್ತಾರೆ.
It's very simple case, Malaj. 8,80,000 is the transaction as per the charge sheet. The entire account statement.
I heard the Learned Counsel Mayur Banu appearing for the petitioner. The subject petition is a rehash of what is decided by this court, Annexure E. Rehash for the reason that the allegation was the transaction of money between the petitioner and the complainant on the alleged promise of marriage. As observed in the order that is passed, the petitioner was a student, teacher.
Oh, my lord, I was an employee. I was working in a...
Petitioner was an employee in the school in which the...
My lord, they met on Facebook. They met on Facebook, my lord.
So, you met on Facebook, ashtena?
Yes, my lord.
The petitioner and the respondent meet on Facebook. What separates them is only 20 years. But is said to have had all relationship on the promise of marriage. The one such transaction is the one that is projected in the case at hand. In that light, there shall be an interim order of stay of further proceedings square the petitioner till the next date. Obretana iradu.
Yes.
Further proceedings in CC 32578 of 2025 till the next date of hearing, 2nd September.
Oblige, my lord.
ಮುಗಿತಾ ಇದೆಯಾ ಮೇಡಮ್? ಮುಗಿತಾ? ಮಾಡಿ.
Be taken up in fresh matters, Malaj. I'll serve a copy.
ಬರೇ ಫ್ರೆಶ್ ಇನ್ ಮೇಲೆ. ಎಸ್. ಇನ್ನು ಉಳಿದಿರೋದು 4-5 ದಿನ ಇದೆ. ಇನ್ನು ಬೇರೆ ಏನ್ ಮ್ಯಾಟರ್ ತಗೊಳ್ಳಿ.
List continued.
Lords, before list continues, one passed over matter, my lords. At time learned the SPP was not present, so my lords have passed over. This with regarding to the temple matter, my lords.
Which temple? ಅದು ಅದೇನೋ ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
Your lordship can quash that against one.
Against the present accused ಅಷ್ಟೇ.
That can be. There's no material, my lord, because
We'll record it. Please. ಆಯ್ತು.
That's on one case, my lord, can be.
ಇದು ಒಂದೇ. We'll take it on Monday and quash it. Monday fresh matters. Please. ಈಗ ಟೈಮ್ ಇಲ್ಲ. Yes.
Number two, list continued. 14.
Madam,
Appearing
Monday
for-
ಎಷ್ಟಿದೆ?
Petition.
ಇವಾಗ ಟೈಮ್ ಇಲ್ಲ, ವಿಲ್ ಆಲ್ ಅಡ್ಜರ್ನ್ ಇಟ್ ಟು ಮಂಡೇ, ಟ್ಯೂಸ್ಡೇ, ವೆನ್ಸ್ಡೇ.
My lord, it's for charges.
ಇಂಟರ್ ಮಾಡಿರೋದು ಯಾವತ್ತು ತಗೊಳಲ್ಲ, ಒಂದ್ ನಿಮಿಷ.
It's for
ಇದು ದಿಸ್
charges
ಇಸ್
27.
wait. List the matter on Tuesday, fresh matters. Next. ಒಂದ್ ನಿಮಿಷ. 20th ಇವತ್ತಾಯ್ತು. 24th and 85. 25th, 27th, 28th. 31st. Yes. ಅದೇನು ಅಶೋಕ್ ಟಿ ಎಲ್ಲಿ ಒನ್ಸ್ ಮುಂದೆ ಬನ್ನಿ ಮೇಡಮ್. 27th ಅದಕ್ಕೆ ಅದು 25th ಹಾಕಿ. ಎಸ್ ನೆಕ್ಸ್ಟ್
Serial number 15 my lord.
ವೇಟ್ ಒಂದೊಂದಾಗಿ ಕರಿ, ನೋ chaos.
Please my lord, petitioner my lord. Covered judgment my lord.
Urgency ಏನು?
Covered judgment.
List on 31st in the fresh matters list. Next. Siddharth.
And there is no stay my lord 15.
31st will dispose it, sir.
Please.
16th.
Interim
16, 2 weeks, I will, next. One ನಿಮಿಷ ಕೊಡಿ.
Connected with the.
Oh, this kitty potty.
Connected with it, but I'll distinguish it.
No problem. Tell me, sir.
Please.
This will have it on Monday, fresh matters.
May I request 27th?
No,
I have a
sir,
flight
Monday
on
fresh
24th,
matter.
27th, no, because I have a flight on
Monday,
24th.
fresh matters. Yes.
I think if it becomes late,
Monday,
I'll miss my
fresh
flight.
matters. Yes.
Lord, I'll miss my flight, my lord. That's
Where,
why.
sir?
I'm going to Delhi on 24th, my lord. It's a 7 o'clock flight.
25th,
Delay.
25th, fresh matters.
But 24th I'll be in Delhi, my lord. 24th I'll be back in.
They'll bury that. Siddharth, I'll tell you, in every case, if this is the swan song that is being sung, you'll lose the court.
I understand, my
Not
lord.
correct
In fact,
at all.
my lord, I
Not
realized
correct
that,
at
I
all.
realized that on the previous occasion, I realized that
This
I was
I've
not seeking
been
for
seeing
time.
for the last 2 months.
No,
Sorry
I
to
was not
say,
seeking
this is not
time.
correct.
I apologize, my lord, if that's
No. Every time this has been happening.
then my lord, may I request it be taken up in the fresh matters?
The fresh matters only, sir. Yes.
Because if it goes post 4, I may miss my flight. That's the only thing.
Post 4 ಇಲ್ಲ, ಬೆಳಗ್ಗೆನೆ ತಗೊಂತೀನಿ.
Which is why
Fresh matter le ತಗೊಂತೀನಿ.
24th I'm here.
Yes.
I apologize, my lord, if I put this
No,
across in any way.
shouldn't do that. Every case, this is not good,
Lord, in
Siddharth.
that, my lord, I had no, because the bank
Not
statement was
correct.
not there.
Every case ಅಲ್ಲಿ ಚೆನ್ನಾಗಿರಲ್ಲ.
I apologize if
Yes.
that's there, my lord. I'm sorry.
All right.
Please.
24th, fresh matters. Yes.
17.
Split up, my lord.
29th, next.
18.
My lords, I'm
Akash.
coming under the petition as well. It's very simple.
Can it
matter.
be on 31st?
My lords,
Can it be on 31st? Yes or no?
it can.
There is no time for argument listing.
I'm requesting for Monday, that's all, my lords.
No, Monday, ಅದು urgency ಇದೆ ಅಂತ ಅಷ್ಟೇ. Yes. 31st ಆಗ್ಬೋದಾ?
I only have one submission. my
31st
lords.
ಆಗ್ಬೋದಾ?
The urgency is that the police have been harassing the pursuant to the FIR, my lords.
Bail ಇದೆಯಾ?
FIR ಆಗಿ I only have one submission, my lords. Only one
List on
submission.
30. ಈಗೇನು ಎಂಟ್ರಿ ಮಾಡಿರ್ಬೇಕಾ?
ಹ್ಞೂ ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ಲ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಸ್ವಾಮಿ.
ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲಿದೆ?
My apologies.
Yes.
My apologies.
Yes. 31st.
19.
Please, I'll file an application.
Yes.
in the meantime.
19.
So, appearing for the petitioner regarding the payment of 20% as fine amount in NI Act proceedings. I have paid the money, my lord.
28th. Yes.
Please, my lords.
Next. Same.
20th. my lord.
ಅಲ್ಲ, sorry. 31st. ಎರಡು.
Please, my lords.
Yes. Next.
Interim order, my lords.
That will continue.
Seal number 18, I filed an application, my lords.
We'll see. ಅಲ್ಲ ಮೇಡಮ್, ಇವ್ರದ್ದು ಆಕಾಶ್ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ ಅಂತಲ್ಲ.
Again, sir.
ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಕೊಡಿ.
Please. It's a part of my petition itself. Here,
Acknowledgement.
here, my lords.
ಅಕ್ನಾಲಜ್ಮೆಂಟ್.
ಇದೆ.
Monday.
I'm grateful.
24th. Yes.
Fresh matters, my lords.
ಹ್ಞೂ ಸರ್, ಫ್ರೆಶ್ ಬೇರೆ ಯಾವ ಮ್ಯಾಟರ್ ತೊಗೊಳಲ್ಲ. ನೆಕ್ಸ್ಟ್.
20.
21.
21 covered my lord, KP Act.
ಅಲ್ಲ, ಪೇ ಮಾಡಿದಾರಂತ. ಲಿಸ್ಟ್ ಆನ್ 31st. 31st again covered. Yes.
21.
Suyog.
I appear for petitioner's counsel.
31st,
My lord, some urgency, my lord.
emergency.
Lord, this is a matter where, my lord, my property has been, the documents has been forged and, my lord, sold by the respondent number 2, Mr. Chaco. My lord, there are 20.
Oh, Joseph Chaco.
Yes, my lord, that matter, my lord. Now he filed complaint against me, my lord, I am the landowner. Therefore, my lord,
Tuesday, fresh matters.
Lord,
Yes.
some interim protection was granted. It was not uploaded in the order, my lord.
I did grant.
Yes, my lord. No
Course,
coercive
not to take
steps.
course steps ಅಂತ ಹೇಳಿದ್ನಲ್ಲ.
ಹೇಳಿದಿರಿ ಅದರ ಬಟ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅದು that ಈ ಕೋರ್ಟ್ಸ್ ಅಲ್ಲಿ ಇಲ್ಲ.
Yeah, ಈ ಕೋರ್ಟ್ ಅಲ್ಲೂ ಇಲ್ಲ.
Your lordship may grant then.
Let's see. Will not to take course steps. Actually ಡಿಕ್ಟೇಟ್ ಮಾಡಿದ್ದೆ ಅನ್ಸುತ್ತೆ.
ಹೌದು ಮಾಡಿದಿರಿ ಬಟ್
ನೋಡ್ತೀನಿ. ವಿಡಿಯೋ ಅಲ್ಲಿ ಇದೆಯಾ? ಟೈಮ್ ಸ್ಟಾಂಪ್ ಅಲ್ಲಿ ಇದೆಯಾ?
ಇರುತ್ತೆ.
Yes sir. Yes.
23.
23. A former director has been arraigned as an accused.
31st ವರೆಗೂ ವೇಟ್ ಮಾಡ್ಬೋದಾ?
It is already stayed, that's all.
Already stayed. ಯಾರಿಗೆ?
In another matter, my lord.
Same. Tag along with same order. Next.
48 also same, my lords.
Liver
Please.
ಬರ್ತೀನಿ ತಾಳ. ಏನ್? 31st. Yes. ಮಧು. ಮಧು ಏನ್ ರಾವ್? ಹೌದಾ? ನೋಡೋಣ ತಾಳಿ. ಎಸ್. ಹಾ.
24.
And Girish?
My lord, can I request for Tuesday or Thursday?
What is the matter?
This is a land dispute, my lord, which is turned into a criminal complaint.
Thursday, fresh matters. Yes, next, 26th, 26, ಅಲ್ಲ, 25, Raghu. 31st, 26.
I appeal for the
Lords, is that matter where Parle-G biscuit or Nai biscuit one that's extensively
No,
heard
no,
by
very
your
sorry,
lordship?
my lords. I take a strong contention that let that
Hey,
word not
Parle-G
be
is not
used.
dog biscuit. Why are you taking that? Yes. Oh.
Allah, let that not be taken time and again, my lords. I'm sorry, my lords.
ಅಲ್ಲ ಅದು ಈಗ ಏನಾಗುತ್ತೆ?
ಇಲ್ಲ, I'm ready to argue the
ಅಲ್ಲ,
matter.
ಕೆಲವು ಕೇಸ್ಗಳಿಗೆ ಐಡೆಂಟಿಫಿಕೇಶನ್ ಆ ತರ
ಗೊತ್ತು, ಬಟ್
ಬೇರೆ
ಅದೇನಾಗ್ತಾ ಇದೆ ಅಂತ ಹೇಳಿದ್ರೆ ವಿಡಿಯೋನಲ್ಲಿ ನೋಡ್ಬಿಟ್ಟು ಕ್ಲೈಂಟ್ ನನಗೆ ಟಾರ್ಗೆಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಆನ್ಸರ್
Seriously, I'm sorry to say this.
Yes sir. List the matter on 31st. Yes.
Interim order may kindly be.
That will ಇದೆಯಾ?
Interim
2
order.
weeks IO. Yes, next.
Lordship, it's extensively heard. May I request
ಅಯ್ಯೋ ಬೇಡ.
please further hearing.
You'll get
On
perfect order
several
after
occasions,
7th.
even learned senior has argued. Sir, ಬಂದಿದ್ರು.
31st. Yes.
Deeply obliged.
Next.
27. Interim order.
2 weeks. Anandaram.
28.
Covered matter.
ಯಾವುದು? ಆನಂದರಾಮ್ದ. Tuesday, fresh matters.
29.
Oh, I'm for petitioner, my lord. She has filed a cancellation of bail.
ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡ್ತೀವಿ, ಪಿಟಿಷನ್ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಕನೆಕ್ಟೆಡ್ ಮೆಟಲ್ಲಿ.
ಅಲ್ಲ, ಅಲ್ಲಿ ಪ್ರೌನ್ಸ್ ರಾಚೆ ಸಾಹೇಬ್ರ ಮುಂದೆ ರಿಸರ್ವ್ ಆಗಿದೆ ಅಲ್ವಾ? ಆ ಪುರಲ್ಲಿ ಕಾಪಿ ಕೊಡಿ ಫಸ್ಟ್. 25th fresh matters.
28
ಯಾಕೆ?
ಸೀನಿಯರ್ ಅವೈಲೇಬಲ್ ಇರಲ್ಲ.
ಆಯ್ತು, 27th.
We are in urgency, my lord.
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ ಸರ್, ಪ್ರೊನೌನ್ಸ್ ಏನಾಗಲ್ಲ, ಡೋಂಟ್ ವರಿ. ಅದಾದ್ರೂ ಐ ವಿಲ್ ಟೇಕ್ ಇಟ್, ನೋ ಡೋಂಟ್ ವರಿ. ಎಸ್, ದಟ್ ವಿಲ್ ಬಿ ಇಂಟ್ರಿ ಮಾಡೋ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಯಾರು ಕೇಳಬೇಡಿ, ಎಲ್ಲ ಕಡೆ ಮಾಡ್ತಾರೆ. ಎಸ್
For the petitioner, my lords,
Madam.
ಇದರಲ್ಲಿ section 9.
ಎಸ್.
My lords, ಇದು section 91 ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡು
31st.
ಬಂದಿರೋದು.
ಎಸ್.
My lords, before that, my lords, because
31st.
ಇನ್ನೊಂದವರು ನಾನು ಮೆಮೊ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಹಾಕಿದ್ರೆ ಮತ್ತೆ ಇನ್ನೊಂದು ಸೇಮ್
31st. ಎಸ್. ನೆಕ್ಸ್ಟ್
31.
Monday, my lords, the short questions involved. The peculiar jurisdiction concern.
ಟ್ಯೂಸ್ಡೇ.
The
Yes.
first list, lordship.
ಇರೋದೇ ಒಂದು ಲಿಸ್ಟ್ ಸರ್.
32.
ಸಿದ್ಧಾರ್ಥ್.
Section 34 dismissed for non-prosecution. I have a judgment on the point. My lords had asked me to get
Correct,
a
ಇದು
judgment.
old.
ಹೌದು. I have a judgment on the point itself.
ಈಗ ಯಾವಾಗ ಬರ್ತೀರಾ ಇದಕ್ಕೆ?
My lord, I will not take that chance. I will not take that risk.
27th? 27th fresh matters.
Please.
ಅದನ್ನು 27th ಹಾಕ್ತೀನಿ. The other matter also, you fly without any
I
tension.
will not. Please, I'm grateful, my lord.
No, it's not.
My lord, the only thing is I've been traveling a lot this month. That's the only issue, my lord.
Because it's the admiration for you that makes me speak like this. It's not-
I
you should not do
apologize,
that.
my lord. I apologize. I'm sorry.
Yes, all right.
Grateful.
ಎರಡು 27th and our time ಕೇಳಬೇಡಿ. ಎರಡು 27th ತಗೊಂತೀನಿ. Don't
I'm-
take time on
Please,
that.
please.
For the petitioners, my lord,
For
kindly
30?
to take petitioners,
Hmm.
33, my lords.
Hmm.
The ED council has already filed their objections, my lord. There's absolutely
So
no
this is
grounds.
Pavinder Singh ಇರ್ಬೇಕು.
In another matter, my lord, there are two matters.
ಅಲ್ಲ, ಇದೇನು ಪವಿಂದರ್ ಸಿಂಗ್ ದಾ?
No, my lord.
ಅಲ್ವಾ ಹಂಗಾರೆ?
My lords,
Yes.
ED has already filed their objections. There's absolutely no grounds
Connected
against,
matter, we have
alleged
not grounds filed
against the
objections.
petitioners, my lord.
31st, yes.
Please, oblige.
35. Siddharth?
34, my lord, 34 is a sub-registrar matter, my lord. This side.
Which I
think, my lord,
Chennai.
has lost fizzle now because the Chennai High Court has also said that proceed only against those people who have received the money.
Same 27th.
Please.
Yes.
Great.
All your matters will finish on that.
I'm grateful.
35.
IO 2 weeks, yes.
Appearing for the petition.
Next.
My lords, it's related to the excise sub-inspector matter, my lords.
For the respondent, my lord.
So what? 2 weeks, IO, next. Yes, same.
Lord, from yesterday it is posted.
ಯಾವುದು ಸರ್ ಇದು?
This is Sessions case.
Oh, that is transfer from one court.
Transfer, my lord.
Oh,
The consequence
ಸೋಮವಾರ
is very
ತಗೊಳ್ಳ?
serious, my lord.
Monday ತಗೊಂತೀನಿ. Monday I will dictate. I am ready for dictation also.
Yes.
I'll take it on Monday. Yes, sir. You're all right.
All right.
ನೀವು ರೆಸ್ಟ್ ತಗೊಳ್ಳಿ ಸರ್, ಮಂಡೇ ತಗೊಳ್ಳೋಣ. Yes, sir.
All matters every day it will be there, my lord.
ಏನ್ ಮಾಡೋದು? Yes, sir. Monday, sir.
38.
My lord, 38, there are total 11 connected matters.
ಏನಪ್ಪ
All are
ಇದು?
covered, my lord.
Covered?
Yes, my lord.
By,
Yes, sir.
with what, sir?
Because, my lord, the company is not named as accused. Your
Anita
lordship.
Hada?
Yes, my lord, same, my lord.
138 proceeding.
It's IPC proceedings, my lord, but they invoked Chit Fund Act. For that also, my lord, your lordship quashed the proceedings. I have judgment.
Reserving liberty to implead.
Please, my lord.
SPP ಅವರೇ. Reserving liberty to implead the company.
That's also same order.
ಅದನ್ನೇ ಮಾಡಿದ್ದೀನಿ ಅನ್ಸುತ್ತೆ.
Yes, my lord.
Shall be at liberty to take appropriate action in accordance with law. ಇಲ್ಲೇ ಇದೆ. Same.
Just to clarify, my lord.
I'll clarify. ಏನು ಅಂತಾನು ಬರೆದು ಬಿಡ್ತೀನಿ ಇದ್ರಲ್ಲಿ. ಇದು ಎಲ್ಲ ಕವರ್ಡ್ ಅಂತ ಇದಕ್ಕೆ ಫಾಲೋ ಮಾಡಿ ಕ್ಲೋಸ್ ಮಾಡಿ. ಲಾಸ್ಟ್ ಅಲ್ಲಿ the respondent state is at liberty to implead the company as a party respondent in the proceedings and party respondent and take up the proceedings in accordance with law.
The respondent police are at liberty to conduct further investigation and implead the, because otherwise, my lord, if you file it without.
ಅಲ್ಲ ಈ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಹೋದ್ಮೇಲೆ ಫರ್ದರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಹೆಂಗಾಗುತ್ತೆ?
ಅಲ್ಲ, your lordship is quashing the charge sheet.
Quashing the charge sheet.
It's only for the reason that we have not impleted the
ಹೆಂಗ್ ಮಾಡೋಣ? Yes, ಬರ್ಕೊಳ್ಳಿ. The respondent state stroke the investigating officer is at liberty to implead the company as a party respondent to these proceedings in the further investigation as the case would be. That would suffice. Last ಅದ್ ಹಾಕ್ಬಿಡಿ, ಎಲ್ಲ ಕೇಸ್ ಕ್ಲೋಸ್ ಮಾಡಿ.
Great.
ಮತ್ತೆ ಬರ್ತಾರ ಬಿಡಿ, ನಿಮ್ಮ ತೊಂದ್ರೆ ಇಲ್ಲ. Yes.
Please.
Disposed. ಯಾರು ಇಂಪ್ಲೀಡ್? Serial number 38.
39. Entry model.
39, we have entry model, my lords. 39.1, same allegation, same person, my lords.
The interim order subsisting in 39 shall continue to the next date of hearing. In the light of the interim order subsisting in 39, there shall be an interim order in 39.1 as well. Number hakbudi. List after 2 weeks. Yes.
Great.
Sachin.
40.
I appeared for the petition, my lords. NBW is issued.
LBW?
NBW. my lords, is-
NBW.
Lords, 31st is the date for hearing before charge and NBW. Lords, 171E, my lords, is the allegation. Truck Ali, my lords, already annexed, my lords, the judgments also.
Kodi.
Lords, at page, Lords, 94, my lords.
171E.
171E, 87, my lords, recent.
Page.
87.
Same order. Covered, closed. Next.
Please, grateful.
41. Post immediately after service of notice upon the respondent.
42.
2
weeks time is granted to comply with the officer. In Venkateshwar Patti.
498A 323, my lord. Serious injuries caused to the complainant and
Stay
brother.
ಕೊಟ್ಟಿದ್ದೀನಾ?
ಇಲ್ಲ
2 weeks. IO. Next.
ಅಲ್ಲ, IO
Sorry,
ಇಲ್ಲ.
2 weeks. to comply with the office objections.
Great.
Flow al banbiduttana sir.
43.
I'm for the petitioners, my
Post
lords.
immediately
43.
after service.
My
notice
lords,
upon
it's
the
been
respondent.
served, my lords. July 16th ಗೆ serve ಆಗಿ
ಆಯ್ತು
ಬಂದಿದೆ.
ಬರ್ಲಿ. Huh? Yes, yes, next.
My lords, 31st, my lords, kindly.
No, no, sir. Yes. If it's my order, no, sir. Yes.
My lord, appearing for respondent number 2, my lord. Mediation is still going on, my lord.
Learned counsel for the
Mediation date is on
44 parties to the list submit mediation process. The talks of mediation is still on. List the matter after 2 weeks. Yes,
My
next.
lord, kindly request on 7th, my lord, next month, please, my lord.
7th September.
On September.
Oh, very good, sir. 7th
Interim order
September.
mediation.
Yes. Interim order subsisting will continue to the next date of hearing. Yes.
Thank you, please.
Post immediately after service notice for respondent. Next.
46.
Maintainability anything.
2 petitions.
List on 8th September. Next.
47.
Post immediately after service notice upon the second respondent.
48.
Lord,
Bharat.
same as 23, please.
ಏನಿದು? Same as 23. Oh, 48. ಕೊಡಿ. 20 tag with 23. 23 ಇಂದ ಅಲ್ಲಿ same order ಮಾಡಿದೀನಿ ಅದೇ order ಮಾಡಿ. Next.
Lords, 49.
49.
It may be had on 27th and tagged along with the number which I gave, my lords. There is a duplication of proceedings. I will ensure that one proceeding stays,
31st.
please.
Yes. 49, 31st. Yes.
It will be
50.
tagged along with that.
Tag along with 49. 48.
No, no, the
Yes.
number I'll give.
ಕೊಡಿ ನಂಬರ್ ಕೊಡಿ. ಎರಡಿದ್ರೆ ಒಂದು ವಿಡ್ರಾ ಮಾಡ್ಬೇಕು. Yes. Next. Madam. 48, 49 same parties.
Same, but 49 there is duplication of proceedings. That's why we are taking.
ಆಯ್ತು ಸರಿ. 49 ಮಾತ್ರ 31st ಹಾಕಿ. Yes, next.
My lord, 50. 50, my lord, I am seeking some time, my lord, your lordship
ಕಾಸ್ಟ್
directed.
ಇಂಪೋಸ್ ಮಾಡ್ಬೇಕು ಅಷ್ಟೇ ಇನ್ನು.
ಅಲ್ಲ, affidavit
Affidavit, ತಪ್ಪು affidavit ಹಾಕಿದ್ದೀರಾ ಅಂತ. List on 2nd September finally at the request of the council appearing for the respondent. Next. 51.
51.
7A ಯಾವತ್ತು ಹಾಕಿದೀವಿ ಮೇಡಮ್? 27, 2:30 PM. Yes, next.
52.
For petitioner, my lord, case has been transferred to for concerned
Huh?
cyber for
This is that legal pay matter.
CID ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ನಲ್ಲ?
Cyber crime.
ಸೈಬರ್ ಕ್ರೈಮ್ಗೆ ಕರೆಕ್ಟ್. ಎಸ್. ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks. ನೆಕ್ಸ್ಟ್. ಪ್ರೋಗ್ರೆಸ್ ಹೇಳಿದೀನಾ? ಪ್ರೋಗ್ರೆಸ್ ಆಫ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್.
Next date.
ಆಯ್ತು. ಎಸ್. ನೆಕ್ಸ್ಟ್. ಥರ್ಡ್ 18 September ಹಾಕಿ. To report progress of investigation. Next. 53 post immediately after service of notice upon the respondent.
My lords, for petitioners, my lords, in that matter, they have settled the matter, my lords. We will file a joint memo.
Which matter, sir?
53, my lords.
Learned counsel for the petitioner submit parties have settled the dispute and would file a joint memo on the next date. List the matter on 31st.
Monday or Tuesday.
25th at 4 PM to report settlement. Next.
Much obliged.
54.
54 also, my lordship, it is settled.
Settled.
ಅದು parties ಆದ್ರೆ
ಇವಾಗ್ಲೇ.
earlier litigation settle ಆಗಿತ್ತು, ಅದು ವಿಡ್ರಾ ಮಾಡಿರಲಿಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಸೊ ಈಗ
ಈಗ
ಅಡ್ವೊಕೇಟ್
ಏನ್ ಬೇಕು ಹೇಳಿ.
ಪ್ರೆಸೆಂಟ್ ಇದಾರೆ, ಕ್ಲೋಸ್ ಮಾಡಬಹುದು.
ಹಾ ಸರ್ ಅಷ್ಟೇ. ಎಸ್. ನೆಕ್ಸ್ಟ್. ಪಾಸ್ವರ್ಡ್.
55.
Post immediately after service of notice upon the respondent.
56 is a matter regarding illegal immigrants SOP.
SOP, wait. Yes, list this matter on 25th. 27th. Yes.
Your lordship have it first week, my lord, for further.
First week ಅಂದ್ರೆ I'll have to treat this as part third. Vinay Venugopal idala. Yes. List the matter on 7th September at 4:30 PM for further hearing. Yes. ಇದು ಅಷ್ಟೇ 56 point. Oh, ಇದು ಬಾಂಗ್ಲಾದೇಶ್. Yes.
And 56.1 and 56.2, the complainants are deported. So 56 will survive.
ಆಯ್ತು, we'll see on that day. Yes. Next.
57.
Admission. 2 weeks, yes.
58.
2 weeks.
In this case, your lordship.
2 weeks, 2 weeks.
Dispute, your
No
lordship.
problems. 2 weeks, yes.
59.
I appear for the respondent.
2
For the
weeks.
petitioner, my lord.
Next.
60.
My lord, petitioner, my lord.
Interim order
Any
ಇದೆಯಾ?
date, my lord. Interim order.
2 weeks. Next.
Any date, my lord.
No. Yes.
61, my lord, sir.
Rajshekar.
There is interim order, my lord, they issued notice, my lord.
2 weeks.
My lord, in
Next.
spite of interim order, my lord, they issued notice for collection of voice sample.
Poison.
Voice samples collection.
Voice sample. ಅದು you have to not to take coercive ತಾನೆ
ಅಲ್ಲ,
ಕೊಟ್ಟಿರೋದು.
precipitate the matter.
ಅಯ್ಯೋ,
Lord, in
under-
59, interim order has to be extended, my.
That will be extended, sir. Yes. Next.
62.
notice ಆಗಿದೆಯಾ? Yes, next 2 weeks.
My lord, Lord, in this case, the trial has not commenced now. I've got the endorsement.
31st,
The
yes,
consideration may be
31st,
delayed because-
yes, next.
because there is no
31st,
investigation by the petitioner.
31st ಬೇಡವಾ?
21st.
31st, yes.
21st.
21st?
That,
31st, sir, yes.
and Monday.
Mondayನೇ 31st, yes, 64.
The date of hearing is on 31.
No problem,
So
31st,
maybe
yes,
two
yes,
days-
next, next.
2 days earlier. madam.
No, sir, yes.
2 days.
31st ತಗೊಂತೇನೆ ಸುಮ್ಮನೆ ಇರಿ sir. Yes.
ಇಲ್ಲ, madam,
ಏನಾಗ್ಬಿಡುತ್ತೆ?
ಅಲ್ಲ, the honorable court asked whether the trial has commenced. Trial has not commenced.
No problem.
Instigation of death, lord. Death by hanging.
No problem.
So there is
Yes.
no point at all. So
It's
therefore.
306 IPC, sir, yes. List on
And
31st.
there is no death note also. As per
List
the
on 31st, sir. Yes.
31st is the date, lord. Therefore,
ಏನು ಕನ್ವಿಕ್ಟ್ ಮಾಡ್ತಾರ ಅವತ್ತು? ಮತ್ತೆ?
if the trial is commenced, the court is of the
ಯಾಕೆ
opinion.
if trial commences I can't take, is it?
Last time it was, opinion was,
ಯಾರು ಮುಂಚೆನೆ ಆಗಿದ್ರೆ ತಗೊಳ್ಳಲ್ಲ ಅಷ್ಟೇ.
the trial has not yet commenced.
No worries, sir. Yes, next.
One day,
31st, sir.
30th.
Yes. No,
Because date-
30th. 30th, ಕೊಡಿ.
Date of
30th ತಗೊಳ್ಳಿ. Yes, next.
Date,
30th. Yes.
30th, maybe, may not, maybe a Sunday, Sunday. Therefore, I was not, sir, maybe one day.
29th.
28. 28.
List on 31st, sir. Yes, yes,
This one.
don't waste time. ಅವತ್ತೇನು ಕನ್ವಿಕ್ಟ್ ಇಲ್ಲದ್ರೆ ನಾನು 7th September ಹಾಕ್ತೀನಿ ಈಗ. ಮತ್ತೆ ಸುಮ್ಮನೆ ಇರಿ. Yes.
Trial has come, not.
7th, list on 7th September. Yes.
64,
2 weeks.
65,
No stay matters. 115 and 74. There's an injunction order in my favor. Complainant also.
Notice ನಾನೇ ಕೊಟ್ಟಿಲ್ಲ. Stay ನಾನೇ
Complainant
ಕೊಟ್ಟಿಲ್ಲ.
also suffers an interim order, please, my lord, where, my lord, injunction is, my lord,
ಆಯ್ತು.
what they would say in the
30,
complaint.
31st, yes.
PW ಇದೆ ಅದು.
That LBW,
NBW.
31st, yes.
Please.
66,
So the
2
petitioner, my lord.
67,
2 weeks.
68,
My lord, 20.
2 weeks. 2 weeks.
My lord, 67 on 31st.
No, entry ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ.
Against the husband, it was not there, my lords. On the last.
Husband ಆ?
ಹೌದು, my
ಪರವಾಗಿಲ್ಲ.
lords. On the last occasion, my lords was convinced on the complaint, my lords. There was
No, I don't, will see, sir. Yes, next.
MMRD, my lord. Respondent has.
Stay ಇದೆಯಾ?
Stay ಇಲ್ಲ.
31st, yes. Anyway, 31st, yes.
70 petitioner, no stay, 31st.
31st, yes.
71,
71, my lords, I'm for the petitioner. My lords, this is the matter where, my lords, the student was urinating at the railway track and, my lords, 75B came to be instituted against him.
Oh, yes. List on 31st in the fresh matters list. Yes.
So grateful. My apologies, my lords, for appearing to VC.
Yes, sir. ನೀವು ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
I'm sorry, my lords.
All right, ಏನಿಲ್ಲ. Yes, next.
Interim order may kindly be extended, my lords.
That will be extended. Yes.
Grateful.
70? ಏನ್ ಬೇಕು? 2 weeks ಆಯ್ತು. Next.
73,
73, there's some urgency, my lord. The petitioner has to travel abroad.
lord.
It's criminal trespass.
One minute.
73,
Who has to travel abroad?
the petitioner, my lord.
You are appearing for the respondent.
I'm for petitioner, my lord.
73.
I am,
Yes, my lord.
Kirti Reddy for R2.
I'm sorry.
For
73.
petitioners,
Interim order ಇದೆಯಾ?
in-laws, my lord. No, my lord.
2 weeks, yes.
We have kept it for the disposal, my lord. Maybe have it on Monday, my lord.
We'll
Because
dispose
you
it,
already
sir.
heard about the matter.
Sir.
Yes, my lord. I
Aro-
mean, if the trial is closed.
The next bench also will dispose it, sir. ನೀವು argument ಮಾಡದೇ ಬೇಕಾಗಿಲ್ಲ.
74, there is no
Mashallah.
stay, my lord.
ಹಾ.
74, there is no stay, my lord. So, but in-laws ಮೇಲೆ ಕೇಸ್ ಇದೆ ಸ್ವಾಮಿ.
In-law stay ಕೊಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಎಲ್ಲ in-laws ಮೇಲೆ.
ನಾನೇ ಸ್ಟೇ ನೋಟಿಸ್ ಮಾಡಿರೋದ ಯಾರು?
ಅಲ್ಲ ಸ್ವಾಮಿ.
31st in fresh matters.
Stay may be granted.
ಅದೇ ಅವತ್ತೇ. Yes.
75,
Before the trial court on 28, ma'am, before.
ನೋಟಿಸ್ ನಾನು ಮಾಡಿರೋದು ಮಾಡಿ.
No, ma'am.
31st, yes. ಸ್ಟೇ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
31st.
28.
76,
ನೀವು ಏನಾದ್ರು ಮಾಡ್ಲಿ ಟೈಮ್ ತಗೊಳ್ಳಿ. Yes. 76.
No stay, my lord. So.
Madam? 2 weeks, next.
77, interim order.
2 weeks, IVO, next.
78,
Mustafa?
On last date of your lordship, asked me SPP to appear in this matter, lordship. Mines and minerals.
SPP is here, sir.
Mines and minerals. No
Mines and minerals, 31st, yes.
79, 79. Lordship, sorry.
2 weeks. 80.
Appear by petitioner.
80.
I'm for the respond number 2, my lords.
2 weeks, yes.
81.
2 weeks IVO.
82. Lordship, sorry.
2 weeks.
83.
Madam, for the petitioners, but there is a 2 years delay. Kindly see, my lord, the.
Stay ilva.
ಇಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ.
ನಾನೇ ನೋಟಿಸ್ ಮಾಡಿರದ.
Yes.
2 weeks, yes. Next.
Lord, kindly accommodate date, my lord.
Yes.
For 84. 84.
Respondent
weeks,
number
I will-
2, your lordship. I'm respondent
Yes,
number 2,
sir.
your lordship.
Yes, sir.
85.
2
My
weeks.
lord, I'm for the petitioner. My senior is quite unwell. If possible, could I get a date in the coming week?
It is given, madam. Yes.
And if the stay could be done
Oh,
until
it
the
can't. It can be, I guess. Yes, Madrappa.
86.
Next.
What about the
2 weeks, yes.
87.
Appearing for the petitioner, Your Honor. In this matter, in the main matter, the accused has been acquitted. Your Honor. This is
Split,
yes.
29th, yes. 88.
88.
Appearing for petitioners, Your Lordship. Your Lordship, this interim order was granted, Your Lordship, despite that judgment is passed.
Oh, that,
The
yes, yes. 1
matter-
minute. The list on 25th,
Your Lordship, the connected matters are coming up on Monday, Your Lordship.
24th,
The fresh matters.
24th. All right, yes. Shashank, compounding,
89.
My lords, parties are present.
settlement. Wait.
Both the parties are.
Wait, I'll just run through the list and call.
90.
Vacating stay, 2 weeks. Ella, 2 weeks.
That's 92 entry order may kindly make.
That will be extended.
Lordship 93, my lord, there is a urgency because he is a
Wait,
police.
wait. What urgency 93?
93 petitioner is a police officer, my lord. He is under the suspension order, my lord.
93. Connected matter ಇದೆ ಏನು?
Both are.
Yes, my lord. Same for accused for
Offenses
second
under-
accused number 2.
No. This is under 69.
ಆಯ್ತು. 69.
ಹೌದು.
ಪೊಲೀಸ್ ಆಫೀಸರ್.
Promise to marry.
ಇಬ್ಬರ ಮೇಲೆ ಬುಕ್ ಮಾಡಿದ್ದಾರೆ.
ಇಬ್ರು ಒಬ್ರಿಗೆ ಪ್ರಾಮಿಸ್ ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ, my lord. That.
Oh, yes. List on 31st. Yes.
My lord, interim order may extended.
That will continue, sir. Yes, next.
Oblige, my lord.
97. Withdrawal memo.
In terms of ಇಲ್ಲ ಬಂತು? No, list after 2 weeks ಮಾಡಿರಿ. Withdrawal in terms of memo. Yes, next.
98.
14%.
ದೇವರಸರಿಗೆ ಕಾಪಿ ಕೊಡಕ್ಕೆ ಹೇಳಿರಿ ಅವರಿಗೆ ತುಮಕೂರ್ದು ಬರಲ್ಲ ಅಂತ ಹೇಳಿ
ಅವರು ಬರಲ್ವಂತ?
ಬರಲ್ಲ ಅಂತ ಹೇಳಿ
ಆಯ್ತು, 7ನೇ ತಾರೀಕು ತಗೊಂತೀನಿ.
ಸರ್
ನೋಟಿಸ್ ಮಾಡಿ.
ಬೇರೆ ಡೇಟ್
7th,
ಕೊಡಿ 7ನೇ
yes.
ತಾರೀಕು ಬೇರೆ ಕೇಸ್ ಇದೆ 7 ಬಿಟ್ ಬೇರೆ
8th ಬೇಕಾ?
8 ಬೇಡ 7 8 ಬಿಟ್ ಬೇರೆ
9th.
ಓಕೆ
ಆಯ್ತು, ಎಸ್ 9th. ಸುಶಾಲ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? 2 weeks.
My lords,
ಸಿರಾಜ್
99, my lords. Serial number 100, your lordship.
100 ಗೆ ಬಂದಿಲ್ಲ ಇನ್ನು. ವೇಟ್ ಸರ್. 100, ಎಸ್.
100, my lords, 3 FIRs that are filed, my lords.
ಈಗ ಸ್ಟೇ ಇದೆಯಲ್ಲ ಮೂರರಲ್ಲೂ.
Hey, they vacating ಹಾಕಿದ್ದಾರೆ ಇವಾಗ.
ವೆಕೆಟಿಂಗ್ ಹಾಕ್ಲಿ.
Based on 307, your lordship. You are asking on 307.
ಆಯ್ತು,
Nirmala
whatever.
Devi judgment is misquoted, your lordship.
ಹಾ?
Nirmala Devi judgment is misquoted.
ಆಯ್ತು, ವಿಲ್ ಸಿ.
Lordship on 31st.
ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆನ್ 7th.
Lordship 31st you better.
ಬೇಡವಾ? ನಿಮಗೂ ಬೇಡವಾ 7th?
If your lordship is continuing, my lords.
No, I am not, sir.
Lordship are to be had, your lordship. It's a request because 307 case, your lordship. 2 matter has to be connected. Lordship
ಕೊಡಿ,
directed.
ಕನೆಕ್ಟ್ ಮಾಡಿ. ಅಷ್ಟೊಂದು ಹಾಕಿದ್ದೀರಾ 307?
3 FIRs, my lords, so there are
3
9
FIRs,
petitions.
ಕೊಡಿ, ಎಸ್. 31st.
31st. Grateful. My lords, in serial number 99, my lords.
99 ಏನು? ಸುಶಾಲ್.
My lords, here they've reduced the memo of calculation, my lords. I just have to verify, my lords. I just need 20, maybe
31st, yes.
31st, yes.
Withdrawal, 100.4 withdrawn, yes.
101, my lords.
101.
But partition suit, family members dragged in under the SCST Act.
31st, yes.
29th, my lords, if possible.
31st.
Obligation.
102.
102, my lords, senior is and
31st preliminary hearing ಅಲ್ಲ, fresh matter ಲೇ ಬರలేదు. ಮಯೂರ್.
This is organizing us.
ಮಯೂರ್ 31st fresh matters, yes. Entry ಮಾಡಿ, yes. Vipin.
The lordships are the yesterday. My lord posted it today.
ಯಾರದು?
Vipin, sir.
ವಿಪಿನ್ನ? ಏನಿದು? He's appearing or disappearing?
I'm sorry, my lord.
Yes, yes.
My lord, this was a matter, my lord. Yesterday, your lordships had heard it.
This
My
is the
lord,
training camp.
where no allegation, my lord, as such is against the petitioner in the entire charge sheet, my lord.
Cybercrime center was set up and the people were kept there, and then through them training was given to make telephone calls to people.
My lord, correct, my lord. It is against other accused. As far as accused number
No,
23 is concerned,
let us see, sir. Let us see.
my lord,
Let's
entire
come.
charge sheet, my lord, except for the co-accused statement, nothing is on record. I am
ಅದೇ
not saying
ಕೊಡ್ಲಿ
about
ಅವರು.
uh,
accused number 1.
ಕೊಡ್ಲಿ 31st, yes.
B group matter.
B group ಎಲ್ಲ 2 weeks ಹಾಕಿ.
Reporting settlement 106.
ಮೇಡಮ್ 105 ಅವತ್ತೇ ಕೊಡ್ತೀನಿ, 9ನೇ ತಾರೀಕು. 105 ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಲಿಸ್ಟ್ ಆನ್ 9th ಅಂತ.
106 reporting settlement.
ಗುರುದೇವ್ ಇಲ್ಲ ಅಂದ್ರೆ 2 weeks ಹಾಕಿ.
107.
ಒಫೆನ್ಸ್ ಏನು?
376
17ಕ್ಕೆ ಬಂದಿತ್ತು, ತಾವೇ ಇವತ್ತು ಕರೆಸಿ ಕ್ಲೋಸ್ ಮಾಡ್ತೀವಿ.
married. Marriage certificate present. 372
ಎಲ್ಲಿ ಸರ್ಟಿಫಿಕೇಟ್ ಎಲ್ಲ ಇದೆಯಾ? ಅವರೇ ಬೇಕಡಪ್ಪ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡಿ.
Along with petition, I produced my lord. Page number 55.
ಪೇಜ್ ನಂಬರ್ 55 ಬರ್ಕೊಳ್ಳಿ. ಸರ್ಟಿಫಿಕೇಟ್. ಎಸ್. ಪೋಕ್ಸೋ ಕಾಸ್ಟ್ ಆನ್ ಅಕೌಂಟ್ ಆಫ್ ಮ್ಯಾರೇಜ್ ಅಂತ ಬರ್ಕೊಳ್ಳಿ, ಮಾಡ್ತಾರೆ.
Malaysia. ವಕಾಲತ್ ಆರ್ಟ್.
ಎಸ್, ನೆಕ್ಸ್ಟ್. ಮತ್ತೆ ಬಿಟ್ರೆ ಪೋಕ್ಸೋ ವಾಪಸ್ ಸಿಗ್ನೇಚರ್ ಮಾಡಿ.
Order sheet signature.
ನೆಕ್ಸ್ಟ್.
Further hearing 109.
ಏನು ಅಭಿಷೇಕ್?
Appearing for respondent.
ಆಯ್ತು, ಒಂದ್ ನಿಮಿಷ ಇರಿ. ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಏನ್ ಮೇಡಮ್ ಇದು?
My lord, it was allowed.
UAPA.
UAPA?
UAPA ನಲ್ಲಿ we have deputy commissioner has passed an order and that order has been challenged by the
community hall was
let's
notified.
release the matter of status being part heard, post the matter after 2 weeks. Yes, next.
108.
108 ಏನು? ಏನ್ ಮೇಡಮ್ ಇದು? ಬೇರೆ ಎಲ್ಲ ಆಯ್ತಲ್ಲ? 112. Oh, sorry. Anyway, since it's by special orders, I'll take it another day. On 31st ಹಾಕ್ಲಾ?
I have no.
Yes, Arvind.
Age is
ಅದೇ ವೆಂಕಟರಾಮ್ ಸರ್ಗೆ ಯಾವಾಗ ಫ್ರೀ ಇದ್ದಾರೆ? 28. ಪರ್ಫೆಕ್ಟ್. 28 at 2:30 PM. 28 2:30 ಯಾವ್ದೋ ಕೊಟ್ಟಿದೀವಲ್ಲ ಮೇಡಮ್? 27th ಅದು 2:30. 28 2:30.
Great.
Yes.
Great.
ಟ್ವೆಂಟಿ ಸೆವೆಂತ್ ಆಗ್ಬೋದಾ?
28 ಇಲ್ಲಾಂದ್ರೆ 31.
31. ಎಸ್, 31 at 2:30. ಶಿವದಾಸ್ ಸರ್ 31. 31st at 2:30.
Interim orders will have to be extended.
Where are interim model extends?
ಬೇರೆ matters because of that.
ಬೇರೆ?
Income tax matters. AG sir Venkatraman is going all over India in all.
No problem. No worries at all. Yes.
Past or matters 54.
Reserved matter.
ಏನು?
Appearing
for respondent, my lord.
ಕೋರಂಟೋ?
Please.
ಕೊಡಿ.
Lords, other compilation, Lords, Kalyani Mathivanan compilation is already in.
ಅದು ಆಲ್ರೆಡಿ ಇದೆ ಗೊತ್ತು.
What are remaining judgment?
ಅಲ್ಲ, ನಿನ್ನೆ ಏನೇನ್ ರಿಲೈ ಆಗಿದ್ದೀರಾ ಅದೆಲ್ಲ ಕೊಡ್ಬೇಕು.
Please.
ಎಲ್ಲ ಪ್ಯಾರಾಗ್ರಾಫ್ಸ್ ಎಲ್ಲ ಇದೆಯಾ?
I have marked it, my lords.
ಸರಿ ಕೊಡಿ. ಆಪೋಸಿಟ್ ಸೈಡ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
Yes, my lords. I have served through WhatsApp.
Yes.
The university, my lords, which they have relayed also, my lords, I have put it. So they don't have any additional.
ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್.
Another one compilation is already there, my lords. Kalyani Mathivanan, which has to be referred.
ಅವರು ಏನೋ ಕೊಟ್ಟಂಗಿದೆ, ಕೊಟ್ರ ಏನಾರು ಇಲ್ಲಲ್ಲ?
They did not serve me anything, my lords. But
ನಾರಾಯಣ್ ಭಟ್ ಏನೋ ಕೊಟ್ಟಿಲ್ಲ. ಕೊಟ್ಟಿದಾರ? ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
That's fine. Good day. And also the relevant documents also, my lords, which we are relied upon, I have given a compilation.
ಇನ್ನೇನಿದೆ ಮೇಡಮ್?
Serial number 54, my lords.
54.
Serial number 54.
Already this honorable court has
For respondent.
settlement ಆಗಿದೆ ಈ ಕೇಸಲ್ಲಿ already. So ಈಗ ಅದು ಒಂದು
We have no objection to allow this petition, my lord.
ಅಲ್ಲಿ withdraw ಆಗಿರ್ಲಿಲ್ಲ. So last time stay ಮಾಡಿದ್ರಿ.
ಓ, ಅಲ್ಲಿ ವಿಡ್ರಾ ಆಗಿರ್ಲಿಲ್ಲ. ಈಗ ಏನಾಗ್ಬೇಕು ಇದ್ರಲ್ಲಿ?
ಅಲೋ ಮಾಡ್ಬೇಕಪ್ಪ.
Petition allow. We have no.
ಅಲ್ಲಪ್ಪ, ಎಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿದೆ?
ಇಲ್ಲೇ ಸೆಟ್ಲ್ ಆಗಿದೆ. ಇದೆ ಕನೆಕ್ಷನ್ ಸಿ ನಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ my lords.
The parties to the list would submit that the issue in the list is terminated by way of, is settled between the parties, annexure C quote ಮಾಡಿ. What remained was quashment of the proceedings. In the light of the absence of the counsel for the respondent, the matter was adjourned. The parties to the list would reiterate the factum of settlement. Therefore, the proceedings stand quashed.
Grateful.
Your Lordship, one submission, Your Lordship. Serial number 88 to be tagged along with these two petitions.
ಕೊಡಿ. Yes.
My lords, wait, wanted to mention a matter.
Yes, my lord.
Settlement ಆ?
Yes, my lord.
ಏನದು?
Parties present ಇದ್ದಾರೆ 498A, my lord.
ಕೊಡಿ.
Order sheet.
Serial number?
Serial number 89, my lord.
ಆಯ್ತಾಯ್ತು.
89.
R2 is present, my lords. Advocate has filed for call.
ತಗೊಂಡ್ರ? Yes.
Both parties are.
Order sheet.
Great.
My lords, wanted to mention a matter, my lords. 5600 houses, the access road is blocked, my lords. We're not able to.
ಬೆಳಿಗ್ಗೆ
move it.
ಮೆನ್ಷನ್ ಮಾಡಿದ್ರಲ್ಲ ಮೇಡಮ್.
My lords, there's urgency in the matter, my lords.
ಈಗ
Monday, if
9
it can-
o'clock ತಗೊಳ್ಳ?
Monday, my lords, please, my lords.